Ready? Okay, good morning, everyone. We're going to go ahead and get started this morning. I am Vice Chair Howerton. The chair will be here shortly. Just wanted to welcome everyone to the Joint Committee on Child Welfare System Oversight, June 2nd. It's our second meeting of the year. I'm going to recognize some written-only testimony from individuals. That's Eric Vaughn, Executive Director from Douglas County CASA, Dina Gage, State Director, Kansas CASA Association, Peter and Kimberly Berzak, private citizens, Sarah Goebel, private citizen. I'm going to try my best on this one. Chana Sakasukwak. Sorry, that was really bad. Private citizen, Christy Sloan, private citizen, and Kathy Winters, private citizen. Those are written-only testimonies that you'll find on the drive online on the committee testimony part. If you would be sure to read those, we thank them for the written testimony. The chair wanted me to let you know that we are going to devote a whole morning to testimony at the next meeting, so we'll have more time. We have a very busy agenda today. We didn't want to cut people short, so that's what we're going to do this morning. So today we're going to be focusing on the front door, kind of as we called it, to the child welfare system. And do we have Christopher Church online? Okay, perfect. We're going to open with him. He's going to be online for us. He is the Senior Director of Strategic Consulting with Casey Family Programs. He's going to kind of give us a national view of the front door and whatever else he has chosen to share with us this morning. So welcome, Christopher, to committee.
Thank you, Vice Chair Howerton. Can you hear me okay?
Yes, we can. Maybe
Great.
Turn them up a little bit in the room. Thank you.
Thank you. And can you see my slides okay? It's a little,
Yes, we can.
Okay. Perfect, thank you. Good morning, everyone. My name is Christopher Church. As you heard, I'm a Senior Director at Casey Family Programs. So I am really sorry that I'm having to do this by web this morning. I have my 3 nephews in town to go to summer camp here for a week. I'm joining you from my hometown of Columbia, South Carolina. So I just couldn't quite sneak away with them here. So I appreciate the flexibility and the opportunity to share some information with you remotely. Just by way of a little bit of an overview, today I'm really going to focus on, well, I think I'm going to focus on my, there we go, it's my slides advance. Focus on a couple of aspects of the front end of the system, or the front door of the system. I'm going to start by sort of framing up the regulatory and legal framework, but also focus on the impact that the decisions we make in the early phases of these cases have on children and their parents and their families. And that really covers all the decisions that are happening from the moment the agency may learn of a report, receive a report of suspected maltreatment, all the way through the decision where some state actor is determining whether they should remove and legally and physically separate the child from their parent. I know you've heard from many of my colleagues at Casey Family Programs previously, and what I really hope to do today is to supplement some of that information that they have already shared. And the substantive content that I really want to focus on is generally some features of our current system, and I'll explain why those features matter and how I believe this committee can make some changes to improve that system. But what I want to start with is just generally, what is an effective child protection system? And I'm going to share a couple of things that I think are rather important to start this. But what I will say generally is that I believe an effective child protection system is one that is sort of immune to the pendulum swing. And so just add a little context to what I mean by that. Anybody that's worked in child protection, worked in child welfare, is probably familiar with this idea of the pendulum swing, and that our system is often being overcast by these competing priorities of child safety and family preservation. And you will hear our system focusing in often on one of these priorities to the exclusion of the other. And one of the things that I think is really important for a child protection system to do is to be immune from that pendulum swing. This system is not about child safety to the exclusion of family preservation, and this system is not about family preservation to the exclusion of child safety. So we really have to embrace the complexity of those seemingly competing priorities and embrace some both and thinking, that both of these things can be true, and we have to focus on both of them in order to make improvements in the system. And if someone tells you that you got to focus on one at the exclusion of others, I would be highly skeptical of what they are telling you. The second thing that I would say about an effective system is that it protects children it knows about from imminent risk of harm through interventions that are tailored to the risk. So the first part of that sentence is that I'm focusing on the children that the system knows about. So by its design, CPS is a reactionary system. We don't have case managers going out into the community, knocking on random doors, inquiring how children are doing. Rather, we wait to receive reports of suspected maltreatment, and then we determine our response as a system and go out. And typically, that starts with an investigation. And so we have I would argue that the system has a responsibility to protect those children that it knows about from ongoing harm. That is our core function. If somebody lets us know that a children is at risk of maltreatment, our interventions should really protect that child from ongoing harm or from future harm. And those interventions really need to be tailored to the risk. And so all I mean by that second part of the sentence is that the things that we're going to require or offer to families should really address the underlying needs that brought this family to the attention of the system in the first place. That may sound really obvious and really straightforward, but I think after my 15 years of practice and many of my colleagues that I speak to, we know that oftentimes our interventions are not tailored to the risk. And so we are working with an imperfect set of tools to respond to often chronic and long-term family adversity, and we need to have more flexibility to really, and more tools in our tool belt to address the underlying conditions that are bringing families before our system. And then finally, the system should minimize time children are separated from their families. There's a lot of good reasons to do this. One is the law. We are required to minimize our intrusion into families. However, there are also good reasons that we know children do best when they are with their families. And so if at all possible, we want to keep children with their families, but also if we do need to separate children for their protection from their families, we need to minimize the time that we do that. And there's something else that I think is representative of an effective child protection system that I want to share, but I need a little bit of a setup to share this. So before we get too far, I want to focus on these sort of two features that I really define some long-standing problems with our child protection system, and problems that I hope that would concern all of us in this room. And so the first thing I want to share is represented by this graphic, which comes from the National Incidence Study. So we have, our United States Congress has invested a significant amount of funds into providing child protection services across the nation. So child welfare systems are a cost-sharing arrangement between local governments and the federal government. The federal government reimburses a significant amount of funding that states expend on these services. And so, of course, Congress is going to want to know whether their investments are working. Are they reducing the overall amount of maltreatment in the system? And so they have long required what we call a national incidence study. And the goal of that national incidence study is really to go out in the community and see how much child maltreatment exists in our nation. Now, that is a very different question from how many families, how many children are being investigated by our CPS system. Because again, we're not out there in the community trying to identify maltreatment as a system. We are reacting to information and calls and reports that we receive from members of the community. So this is a much more proactive assessment of the overall rate of maltreatment in our nation. And this study has been congressionally required. It's about every decade or so since, I believe, the 1980s. And a consistent finding across all of the studies that have been released from NIS 1 through NIS 4, which is the study I'm going to quote for you today, is that although CPS investigates a substantial number of maltreated children in the nation, these children represent the tip of the iceberg. So what we know is that CPS works with a lot of children and families, and a lot of children and families that are likely in need of the intervention that CPS provides. But what we also know is there is a lot of maltreatment out there in our community that goes undetected. And so that is the first piece. The second piece is that a lot of the responses and reports that we receive from the public concerning children that may be at risk of maltreatment ultimately go unsubstantiated or ultimately are unable to be determined. So a different way to say that is, out of the nearly 3.1 children who received a response nationally as a result of a CPS report, only 500,000 were confirmed as victims. Our system in every state spends far more time investigating non-victims than it does victims. And so this creates a sort of, again, a duality, a sort of tension about two really important features of our system. One is that we miss a lot of the maltreatment that we would hope to detect with our system's response. And the second is that we bring in a lot more families than necessary. And so from a sort of statistical standpoint, we would describe this as both an overfit and an underfit problem. And getting this balance right, where we're only intervening in the children and families that require that level of intervention, is a really hard problem to solve. And we're probably never going to, in fact, we're never going to get it just perfect, where we're only doing it when necessary and we're capturing all children that need it. But nonetheless, these data show a particularly large imbalance. And so while we're never going to achieve perfection, we always want to be striving for improvement and trying to carefully calibrate the front end of our system to make sure we're minimizing those errors. And yet the data have reflected for decades upon decades that we're just not getting that right. So what is the big picture takeaway here? Again, CPS agencies are overwhelmed by reports that lead to unnecessary investigations, which most often result in no protective or supportive services. If we unsubstantiate or unfound, or whatever the sort of local parlance is in Kansas, an investigation against a parent, it's very unlikely that they're going to be willing to voluntarily engage in services and receive services. But at the same time, we know from our NIS studies and other research and data that many children are not receiving the protection from maltreatment that they require. So again, in the realm of sort of embracing these both-and thinking, these competing tensions, we really need to be responsive to both of these issues. They can really paralyze the system when we miss cases we're supposed to identify, or when we're overwhelmed with cases that we have really no business responding to. It can really paralyze the system from doing its core function of keeping children safe and keeping families together. And so a lot of my comments today will be sort of couched in these sort of understandings or sort of features of the system. So how do we get from a report to a removal? I've heard this said before. If you've seen one CPS system, you've seen one CPS system, and I certainly agree with that. But this is my intent to sort of flip the script on that position, which is to say, this slide is really about if you've seen one system, you've seen them all. And so I'm trying to really generalize the features of the system here. And so how do we get from report to removal? Well, someone is first going to have a belief that a child is at imminent risk of harm. And I want to say this, again, I'm trying to generalize at the federal level here, or at the sort of national level here, and that all of these systems sort of have this general framework. And of course, we all have our specialized in our local language. But again, this is the sort of general framework that we're working in. Someone will believe a child is at imminent risk of harm. Now, as that person believes it's necessary to intervene, they have a couple of options. Sometimes they may have statutory authority to remove the child, and they may remove the child. And so that requires no other determination than their own that this child is at imminent risk of harm from a statutory standpoint. So in many states, law enforcement will fall into this category. In some states, the child protection staff themselves may follow into this category, although that's a sort of group that is sort of split across the nation. There are many states that, like Kansas, that do not require or do not allow the state staff from the Child Protection Agency to remove the child. And so if you don't have statutory authority, but you believe the child needs to be removed, then those actors can often go to the court, and it's usually ex parte. So I just mean that the person who believes it is going in and sharing their version of the facts with the judge, and there's nobody else in the room. And so they ask the court, typically ex parte, for authority to remove the child. And so that court is going to have one of two options. They will review the request, they will appoint counsel, they will set the case for a hearing, and they'll provide notice to everyone. And in a couple of days, typically, everybody will come to court, and the judge will hear the case and make a determination of whether the child needs to be removed and placed in foster care. Or the court will just grant the person's request who came to them ex parte and remove the child, give the authority for that person to remove the child, and then they'll appoint counsel, set a hearing to review the removal, provide notice, and do all of the things. And again, that post-deprivation hearing is usually happening in the context of, within a couple of days of the actual removal. And all that's going to be driven by state law. But this is really our framework for how we get from report to removal at the broadest sense. And so you either have statutory authority to remove a child, or you must get a court order. And then that court order can either be ex parte, which would typically be effectuated under some, offer that this is an emergency situation, or they will set a full adversarial hearing. And so my position that every system, although unique, although, with different language, different timelines, different pathways, different statutory actors, are a little different, you can really broaden it to this sort of framework. And the reason I think you can broaden this to this framework across all the various jurisdictions is because it's what the federal United States Constitution requires. So just over 50 years ago in Stanleyville versus Illinois, the United States Supreme Court held that as a matter of due process of law, parents are entitled to a hearing on their fitness before their children are taken from them. I think the key word that I would highlight here is before. And so our system and our regulatory framework really contemplates one that affords a parent pre-deprivation due process prior to any legal removal of their children. Now, the Supreme Court has never really followed up and provided much clarity or context on these cases. But our federal circuit courts have all addressed the issue of what I would sort of argue is the well-established exception to Stanley's holding. And that is that, of course, when there's emergency circumstances that place the child at, an immediate threat of harm or safety, well, then, of course, we can temporarily deprive a parent of custody without consent or a court order and, go that ex parte path to removal. And so this is really grounded in the understanding that if the time it takes for state actors to do what the Constitution requires, which is afford a parent pre-deprivation notice and an opportunity to be heard, if that's going to place a child at risk of harm, well, then of course we wouldn't require the state to do that. We will allow them to temporarily and remove them under these emergency circumstances and then provide post-deprivation. But I do want to be really clear that, this bottom left-hand corner down here, where the court reviews the request, appoints counsel, sets the case for a hearing, and provides notice to everyone, that's our default. And these other ones where we either statutorily remove a child or remove them pursuant to an ex parte order is really the exception to the norm or the exception to the rule. And so the legal and regulatory framework sets up, pre-deprivation due process for parents. But of course, that exception allows us, when a child safety requires it, to go another route. And every circuit court in the United States, all 11 circuits, the DC circuit, have all held this in a similar way, in similar language. I put Hollingsworth v. Hill up here because that's a case that comes out of the circuit for which Kansas sits. So I figured I'd include the relevant one. But again, while there's some differences in how the federal circuit courts have held this, and particularly in the language they've used, it all comes down to this idea that if there's an immediate threat of harm to the child, of course we can do a removal without pre-deprivation due process. But absent those circumstances, we're going to require due process of law before we take a child from their children, which is consistent with the full body of jurisprudence the court has found in child welfare and Fourth Amendment and criminal and all sorts of contexts. We favor pre-deprivation due process, but in an emergency, we allow some flexibility there, especially when it's necessary to protect a child. So we have a fairly regulated process for getting from report to removal. But one thing that really always surprised me is how much variance we have in the rate at which we remove children operating within this sort of single framework. So what I've got up here is the most recent federal data that the federal government makes available for all states, showing how often per average on month they remove children from their parents' custody. And what I've done is right across the middle here, if you follow this all the way across, right across from 100%, I'm moving my mouse on my screen. I'm guessing you probably can't see that, so I don't know if that's very helpful. But this sort of middle line here represents the national rate. And I'm expressing the state rates relative to the national rate. Now, I'm not here to suggest that the national rate is the gold standard or the benchmark for removals, far from it. However, it's as good a baseline as any to sort of compare all of these state practices. And so what we see is states like West Virginia, Alaska, Montana, Vermont, removing on average per capita far more children than we see both at the national rate and in states like Virginia, Maryland, New Jersey, that remove far fewer children on average per month. And so in such a heavy regulated field, it always surprises me to see that a state like West Virginia and a child living in that state is 17 times as likely to be removed and placed in foster care as a child living in New Jersey. And it's not that I think every state should have the same removal rate, but in such a regulated system where we have really clear sort of guidance around the front end of the system, I think we'd expect far less variance. Most relevant to, I'm sure, the folks in the room today, Kansas is on the higher end here. So you can see removing, I think the removal rate's about double the national rate in Kansas based on the most recent data I've seen. And I will say this, that nobody can tell you really the right number of children to be in care at any particular time. And I'm certainly not here to tell you that. But when we see a system with such variance and such differences, it's worth sort of interrogating why that may be. And we could spend the rest of our time today doing that, and it would probably be a fruitful exercise, but I'm not going to do that today. But I do think it's worth looking at these data and thinking, why might this framework be happening the way it does? The other thing I will say is that I've done this in almost all the states that I've practiced in, which is pretty close to all the various jurisdictions that operate a child welfare system. And I could run this same chart and use counties in Kansas instead of states at the national level, and we would see that same level of variance. And that should really be even more concerning. So in Kansas, these, all the counties are operating under the same statutory scheme, the same sort of federal regulatory framework, and yet still, even within the same jurisdiction, we see so much variance across geographies and over time. So this one represents the geographies, but we would see the same level of variance if we looked at these metrics over time, which really goes back to that idea of the pendulum swing, where we're seeing different priorities really drive the front end of the system. So the other piece that I wanted to highlight is why this is such an important matter. So why am I so interested in removal and the variance and all of these different features of the system? Well, the first is because the law tells us that we should be paying very close attention. So the federal, particularly congressional language, talks about removal and the front end of the system being among the more important aspects and decision points in the system. We also have a very high bar for removal. So the federal regulatory framework, which every state has sort of opted into, tells us that we can only remove a child when a court finds that it is contrary to the welfare of the child to remain in the home. And that's not even enough. So it's not that it would be better to remove them or that we think it's best to remove them. It's that it would be unsafe not to remove them. So that's the standard that we're working with. But even then, we also require the state to tell us within reason what they did to try to prevent the removal. So we have to have reasonable efforts to prevent the removal before we legally and physically separate a child from their parent. Absent some exceptions, like every good law, we got a handful of exceptions that would excuse the agency from doing that. But that's the federal regulatory framework. And so the law tells us that we should care about this decision. The other reason that we really care about this decision, and I would say that the courts are sort of starting to latch on to this and see this, is because we have a pretty expansive body of research telling us that this is a very critical decision for children and families, and that no matter what decision we make, our intervention can lead to further traumatizing them throughout this process. So one of my favorite researchers on this topic is Dr. Monique Mitchell. She's done a lot of research about the trauma that children and parents can suffer when our interventions happen. It's not to say that those interventions aren't necessary, but it should caution us to really want to get those decisions right. Because if we're removing or intervening in children and families that don't need it, then we are unnecessarily traumatizing them. But in terms of the children that are involved in this process, they experience many things when the agency intervenes or any of the agency actors intervenes into their lives. So they often experience structural ambiguity. That's where we're all, wondering, like, what is this system? What is happening? Where am I going? They experience placement reason and placement context ambiguities. So they don't know why they're being separated from their children, from their parents in these moments. They don't understand where they are going, how long it will last. And there are all sorts of ambiguities that really can threaten child well-being. The other important aspect of the literature on this is that Dr. Monique Mitchell talks about is this idea of ambiguous loss. And I want to talk about this a little bit. This is a concept that Dr. Bruce Perry has talked about and studied pretty extensively. And the reason it's so important in this context is because ambiguous loss sounds a little confusing, but it's a pretty straightforward concept to understand. So, if, like I said, my nephews are here this week, so these are my sister's children. If my sister's children, or if my sister was, for some reason, arrested and placed in jail, and her kids could no longer see them, they have a really hard time understanding that loss. And that's what's called an ambiguous loss. They know that their parent is out there in the world, and yet they cannot see them. For adults, it's not fun. I would love to see my sister, but I can at least understand it. But Dr. Bruce Perry describes ambiguous loss when children are aware that their parents are out there in the world, but for whatever reason are prevented from seeing them or interacting with them, as one of the most complex traumas that children can suffer. So all of these sort of ambiguities and losses will threaten their well-being long-term from the moment that we start interacting. But ambiguous loss in particular is quite traumatizing to children. Their brain has not developed in a way where they can really appreciate and understand this. So on the other side, parents, we also know, suffer tremendously when we intervene in their lives. Some of the most prominent research really comes from this idea of disenfranchised grief, where they are experiencing a tremendous grief, but one that society may not validate or understand. And so they are unable to sort of process that in a way that is healthy or trauma informed because society may not be very sympathetic to those parents. And that can really traumatize them and send them into behaviors and activities that are only making matters worse. So again, all of this sort of cautions, I think, decision makers, state actors that work in this system, policymakers, to really be thoughtful about designing a system that's really carefully calibrated to prevent unnecessary involvement, but also to identify the children and families that need these interventions. So how might we do that? Well, there's a couple of topics that I just want to, this is a running list, and I just want to share a couple of these things that I think can really help the system be more fine-tuned at the front end of the process. The first one I think you've heard about a little bit before from one of my colleagues, but I'll frame it as preventative legal advocacy. What we've seen in the data is that a lot of families come to our attention for a number of issues that the CPS system may not be best suited to resolve. And so by having more tools in the tool belt at the front end, to where either CPS or the folks involved interacting with these families themselves can help the family get services that will actually address those needs, is critical. So, the best examples of preventative legal advocacy, I would say, are your sort of bread and butter poverty law legal services. We've seen these in the child welfare context be really effective in the context of medical legal partnerships. So medical legal partnerships are a little bit of a novel legal services provider that really embeds themselves in the healthcare setting to address the social determinants of health. And so the classic sort of MLP case that you can think of is, if a child has chronic asthma problems and, goes in to see a doctor, their pediatrician may refer them to a subspecialist in pulmonology. That pulmonologist may give them some, albuterol or some other treatments, send them home. But if that kid's going home to a moldy apartment, that albuterol is not going to be effective. And so we know that a lot of children's health is impacted by things that happen, of course, outside healthcare settings. And we have to be flexible enough to address those underlying needs, because the albuterol itself is not going to help get rid of that, get the landlord to fix that or remediate the mold problem in the home. We also see school-based legal partnerships where attorneys are embedded in the school. And as two of our biggest mandatory reporters, these are really promising models for identifying the children that need that protective intervention of CPS, or identifying those families that may just need addressing some of these environmental conditions that absolutely are placing children at risk, but that the CPS system may not be designed to effectively respond to. And so we see a lot of these in the context of like housing issues, domestic violence, income insecurity, food insecurity. And it's a way to get upstream and to get in front of some of these issues that may tumble into a bigger problem that pulls the children and families deeper into the system. High quality legal representation is also critical, and the research suggests this can be an effective way to really get the front end of the system carefully calibrated. What I would say is that the components of high quality legal representation that are most effective in this context are early appointment. Some of the research that we've seen shows that high quality legal representation can absolutely move children to permanency more quickly and minimize the time that they are separated from their families. But if they're not appointed early enough in the process, they're not going to be able to impact decisions that happen early in the process. So the states where we see this most effective is when attorneys are there right from the outset, prepared to really be a part of the system that makes sure these allegations are tested through our adversarial system. The other thing that we see a lot of, I'm actually doing some research on this right now, and all of my suspicions are being confirmed, is that we don't have a lot of adversarial testing on the front end of the system. And what we know is that our legal system is designed on adversarial testing to get to the truth. That is the sort of bedrock of our system. But we are not seeing a lot of adversarial testing. So we're not seeing contested removal petitions. Oftentimes, we're seeing a lot of momentum carry those children and families forward through, maybe even up to the adjudication phase. And that's really where the first time we see adversarial testing. But in many states, that can be weeks, months after the child has been removed. And if we really want to, help kids and families and minimize the trauma that we may inflict on them, we want to move that adversarial testing much further up. And in the jurisdictions, there are very few of them where we see that level of adversarial testing. It really makes a tremendous difference. And then the other piece is, I sort of frame this as specialized training. We really need to make sure that our attorneys are trained and skilled in the areas of dependency law, which I would argue is a very complex field and not one to dabble in if you really want to make an impact on children and families. It's also important to clarify the regulatory framework. I think this can be done through statutory definitions. I know you've heard a lot about, redefining what neglect means. I've worked with a couple of states that have worked on this, and I think one of the more promising features is to untangle intentional versus unintentional harm. I've seen states that have focused in on, children that intentionally or willfully withhold information that will help their, that will keep their children safe. And that seems like a much more promising intervention for those children and families. Whereas if we just have a family that, through no choice of their own necessarily, is just really in an environmentally risky situation, our interventions need to be tailored to help that family in the context of where they're living, not treat them as if they have somehow intentionally or willfully harmed their child. We've also seen a clarifying what is an emergency and justifies this sort of ex parte or statutory removal without due process of law. I think you heard from one of my colleagues who talked a lot about Texas. They did both of these things, and we saw a tremendous reduction in the use of emergency removals in that state, which had a number of downstream effects that I would argue are all positive. The next thing that I would say is, again, in this idea of embracing the complexity of these competing risks, we need to have effective responses to assess and address safety when CPS responds to reports. Many states have but one choice there, maybe two. They can either refer to a community partner or to another division to provide, maybe some benefits or some other information. But largely, when an intake meets criteria, we investigate it. And we've seen a lot of states experiment with what we would call alternative or differential response, where certain cases may be better for an assessment, where we have a much better chance of engaging the family in a positive way and getting them to buy into services, particularly voluntary services. And then we have the investigative response, where we really need that substantiated allegation of maltreatment, perhaps to coerce families or to ensure that we have, the power of the state and their parents' patria authority to really protect children. But only having, one of those is probably not enough of sort of flexibility for the state actors to really respond to child maltreatment allegations. So having more flexibility on the front end. And finally, I've talked about this a lot, services tailored to the risk. I often think about this in the context of healthcare. If everybody in the emergency room just got prescribed penicillin, after some triage dose and response, we would not have a very effective healthcare system. What we need to see is meaningful services available and offered to families that are tailored to the underlying conditions. So just like in a hospital, we need to triage and understand what we're working with before we come up with an intervention. And what we often see in the CPS system is a little bit less nuance than that. And so oftentimes we see that there will be a handful of services or responses that are sort of put into place in various cases that have certain characteristics. And we see a lot of that repeated over time. And so making sure that we're offering services that are going to address the underlying condition is the only way to hope that the underlying condition absolutely improves in the long term. So let me stop there. I tried to, I think I did pretty close to time, but I'm happy to answer any questions, or if I am out of time, I know I'm getting pretty close, then I'm happy to, share any other information that can be helpful, via email or via follow-up. But I will stop for now, and I want to thank you for the opportunity to come and share some information with you. I hope it was helpful, and if there is time, I'm happy to answer any questions.
Mr. Church, I just arrived. I'm the chair, Beverly Gossage. Thank you so much for your testimony. And committee, do we have any questions? Yes, Senator Faustido.
Thank you, Madam Chair. Wonderful presentation. Thank you. So, regarding the malnutrition piece, so part of your study, did it consist of like sometimes states, legislatures will amend or cut food SNAP benefits? Did you include that in your study of how that affects that piece? Thank you, Madam.
Of course, yes, thank you. So what we've seen in the research is that those sort of tangible benefits, in whatever form they come, are critically important to reducing reliance on the CPS system to respond to problems like that. So I would put, something like food insecurity in the bucket of sort of unintentional neglect, right? Now, if a parent is willfully withholding food from their child, totally different situation. If they are so impoverished and so stressed that they're not able to provide, appropriate healthy food to their child, that's a different situation. And we have benefits that can address that. And when we have those benefits readily available and provide them to children and families that need them, we do see reliance on the CPS system to respond to those events go down, which I would argue is a good thing. And there is a fair amount of research that talks about not just the sort of food insecurity, but all of the sort of benefits that would promote a child's health in that category of it reduces reliance on the CPS system and allows the system to focus on the children and families that need its protection more or at all. I hope that answered your question.
Representative Ruiz.
Thank you, Madam Chair. Christopher, thank you so much for your presentation. As always, KC Family Programs comes across with really good ideas. Looking at the slide that shows the numbers of removals, and it shows New Jersey being way down there as far as the removals. Did you do a comparison, let's say between Kansas and New Jersey? What is it that New Jersey is doing that maybe Kansas isn't doing? And is that what informed your slide on, let me look at it, find it here, on the preventing unnecessary removal and out-of-home placement?
Yes, so we've done a lot of state comparisons, but we haven't got, one of the most fascinating questions I think you can ask on that removal data is what's driving these differences, and which is sort of what you're getting at. And what I would argue is that it's a really complex question to explore, and we probably can't ever sufficiently answer that. But I don't think that takes away from the value of thinking through what might be causing those differences. So what I will say about New Jersey is they have invested significantly in a comprehensive system of care for children and families, and particularly one upstream. So New Jersey has not always been at the lowest. Virginia used to have the lowest rate of removal. New Jersey's eclipsed them recently. Maryland's usually down there. But they have not always been down there. They used to have far more kids in care. And that's sort of that pendulum swing, right? So, what we've seen is that their system reflects the priorities and investments that they have made, which is, again, a significant investment, probably one of the biggest that we've seen nationally in the sort of upfront creating a system of care across multiple agencies. So it's lots of coordination and lots of intentionality around the front end of the system. Now, is that the only thing that contributed to that? Absolutely not. There's probably so many factors that we could talk about and identify, but we've long believed that that is one important piece of it. What I will say about New Jersey is they were one of the earliest states to really invest in preventative legal advocacy. So New Jersey's legal services has long had what they call a family reunification project, whose goal really is to support families during the investigative process to really try to address the issues that are raising all of these concerns. So they help families, improve conditions in the home by advocating with the landlord. They prevent evictions through representing families like in a magistrate proceeding. They get orders of protection for families and help connect them to resources when domestic violence is an issue. So there's all of these, aspects that they do that are a part of their system. But that's not entirely what informed that list. So the preventing unnecessary removals and out-of-home placement, that list really comes from just a summary of the research of what we know can really be effective in narrowing the front door and addressing issues before they sort of spiral into a CPS report. But yes, the differences in states is really quite stark. What I would say is that usually when we interrogate, the causes of why one state might be lower or one state might be higher, it very rarely has anything to do with the needs of children and families. It's usually driven by something else, like high-profile cases. Oftentimes, we see a big swing in the system after a high-profile, tragedy happens. Changes in administration. When we have a turnover and new leadership comes in, we'll often see a little bit of a what I referred to earlier as the pendulum swing. And so, that on its face should also be somewhat concerning that we have big rates of change in the way that our system interacts with families and involves with families, and that seemingly has not a whole lot to do with what's actually happening in the underlying community. There's lots of examples that we could share that sort of highlight that feature, but I'll leave it at that for now. But there is some connection between those two slides, but not necessarily at the level that was contemplated.
Thank you. Thank you, Madam Chair.
Representative Howerton.
Yeah. Thank you, Madam Chair. So this was not a conversation I thought I would be having about police protective custody, but you did bring it up. I thought we were going to get off that topic today. But you mentioned the 2 court cases and talking about immediate threat of safety of a child, in that nationally, or I can't remember exactly what you said. I'd like for you to say that again. Is that normal for police to remove? Or is that, what were you saying with that? If you could.
So in every state, the legislature will usually have said this class of professionals has statutory authority to remove a child when they determine, and then the language differs by state, but essentially when they determine the child's at imminent risk of harm, right? If we don't act now, this child's going to be harmed. And so that's the sort of default. And in most states, law enforcement is included in that group. In some states, doctors are included in that group, right? So a child's in a hospital, the doctor can place, what we typically call like a hold on the child and legally and physically remove them from the custody of their parent, separate them, take away their decision-making control, all of those things. Until a judge can, hold a post-deprivation hearing or, a hearing on that removal. So most states do include, I'm not aware of any states who don't allow law enforcement that authority to say in the moment, yes, we need to remove this child to protect them from, risk of, substantial risk of injury or imminent harm or imminent danger, whatever language we use. And then they would then, typically notify the agency, notify the court, and set it, for a 72-hour hearing or a preliminary protective hearing, whatever it may be. And then there's the other class that don't have that authority, and so they have to go to court and request the judge, they file a complaint, they file a petition. And in many states, that includes the agency staff. And in many states, the agency staff have statutory authority. But in many states, it also includes private citizens. So, in many states, a private citizen can walk in and file a dependency complaint. And, the judge is going to review it and set it for a hearing. So there's these sort of two classes that are treated differently. And law enforcement typically has the authority to remove children under those criteria. And then it's, what we get into in the statutory analysis is that you'll see how they have to coordinate with the department or the juvenile court or family court to then process those cases and give the parents a hearing so that they can hear the allegations against them and have an opportunity to contest them.
Okay, so just to follow up, so according to the circuit court decision, police cannot remove kids without a court order unless it's immediate threat. Is that what that was saying?
Yeah, so every circuit court in the nation has held what you just said, but they all say it a little differently. So I tried to pull a case from the circuit in which Kansas sits, this Hollingsworth versus Hill. And yes, the language they use there is right from that slide. In emergency circumstances which pose an immediate threat to the safety of the child, you can temporarily deprive a parent of custody. So all this comes back to the idea of we don't take things from people, particularly their children, without due process of law. And that cuts across most of our legal landscape, right? We don't enter someone's home unless we've gone and gotten a warrant to do that. But of course, there's always that exception to the general rule, right? So in emergency circumstances, however that's defined, we do allow somebody to take something from someone without due process of law. And in the child welfare context, the child protection context, that would be taking custody of a child before we've had that hearing on their fitness, which, Stanley requires. And then we try to do it really quick afterwards. So yes, that is the language from the circuit court. And again, all of the circuits have held this in some fashion because that's what our constitutional framework requires. But they all use, like in the 11th Circuit, it's like under all relevant circumstances, the child's at imminent risk of harm. And so I think the 10th Circuit, the 8th Circuit is something like if there's time to get a warrant, right? So they're not all going to be the same, but there's some sort of framework around if there's a justification to removing without due process of law, then sure, you can remove without due process of law. But that justification is always going to require some sort of emergency, some sort of imminence, some sort of, immediate threat to the child's safety.
Okay, and if I may, Madam Chair, my last question is about tracking the removals from police and emergency removals. Is there a national standard for that, or when should removals be tracked?
Yeah, that's a good question. This is one of the data elements so we have a lot of really amazing child welfare data from our system because the federal government has sort of legislated and made a very uniform and standardized data set to tell us how many children are interacting and involved in our system and for how long and what happens to them. One of the, so we know with absolute certainty how many children are removed in a given year, in a given month, in a given day. We can look at that granularity of the detail. What we do not know is the pathway in which they came. And so we don't know whether they were removed pursuant to an ex parte order or pursuant to being placed in emergency protective custody or whatever the sort of local language is for those determinations, which is a troubling aspect of our data set, but it requires a sort of state by state and in many states, almost a court by court inquiry to really parse out the details of how children, came into care, whether it was pursuant to an emergency or the sort of standard way or through an ex parte order, whatever it may be. So unfortunately, we don't have good data on that. And the jurisdictions that we've looked at, I think I mentioned we were doing a little bit of a study on this right now. The jurisdictions that we've looked at, most commonly children come in by way of an emergency. Now, whether that's the right way to do it is a whole nother question, right? But typically we're seeing those children come in via one of the emergency pathways where parents are not afforded pre-deprivation due process, but are given a hearing after the fact, typically within a couple of days.
So the emergency is becoming the norm.
Yeah, I mean, yeah, exactly. The exceptions swallow the rule, right? Yeah.
Thank you. Thank you, Madam Chair.
No problem.
Representative Humphreys.
Thank you, Madam Chair. I do have several questions if you need to cut me
Okay.
off. So thank you for your testimony. One word you've been using I find super helpful is the word upstream. You know, I've tried to have a word where I can explain to people kind of what we're trying to do with child welfare, and upstream is a great way to define it. So thank you for that. I do have several questions. So one, and my colleagues have kind of touched on that, but the legal representation that you said needs to be high quality and early, does that include representation for the children, like a guardian ad litem or a children's attorney, or are you only talking about a parent attorney?
All parties, yes. So children should be represented early, have an advocate early, parents should have an advocate early. What I will say is nationally, our system's a little better at getting children an advocate early, but still not enough to impact the removal decision.
And so, you know, I mean, in Kansas, and I assume in other states, we have a bit of a gap of number of attorneys, especially in rural areas. So what states are doing that right as far as having enough attorneys? I mean, it's a little bit of a different question, but I'm just curious if you could point us to what states are doing that correctly, in your opinion.
So I think a lot of states, thankfully, are really focused on this issue right now. Some of the research I described is a little more recent. So there's also been some changes at the federal level that I know that this committee's heard about that provides some reimbursement for funding those attorneys. Mm-hmm. That's given states a little bit of a financial cushion to mm-hmm. Try to build out this practice. But you know, I think one of the ways that states have addressed the problem that you're describing, and we just saw this in Delaware, we worked with the family court there to support this, is they made the investment and moved to what we would call an institutional provider of representation. Yeah. And so there is a single statewide entity that is representing children. Mm-hmm. And those are, you know, they're staffed. They have a budget. It's not an hourly, you know, rate. They have an appropriation that they receive every year to provide this representation. They've moved to 2 offices to provide representation for parents. So they have their primary and then their conflict office. And, you know, these are not all government agencies. One of them's a legal services provider. One of them's an Indigent Defense Commission. And that has been a really effective way to make sure that parents and children receive high quality legal representation early mm-hmm. in the process, because typically what we see is we're fighting a little bit of the coordination. How do we get attorneys there early, especially if we're working off like a contract list where we don't know which attorney in the community is going to appoint them until we actually get to court and the court makes the appointment. So that's been yes, please.
Yeah, no, that's super helpful. I'm kind of filing that away for another committee that I'm on.
Okay.
But, you know, I find it kind of interesting that legal framework where you have the 2 cases, the U.S. case and the 10th Circuit, and you said, you know, most of the cases are this emergency. There's no doubt that the default should be, you know, a hearing ahead of time. But if we're not removing children as readily, if we are trying to work upstream and we're trying to take care of family issues or whatever it might be ahead of time, then it completely makes sense that most of the removals would be an emergency, because otherwise we're not, you know, I'm trying to think of a situation where we could say to a parent, we think the child's not really in imminent threat of safety, but we're going to remove your child, so we're going to have a hearing. You know, that doesn't, you know, in that case, we don't do that. We are trying to give them services upstream. So I think it only makes sense that the vast majority of removals would be an emergency, because otherwise we're trying to help the family. Does that make sense to you?
Makes 100% sense. And I think this is one of the, you know, to me, this is one of those places where the bullfan thinking really becomes important, because 100% in a system that is functioning well, it should only be intervening in the cases that are, you know, represent the most serious sort of circumstances, where other efforts have not been successful, and where we are finding ourselves in that moment where we've got to act now. And so I completely agree with you. I think the challenge is in the jurisdictions and in my own practice and in, what we hear from the field is that our system currently isn't operating at that level. And it's pretty clear that, again, those sort of two initial slides about the NIS study and the federal government child maltreatment reports, it's hard to imagine that any state has sort of cracked the nut of making sure that no children unnecessarily passes through the system, and that no child and that all children make their way to the system. And so what we see is that when we actually go in and review those cases, there isn't necessarily adversarial testing of the removal request. And that may be because it never went to court, because somebody's just exercising their statutory authority. It may be because the court just sort of approved the agency's request without really digging in deeper. And what we see is that there are no shortage of examples where when we review the files and start to examine what's happening, that cases are slipping through the cracks. So yes, go ahead.
Well, I was just going to say thank you for that, but because I'm conscious of, I have a couple more questions, and I'm hoping the chair will allow me. But so you had mentioned you don't really have good data at this point about, to the day how many children are removed, but could you do a study on, like, for instance, just one county in Kansas of what, the circumstance of the removal, if it was police protective custody or if it was, otherwise. So if so, I'm just asking, maybe you could do that. You don't have to answer right now, but if you could think about that and possibly provide that, that would be helpful to the committee, especially I'm from Sedgwick County, as several of the other members are, and that's probably the county, what is the county where we have the most removals. So that would be great. Okay. I do just want to mention at the beginning of your testimony, you talked about how many reports there are and how many investigations. And I kind of have a bit of you said, only, it comes out to 18% of the investigations turn out to be victims. And I find 18% to be, if you were going to walk across a bridge and 18% of the time the bridge is going to fail, we're not walking across that bridge. I mean, we're investigating every board or rope or whatever on that bridge. So I kind of have trouble with your word only 18%. So I think 18 is pretty high.
Oh, it's probably it's I would guess that more cases are unsubstantiated in Kansas than the national rate. So it's actually, locally it's probably even a little more stark. But you're 100% right. I mean, that 18% means that 82% of children, received an investigation and were subject to that sort of, where the people are contacting collaterals, they're, investigating whether maltreatment existed, getting sensitive records, only to find that they can't substantiate the claim. So it's a really ineffective way to detect maltreatment.
Yeah, but it has to be done because 18% are found to be victims. I mean, at this point, maybe till we come up with some other thing. My last question is super quick.
And if I may, before you get to your last question,
Yeah.
I expect that your question that you just asked regarding in Kansas specifically, that Tanya Keys is up next, and perhaps she could answer that for us. But go ahead with your last question.
Thank you. That would be great. It's just on your chart, the national context regarding removals that have all the 50 states. I'm two things. I'm wondering if you could, if you wouldn't mind. So I'm a very visual person, and so I notice on the left side, you go from 100 to 300, and then the ones that go below, it just goes down to 33%. I'd love to see a chart that actually was equal on the ups and the downs. So you understand what I'm saying?
Yeah, you're gonna force me to go back to my math days. So,
Sorry.
it's okay. You want the scale logged. And
I
can
do, yeah, because I mean, when we're looking at it, it's actually, it looks like New Jersey is the same good as maybe, Montana is bad, but that's not exactly right because it's 33 versus maybe 250%. So, if
Yeah,
you,
but the one thing I'll say is that the way it's shown now is actually counterintuitively the way you want it. And I can explain it, but it's like super technical. It's because the space between 0 and 100% is the same as the space between 100 to as high as it can go. So New Jersey and Montana are somewhat similar on that track, and it's highly technical. I'm happy to provide some written explanation of that.
okay, well,
But
I'd be happy for you to go back to your math days if you don't mind doing that. I think it would be helpful, and math is kind of a thing for me that I do enjoy. And then you mentioned that you could do the same thing for Kansas with counties. And so if you could do that, that would also be really helpful for us if we could see our counties. I mean, even if you don't do all 105 of them, whatever, but and scale the chart again to, be the same, would be appreciative. Okay, Madam Chair, thank you so much. Thank you for
Absolutely. I wish we had
being
more
with us.
time. And we have one last quick question from Representative Housley.
Thank you, Madam Chair. And the previous representative touched on it, but the county comment that you made when you were talking about disparities, in removal. I know Kansas is an outlier in some situations, and we're unique like every other state in situations, but is that county discrepancy unique to Kansas?
no, not at all. Every jurisdiction I've looked at has significant, and it's not unique to removal. It's not unique to, like, across all decision points, we see tremendous variance across counties, across states over time in the rates at which we do things. So I actually I haven't looked at county level data in Kansas, but I'm willing to bet my mortgage that it looks like every other state I've looked at, which, even when we throw out some of the smaller counties that can really skew the number, I think you said you had 105. So if we find those larger counties, we still see tremendous differences in the at which we do things in this context, remove children from their parents' custody.
I appreciate it. Thank you.
Thank you so much, Mr. Church. And committee, I would address your attention to the slides, that there are links on the slides within our, and if you haven't been able to find testimony, maybe most of you have, and I was the last one to find that, but it's under agenda and minutes on the legislative site. And now we'll move on with our agenda to Tanya Keys, and I hope that you can address some of the questions that were asked about Kansas specific. Welcome to committee.
Thank you, Chair Gossage and committee. I'm Tanya Keys. I'm in the role of Deputy Secretary for Programs and Services with the Department for Children and Families. It's good to see you guys again. Thanks for the opportunity to talk about sort of our front door pathways and activities. I have 2 items, so I'm going to be going through a slide deck, but I also prepared sort of a set of attachment that goes a little bit deeper into some of our forms and some of the tools that we use and have alongside families in case you want to see what a family would see, or a little bit more about one of our protection specialists, how they're doing the work alongside the family. So I'm going to talk a little bit today about well, maybe. All right, he told me it was slow, but it's pretty quick. I'll go through a little bit on the practice model context. I want to talk about the Kansas Protection Report Center, because that's the gateway to where our work starts. Go into a little bit more detail on activities for reports assigned, additional coordination, and then the prevention service path. It's important just to set a little bit of a landscape, I think, in terms of the Kansas practice model, which some of you have heard about before. Our approach is a safety organized approach. We want to make sure that we're getting family voice, youth voice. We have tools that help us get a child's impression through drawings and different things that we can use. We also, as has sort of been mentioned, we want to cultivate those family and community networks to help us. We want to make sure that we're using evidence-based assessments, meaningful service interventions, as Christopher Church mentioned, and we know all of that happens in a context of a robust workforce and data and quality assurance. So that's our approach in the safety organized practice. Within that, then, we have some ways that we're alongside families through tools that we use, and you'll see some of those tools today. So, for example, we use signs of safety, we use structured decision-making, solution-focused questions. I think you guys have heard sometimes about team decision-making that we use, 4 questions. We do collaboration, and we have some specific procedures. You know, for example, we make a care referral. We might make a referral to a child advocacy center. So those are some of the tools that we do in the collection of activities, but all those tools hope to support our approach. All of this work and effort in the communities with our collaborators and partners and alongside families is sort of in an environment of our agency beliefs and values. And so I want to notice that, and we appreciate all the community partnerships that help us with what we believe. Very quick sense of what the pathway is. So today, again, I'm going to talk about when we get that call for the Protection Report Center. If the report is assigned, that report is sent to a regional service center, a child protection specialist there. That specialist then goes out and is alongside the family and does some effort, coordinates referrals. So very high-level summary, that's the sequence that happens. So first, we're going to talk about the Protection Report Center. The Protection Report Center is our gateway. Today I'm here to talk about child reports. Protection Report Center also is the agency's mechanism to receive reports of adult abuse or neglect or exploitation. So functionally, that number and that center does both child and adult, but today I'm just talking about child reports. So let's talk a little bit about just some logistics about the Kansas Protection Report Center overview. Again, it's our gateway. So it operates 24 hours a day, 7 days a week, every day of the year. It's open holidays. The mechanism can be you can call toll free. Mandated reporters often make their reports online through a web portal, but we also accept fax. We accept someone can walk in and talk to us, and we accept postal mail as well. So lots of different ways to get a hold of us. It's staffed through 88 positions across specialist supervisors and a couple of managers. Physically, it's located in 3 different locations. We have sort of a hub team at the Kansas City Service Center, one at Topeka Service Center down the street, and Wichita. A number of staff do telework, and across all 3 shifts that they might be working, but we do have the physical hubs for those locations. We have an information system called the Kansas Intake Protection System. KIPS is sometimes what it's referred to. Just to give you a sense of where we're at. So I'm starting to talk about the Protection Report Center. So this is our gateway. We received last year about 71,000 reports. That's where we start with the numbers, is about 71,000. Over 2/3 of those reports come to us through the web online report. So just some context of how we're managing those. We receive them through the web, and educators are our most frequent reporter. But just a little bit of data regarding the report source for you, and I think some of you maybe saw this, some of this at the March meeting, but again, educators, social service members or social service professionals, collaborators are the 2 most frequent reporters. I mentioned earlier we have kind of the Kansas practice model, and we've had a lot of help from Safe Generations and others, Evident Change, who have helped us with questions that make a difference. Over the past year or year and a half, we've really been integrating those questions that make a difference into the Protection Report Center specialists. So our process starts with we get the call. We need to ask some contact questions. So in addition to asking names, where are folks living, where are they going to school, some of those identifying informations, we, at the beginning of our understanding of a family, we want to ask the reporter, what are they worried about? So we ask the reporter at the time of our Protection Report Center, we want to ask them same questions that we're going to ask a family in a couple of days if it's assigned. So we want a continuous way to have a consistent practice model so that it all aligns. So, you know, for example, after we've asked for contact information and got some logistics, you know, what has someone done or not done that has you worried enough to reach out and call us today? So we're trying to engage reporters in a different way when they're calling us. And those are just some examples of different intake questions that's happening in our front end. The next sort of point that happens with the Kansas Protection Report Center. So someone's called us, we've got their information. A decision point for the Kansas Protection Report Center is an initial assessment decision. And it's really to determine whether or not there's enough information to proceed, that we need to go out and make a family. So was there reasonable grounds to believe abuse or neglect exists? Are there immediate steps that need to happen to protect a child? Also, is this a family in need of assessment? Maybe there's no abuse, neglect alleged, but they might be in need of a service. So those are the context of the decision points for that specialist at the Protection Report Center. So we've got these kind of boxes. So we're doing an initial assessment decision. That's on that, you know, approximately 71,000 reports. That's what happens. All those reports at least get that initial assessment determination. Below that, on the left side, with the information that we have from the reporter, and we take information from a reporter in good faith. We do have some tools that we can look up some history to understand some, but we take information in good faith. 48% of reports that we receive are assigned for further assessment, and that's the box on the left in terms of the decision point. But we do have just slightly over half, 52% of those, you know, 71,000 reports are not assigned for further assessment. Factors considered in that decision for the initial assessment, you know, include age, is there access by an alleged perpetrator, the condition of the child, actually the impact to the child. So there's a set of factors that are part of this decision process. As I mentioned, a little bit over half, 52% of the reports that we get, and again, those might be through a web or a phone call or from a fax, 52% are not assigned. The most frequent reason that a report is not assigned is because it's a duplicate report. So it's already been assessed. We might, for example, we might receive a report from a school or from a medical professional, and maybe we'll get that report, say at 9:30 in the morning. Well, later that afternoon, perhaps we then receive a report from law enforcement or a report from school on the same incident. So it's sort of an easy way, or maybe a classic example of how to explain that. Of those 71,000 reports we receive, we don't assign all of them, because really all we need is one report that has information so that we can go out and assess alongside a family. Talk a little bit about assigned reports. I mentioned 48% of that 71,000 are assigned. So which for 24 was about 35,000 reports. So that's what we're going out on. In general, when we're assigning those, 30% of those are about a family needing assessment. There's no abuse or neglect alleged. So 30% are in kind of this light blue category. Another 25% are all types of neglect. So for example, lack of supervision, medical neglect, physical neglect. That's another grouping. 25% neglect, 45% are regarding an allegation of some type of abuse, physical, sexual, emotional. That sort of gives you the distribution. The top three reasons are physical abuse, emotional abuse, and lack of supervision. That's when we're assigning reports, those are the three greatest worries that we receive from reporters. So where we are in the process is we've got a call, we've made a determination that a specialist needs to go out, and the next decision that the Protection Report Center makes is we need to assign a response time. We have 3 options for a response time currently in policy. One is the same day, one is 72 hours, and if it's a family in need of assessment, we can have 7 working days unless there's a police protective custody or an infant involved. And I have on this chart, we know as of July 1, we'll have an additional response time where we need to make contact with the family within 24 hours. The majority of the reports that are assigned, 50% are assigned as a 72-hour response. That's kind of where things land based on the decisions. I have on the next slide a little bit of detail about, well, how does that specialist in the Protection Report Center decide whether or not it meets criteria for same day? We have set forth in policy reasons why it would be assigned for a same day. The most frequent reason is the child's currently in police protective custody, so it needs to be same day. Any allegation of abuse or neglect of an infant. Another example, a child with a current injury due to alleged abuse and neglect. Those are just some examples. Our policy and procedure manual outlines a lot of details and guidance for specialists in how they make the decision about either same day or 72 hours for abuse and neglect. So this is where we're at in the process. So the Protection Report Center, we got the call, it's assigned, and we know in state fiscal year 24, right, it's about 35,000 reports. That's what we're talking about for a whole year. It's assigned to a service center, goes to a child protection specialist, and it goes where the family resides. That's how we decide. This next pie chart, it gives a little bit of sense of the distribution across regions, and then the next slide I have a map in case it's helpful to see a map. But with this one, so a third of those assigned reports, right, the about 35,000, or a little less than a third, pardon me, 30% are for the Wichita region, and that region has about 10 counties. It's larger than just Sedgwick. Kansas City region is 24%. And that, again, that's the Kansas City region. It's about 5 counties, so it's not just 1 or 2 counties. So just keep in mind that percentage. And I want to go to this next slide so you have a context of the counties that are covered and the percentage that's impacted. And I wanted to take a little bit of time on this slide to talk about our workforce in caseload. So 35,000 are assigned. That's about 100 a week that are impacting the different regions depending on which region. And our goal is we have about 330 protection specialists across the state. And with those, about 60 supervisors. So our ratio of a supervisor to worker is 1 supervisor to, it doesn't quite get to a whole number. It's like 1 supervisor to 5.56 specialists. Our goal is to, what we know the standard to be is a lower worker to supervisor ratio is better. So we've strived in the past 3 or 4 years to make sure that we have a really good supervisor ratio. Our caseload goal or target is for each specialist to have 14 or fewer new cases assigned a month. Most months in state fiscal year 25, we've met that. We didn't meet that in September, October. Those are our busiest months for reports. So we have a couple of months that pop up above 14 new. We also have a couple of regions, Wichita and Kansas City, who have sort of more challenges making sure that all of their specialists have 14 or fewer. But we've been doing really well this year and last year too. We want to make sure we're supporting Kansas City and Wichita too with their specialists to make sure. So that's a little bit about that. I think I anticipated maybe a question about salary. So a starting salary for an unlicensed specialist is it's $51,727. So about a little bit over $51,000. If you're licensed as a practitioner, you start at $54,450. and supervisors for child protection specialists start at $58,471. We also have some other career opportunities, such as like a team decision-making facilitator is the same as a supervisor, and some other pieces. But that's the basic framework for our salary. So we are at a point in this process where we're talking about a report's been assigned, 35,000 last year, and a specialist is going to go out and meet the family. So I wanted to just talk at first about just some common activities. So we, in the beginning, depending on the reason why it's assigned, it might need to be a joint investigation. So one of the first things folks are doing is, does this need to be coordinated, joint investigation with law enforcement? Do we need to make a care referral? Do we need to engage a multidisciplinary team for a child advocacy center? Those are some frequent coordinated activities, especially for those reports that involve abuse or neglect. We interview and observe a child. Sometimes that might be jointly, depending on the nature of the allegation, but there's an interview and an observation of the child. We're engaging the family, we're interviewing the family, other collateral witnesses. We want to engage the family's network and their relatives. We're assessing and creating a lasting safety plan and risk assessment. So I think you heard Christopher Church talk about safety and risk assessments. We complete those at this stage when we're with the family. We also will develop a finding conclusion, and you heard Christopher Church talk about that, so I'll go into a little bit more detail about that. But we're also exploring meaningful service delivery. And also we're assessing immediate danger, alternatives to protective action, and having those kind of conversations. So those are the types of common activities. And this slide I just wanted to find a way to illustrate that sometimes the work isn't as sequential. Sometimes it can really overlap. All of this can happen in a few days, or sometimes this might take a few weeks. But typically the activities that I just mentioned, and that I'll go over in a little bit more detail, can be overlapping. I wanted to talk a little bit about immediate and lasting safety plans. So a report is assigned, we're alongside a family, we've observed and interviewed a child or children, and we've talked to the family, and hopefully they've had an opportunity to include their network and any collateral witnesses that might be relevant. So we've done that work. That work helps contribute to immediate and lasting safety plans. In your packet, and I think on a future slide, I have some examples. But in your packet, we have an example of the brochure that we give to families to inform them about the process. You have an example that is specific to a plan of safe care. That's a brochure that we give to families, either pregnant women, women who are pregnant who need services, or they have an infant. And we also have examples of the actual conversation notes and the MAP assessment that we do with families. The immediate safety plan is really about, we're having conversations in the conversation notes to ask, what are you worried about, what's working well, and what needs to happen? And that's a little bit more in the moment. You can be working on an immediate safety plan while thinking about the risk assessment and a lasting safety plan. There might be more conversations to have, but today, we might just need an immediate safety plan and discussing alternatives to protective action. So an immediate safety plan is short-term. We have children's tools we engage. We have other tools that we can talk to families. We use the 3 columns in a conversation so we can get a full perspective of what's happening. We might be asking the 4 questions in order to lead to a team decision-making meeting and different things. So just think the immediate safety plan is more short-term. In addition to that, or maybe co-occurring with that, we're having conversations about lasting safety. And sometimes lasting safety is referred to as a risk assessment. We use the term lasting safety. That lasting safety goes into a little bit more detail about past harm, other things that have happened, how has the family solved problems before. And I think I've got some examples of how we can also scale. So this is a little bit hard to read, but This is an example of a resource, a guide that our specialists have, and we can show to a family and talk about with a family to help the conversation. And it's usually just, a question about on a scale of 0 to 10, and you give them some what's 0 and what's 10, how do you feel about a child's safety now? And that helps you have conversations about, well, why are you worried about that? What's been happening in the past couple of weeks? What happened yesterday? All of it is really to just try and engage everyone in those kinds of questions. The questions about the immediate safety scale are a little bit different than when we want to talk about the lasting safety or risk assessment. The lasting safety includes greater factors, like, for example, do we know, are there 4 or more children in this family? Are there 3 or fewer? Are all of the children under age 3 or over age 3? So the lasting safety assessment, which is about risk, helps us have conversations to include more context about family dynamics and other things that we know can impact protective capacities of a parent. Very quickly, just a little bit about some additional coordination or referrals that we do. A collection of activities, not all of these are applicable to all families, but if they are, we do these additional coordination. So for example, we have some federal requirements around pregnant women using substances or substance-affected infants. We need to do a plan of safe care. It's a very specific, it has federal requirements and conversations in a separate planning document. If there is a family whose children, they're victims of abuse or neglect and they're under the age of 3, we need to make an infant toddler service referral. That's a federal requirement. We have policy requirements to support families with infants. So we'll do a parent skill building service referral. And we also, when there's an infant, we do a safe sleep referral. There are other pieces around state law that have been a bit more recent in terms of coordinated referrals. So if there is a child with problematic sexual behaviors, we make a referral to mental health or a child advocacy center. And then more recently, in the past couple of years, if the child's 5 years or younger alleged to be a victim of physical, emotional, or medical neglect, we make a care referral. So there's just additional examples of additional tasks or activities. Wanted to talk very briefly about a case finding. So we've met with a family, we've been doing our assessments, we've been evaluating the facts and circumstances with regard to the allegation. We make findings when there's an allegation of abuse or neglect. So this does not involve a FINA family. This is about abuse or neglect. We have 30 work days to make the finding. There can be some exceptions with that, like if law enforcement asks us to wait or we're waiting on medical records. So, but our policy is we do the case finding in 30 days. So the finding itself is unsubstantiated, substantiated, or unable to locate. Those are the 3 finding types. In Kansas, 96% of all report allegations are unsubstantiated. So that's what we look like in Kansas with regard to our unsubstantiated. The finding type, which is a task we have to do, we have to make, and that just says, to which allegation was that? Was that regarding physical abuse? Was it regarding lack of supervision? We have to be very specific about the finding for each allegation type. And then we also record a little bit more detail. And I've just got some examples here that come from our form. So for example, we need to, if the report is substantiated or unsubstantiated, we need to describe what type of injury was alleged, what was the degree of injury, was it minor, moderate, none, and then also the perpetrator relationship of the child. So the finding itself, then we sort of just have to give a little bit more detail, and all of these are reported in federal reporting as well. So that's just an example of some of the details that we record with any finding. I want to talk a little bit more about the basis. So the finding decision for a case, again, this is about abuse, neglect allegations. It's made in consultation with the supervisor. It's done through the assessment, and it's based on facts and circumstances that they're able to gather. The standard is preponderance of evidence, and it has 3 components. of it. I already mentioned that it can be delayed more than 30 work days. And when we make a finding, we need to make the same finding for the child as well as the alleged perpetrator. We can't have differences in findings. So that's the basis for decision. And then I wanted to talk a little bit more about substantiated finding decisions. So 4% of our findings have a conclusion of substantiated. So for those decisions, the child protection specialists, that decision is made, and the result of that substantiated finding means that the perpetrator's name would be placed on the Child Abuse and Neglect Central Registry. Administratively, that's what that finding does. That's the impact of that finding. It needs to meet certain criteria. Substantiated findings are provided as a notice to the county or district attorney procedurally, but the finding needs to meet the criteria for 3 pieces. So 1, it needs to meet the definition of whatever maltreatment type it was. Physical abuse, lack of supervision. So that's the first criteria. Then the determination, and it's not just a then, and that determination needs to be made on, the perpetrator's actions, behaviors, or omissions occurred and met one of the following criteria. So there's an intent to commit the act. A reasonable person would have anticipated harm would occur, or the harm was the result of failure or refusal to protect. So those 3 pieces need to be associated with the perpetrator's actions. And then 3, and there's serious harm or injury or deterioration of the child. Those are the sets of criteria that would lead in Kansas to a case finding of substantiated abuse or neglect, again, where a person's name would be placed on the registry for child abuse. That's the criteria for the substantiated decision. We do have due process for any alleged perpetrator. So the DCF proposed finding of substantiated doesn't impact any alleged perpetrator until all appeal time is exhausted. A substantiated finding can be appealed to the Office of Administrative Hearings. That process occurs. If that individual is not satisfied with that process, they can go again to a state appeals committee, and yet not satisfied there, it could be appealed to a district court, and they have an opportunity to be represented. Thanks for your patience. I just have one more. This last piece in your packet, I wanted to talk about the service prevention path. So I've talked about a lot of the technical coordination activities that are done, and a lot of those activities, especially the finding, just had to do with abuse neglect. But without regard or regarding any worry that someone calls in and we've assigned for help, whether it's a FINA or neglect or abuse, we have an opportunity to be alongside the family on a prevention service track. So the first page in your packet just sort of gives a little bit of a diagram about risk level. We can always make a community referral for any family. If through our assessment and the immediate safety plan and the lasting safety plan, they're at risk of removal, we have options of family preservation services or an array of meaningful services based on age and need of a child for family first or family preservation, and to include preventive legal services. In addition, if there's a worry that the safest decision might be to separate the child and the safest decision is foster care, we would engage the family and their network in a team decision-making meeting. And the results of that meeting could be a service referral, or it could be that the safest decision for the child is foster care. That's a very high-level track of possibilities within the framework. The last slide, I think, shows over time, the number of children who have needed to enter foster care in Kansas, and we've had a decrease in the number of children removed and the rate of removal that Christopher Church mentioned. In his, he had all the states across in that continuum. So Kansas, since federal fiscal year 21, has reduced the rate of entry into care. So for example, in federal fiscal year 20, our rate of entry into care was 4.17 children per 1,000 child population. That was nearly twice what the national rate of entry into care was. So we started at 4.17. Federal fiscal year 24, we've reduced to a rate of 3.55. So that's the result of a lot of community support, a lot of opportunity with prevention service continuum and meaningful services, and a lot of other community support. So that's a little bit of context. Happy to stand for questions. Thank you.
Thank you. We'll open it up to questions in just a moment. I did notice in our packet here, there's this, looks like it's a handout, Kansas Child Protective Services. I don't see a number on the slide, but I think that would be good for each of us to have as legislators to be able to give to our constituents that we may come across or just have them available. Is this something that's available online that we could send as a PDF, or are there copies that we could actually get from the office?
Yeah, thank you, Chair, for the question. It is available online. It is available in a PDF. We can send that to you. We could print you some, but it's available online. It's provided to each family that a protection specialist goes out and meets with. It's usually like a trifold. It's a brochure.
Yes,
Yeah.
I can tell it looks very informative. There was a question that was asked by Representative Humphreys, and I wondered if you could address that as to the number, and I'll let her ask her question again. But it appears to me it was 31% of the reports that you get end up being something that you investigate, but then I didn't hear you say what percentage of those end up going into foster care.
Thank you for the question. Of all the reports we receive as an agency, 48% are assigned. So we're going out to meet 35,000 families. In state fiscal year 24, we met a little bit more than 35,000 families. In state fiscal year 24, I believe there were 2,578 children who entered care. I don't have a number of all the family reports we received, how many of those 38,000 reports led to a path where the safest decision for a child was foster care. The difference is one's a child count and one's a family count. Right. So it's kind of tough to make it into a percentage. So I don't have that. We could look at a way to see reliably if there's a way to predict it. We wouldn't be predicting it. We would be looking at the data to see if we could count it in a way that would be meaningful. But it's kind of tough. We have a lot of data items that are by family, and then other data items that are by child. And a family could have one child or 4 children. So that's kind of tough to answer, but we can see if we can try and make it meaningful.
You can start the questions with Representative Humphreys if you have a question for her.
Well, I think you answered that question, Tanya. But also, I think the other question was do we know the mode of removal? I mean, maybe we already have that. Is it police protective custody or of those families or children, either way,
Yeah, thank you, yeah. Madam Chair, and thank you, Representative, for the question. We do have data, and it may have been presented back in March. How we look at it is, so I mentioned I think it's 2,578. I should probably just say 2,500 in case I'm wrong. But of the children who entered care in a year, and that 2,500 is from 24, we can do a look back and reasonably count if they entered foster care, if they entered the temporary order of the custody of the secretary, did they have what we call a law enforcement plan or a police protective custody episode within 6 days prior to entering the temporary custody of the secretary. So we use that as a proxy to know how many police protective custodies impacted the entry cohort of foster care in Kansas. And we select the 6 days simply because we want to include like the Thanksgiving holiday or the longer holidays. But what we knew from that data was that most often, if the child entered the temporary custody of the secretary, that police protective custody happened within 2 days prior to the temporary custody. So it was a real short amount of time. There weren't a lot that were really 6 days apart. They were pretty close to each other.
And just to make sure I understand the terminology, when you're talking about entered care or whatever, that has been adjudicated, they've been adjudicated as a child in need of care, or they have just been removed from the home? Which one?
Thank you, Madam Chair, and thank you, Representative. No, they have not been adjudicated. Removal into care or separation from a family, our measures are removal into out-of-home placement and temporary custody to the secretary. So it's the temporary order of custody hearing. Adjudication may take another 60 days to occur. The removal is we measure, were they removed into foster care?
Just really quick question. So that temporary custody order, does that have a hearing, or that is just filing an order and the judge signs it? I mean, is there actually an appearance in court for that temporary order?
Thank you, Madam Chair. Thank you. Yes, there should be an opportunity for a temporary order of custody hearing that occurs within 72 hours, not including weekends and holidays. It needs to happen within 72 hours of the initial order of protective custody, whether or not that was through law enforcement or through an application for consideration from DCF.
And all the parent, everyone's given notice of that, surely?
It's my understanding they are.
Thank you. Thank you, Madam Chair.
Committee, we're running a little behind, so I'm going to take one more question from Representative Howell. If you have other questions, please reach out to the Secretary.
Thank you very much, Madam Chair. Just really quickly, thank you so much, Tanya, for your presentation. I can tell you put a lot of work into this, and I really appreciate it. It's very educational. My question has to do with the very bottom of slide 27 and on slide 28 about the substantiated finding decision, and bottom page 27 talk about it's the same case finding for the child and the alleged perpetrator, and based on the facts and circumstances of the incident, unless the alleged perpetrator is unknown. And then it talks about on the substantiated finding decision that you have to have, it talks about you have to have a number of factors to find the substantiated case finding. So when the alleged perpetrator is unknown, like for example, when the child has had numerous caregivers, but the child is removed from the home, then how would you prove intent of a parent? And how would they prove it's safe to get their child returned?
Yes.
I mean, how does that work in practicality?
And thank you, Madam Chair, and thank you, Representative, for the question. A case finding or a conclusion about whether or not an incident occurred or not, or is substantiated or unsubstantiated, can happen independent of a decision about safety and harm and whether or not the safest decision is foster care. So if you could have a circumstance where, and I'm going to be very classic or general in the sense that maybe we have medical information of a fracture. There's no explanation that matches the injury. The alleged perpetrator is unknown because of what you described. Maybe there's multiple caregivers, maybe there's child care, maybe there's two parents. Also, with that family, there are some other worries about harm happening that didn't have to do with that allegation of physical abuse or an allegation of an injury that was unexplained. And so in addition to a substantiation for a child for physical abuse and unknown perpetrator, in addition to that, there are circumstances of worries or harm, and the child needs to be separated from the caregivers, and the safest decision is foster care. So a finding, maybe a better way to say it is, a decision to enter foster care related to a child's safety reason does not have to be related to the case conclusion finding that happened about maybe one incident that occurred previously. Case conclusions or findings are about whether or not an incident happened and whether or not that individual should be placed on a registry and not be working, volunteering, or residing in a facility that's licensed by Department for Children and Families or KDHE. They're separate decisions.
Thank you. Thank you so much. We are now going to move to Natalie Nelson regarding mandatory reporting of child abuse and neglect, which we had requested previously. Thank you, Natalie.
Thank you, committee. I am Natalie Nelson from Legislative Research. I am here to talk to you a little bit about mandated reporting throughout the 50 states. For those of you who are on the standing committee of House Child Welfare, some of this information should be pretty similar to what I have presented previously. This memo goes a little bit further, though. So what this is going to include, what I'm going to talk about are 5 things. So the categories of individuals that are designated as mandated reporters, state requirements for reporter training, provisions for privileged communications and confidential reporting, legal standards for initiating a report, and recent legislative developments pertaining to child abuse and neglect reporting. So the information in this memo is primarily sourced from the Child Welfare Information Gateway, which is, it's sort of part of the U.S. Department of Health and Human Services. And then the information regarding recently enacted legislation comes from the National Conference of State Legislatures Bill Information Service. Lastly, I would note that this memo is going to be sort of a summary of the 50-state survey, but an appendix containing 4 tables summarizing all of the information described below is attached to this memo in the back there. So you should have actual 50-state information related to this information. So firstly, who must report? 46 states identify specific professional groups obligated to report suspected child abuse or neglect. And the most common types of professions listed in statute include physicians, nurses, other healthcare professionals, teachers and other personnel, social workers, law enforcement officers, mental health professionals, child care providers, clergy members, medical examiners and coroners, attorneys, guardians ad litem, and court-appointed special advocates, and then recreational activity employees and volunteers who frequently come in contact with children. So additionally, 17 states impose a broader duty, so requiring any person who suspects child abuse or neglect to report the concern to the state's child protection agency. And some of that includes, some states have both that general requirement and the listed specific professions, but then there are, I think, 4 states that just have that any person sort of general requirement. So then the next piece here is the standards for making a report. So states generally use consistent statutory language outlining when mandated reporters must report. Typically, those reports must be made when the reporter in their official capacity suspects or has reason to believe that a child has been abused or neglected. And many states also mandate reporting when the individual has knowledge of or observes a child being subjected to conditions that would reasonably be expected to cause harm to a child. And I wanted to note, before I go any further, that Jesse Pringle from the Revisers of Statutes Office is going to be talking to you specifically about Kansas's statute. So that's why I don't have anything specifically just to Kansas in this one, because I don't want to steal her thunder. So, okay, so next, confidentiality and anonymity. So some states protect the confidentiality of information that is received through a report of suspected child abuse, specifying that such information is privileged and cannot be used in legal proceedings involving a child in need of care. The most commonly recognized privilege is the clergy penitent privilege, and that's protected in 30 states. I would note that a lot of those states have a sort of disclaimer there that says if a clergy member is also a member of, a specific profession, if they're also a licensed counselor or a social worker or whatever it may be, then they're not sort of protected in that regard. So they're still under, sort of the mandated reporting requirements of that profession. And that would be more likely to be, a member of a clergy within a church than, say, like the priest himself. So, and then the attorney-client privilege is another commonly held protected. So that's in 22 states. And then 5 states recognize a physician-patient privilege. Along the lines of confidentiality, 30 states permit anonymous reporting of suspected abuse and neglect, while 19 states require reporters to disclose their names and contact information, either orally or in writing, when making a report. And then training for mandated reporters. 22 states require training for mandated reporters to be conducted either upon the initial employment or during regular and ongoing training, or some of them that's both. And I am in the appendix, I did include those states where there's, specifically mentioned how the training should be, the frequency as mentioned in statute. So, and then lastly, so recent legislation. So 8 states have enacted legislation pertaining to the reporting of child abuse and neglect in 2024. I would note that the information that I found from the survey comes from was current through, I think, May of 2023. So I went back and looked starting at 2024 to see if there's been any changes. And so these are the additional items that have been enacted since that original memorandum. So Arizona, they expand in SB 1067, they expanded the definition of abuse to include abuse by employees of child welfare agencies where a child is placed if the agency is licensed by and contracted with the Department of Child Safety. So basically the case management providers, like contractors, like we have here in Kansas. Furthermore, it requires that the DCS hotline to prepare a report if the suspected abuser is an employee of the child welfare agency where the child is placed. So it's essentially just including all of the normal requirements for reporting to specifically include those employees of, case management providers. SB 1235, that just establishes in Arizona the Child Safety Fatality and Near Fatality Review Team to review all reports of fatalities and near fatalities when of a child made to a child abuse hotline, and then that directs the team to prepare a report to they also have a joint oversight committee similar, I think, to this committee. So they have to prepare a report for that joint oversight committee. Colorado, in HB 1046, the bill requires mandatory reporters to include information about domestic or intimate partner violence in the child's home when reporting abuse or neglect. And it also mandates development of a consistent screening process for reports and the implementation of disclosure procedures for hotline calls that reflects best practices and cultural competencies. Delaware, it's codifying that another commission is, in addition to their Department of Services for Children, they maintain and conduct child abuse mandatory reporting, the response and trainings. Florida, HB 7001, that preserves the public record exemption for identifying information of individuals reporting child abuse, abandonment, or neglect. Illinois, SB 2788, it amends Abused and Neglected Child Reporting Act to remove a provision requiring all reports made by mandated reporters to be confirmed in writing to the appropriate Child Protective Service unit within 48 hours. Indiana, it mandates that medical professionals report suspected child abuse to both the Department of Child Services and local law enforcement, increases the penalty for failure to report to a Class A misdemeanor. And let's see, Kentucky, HB 271 allows a person to make a written report of dependency, neglect, or abuse of a child, allows child dependency, neglect, or abuse reports to be submitted electronically, and requires that the Cabinet for Health and Family Services establish a statewide reporting system for making reports available to the public. Furthermore, the bill requires the Cabinet report monthly to the Kentucky General Assembly on Child Protective Services intakes, and requires that the Cabinet refer families to community-based child and family service agencies for services when it determines that a report does not meet criteria for investigation. It also creates a new section of law establishing requirements for the Cabinet related to when a safety plan is put in place for a child. Then lastly, New York Assembly Bill 8486. It extends the time by which a mandated reporter must receive updated training incorporating how to identify an abused child with an intellectual or developmental disability from 1 year to 2 years. And I believe that's all I have. If you have specific questions about any statute from any state, I'm happy to look that up and get back to you. I don't have all of the statutes at my fingertips right now, but happy to get back.
Well done, Natalie. Any questions for Natalie? Okay. Yes, Representative Ousley.
Thank you, Madam Chair. Natalie, you mentioned in the confidentiality and anonymity, clergy penitent privilege, and I'm not familiar with that term. Can you just tell me a little bit about that?
So it's essentially whoever is coming to a priest with a confession, or any member, I guess, of a church. And I don't know the specific, I don't know if there are, keywords in statute for that. I can look that up to see if there's specific, of what penitent means. But in general, it's sort of who is coming to a member of the clergy for sort of religious or counseling advice. Yep.
Thank you for that. That makes sense.
Thank you, Natalie. We're going to move on to Jesse.
Thank you, Madam Chair. Good morning, Jesse with the Revisor Statutes Office. So what we have done is we've provided a memo with the exact statutory language that governs the reporting, the mandatory reporting of abuse and neglect of children. So I'm going to highlight some of those items that are covered in that statute. So the statute first addresses the persons making reports, who is required to make that report. And this person shall have reason to suspect that a child has been harmed as a result of physical, mental, or emotional abuse or neglect or sexual abuse. And so there, A, B, C determines who shall make reports if they have that reason to suspect. So in Kansas, that includes persons providing medical care or treatment, persons providing mental health services, employees, teachers of educational institutions, persons licensed by the Secretary of Health and Environment to provide child care services, or persons employed at places under a person who is licensed, and then emergency medical services personnel, firefighters, law enforcement officers, kind of those first responder types, and then any person who volunteers or works at an organization that provides services for pregnant teenagers. So in Kansas, those are the ones that are required to report abuse or neglect. But in Kansas, the statute allows that any person who has reason to suspect that a child may be in child in need of care may report. So that allows this open-ended. If there is a suspicion, then the person has the statutory authority to report. Next, the statute covers the form of the report. It outlines what items are required to be in the report as that is given to the Secretary of Children and Families. And then that report next shall be made to the Secretary, except in a few circumstances. When the Department of Children and Families is not open for business, these reports shall be made to the appropriate law enforcement agency, and it outlines that the next day the department is open, then those agencies are to report that information to DCF. And then there are cases in which reports of child abuse or neglect may occur in an institution that is operated by the Department of Corrections or KDADs. And so there are specific requirements that if that abuse or neglect occurs in a certain type of institution, it outlines who that report shall go to specifically. The statute also covers that when there's a death of a child, and after that death, if there's a person who has a suspicion that that child, or that they have information of that death related to any abuse or neglect, they shall immediately notify the coroner, and that's in KSA 22A 242. So that directly goes straight into that the coroner, and kind of that analysis. The statute covers violations of the section. So this would be the failure to make a report, or intentionally preventing or interfering, or the making of a report, or making a false report. So there are violations and there are penalties for those types. And then lastly, the statute covers immunity from liability. So anyone who in good faith, without malice, is making this report is then immune from any civil liability that may be a result of making the reports. This section has been amended a few times. It was first enacted in 2006 and then was enacted in amended in 2011, 2012, 2014, 2016, and then the current language before you today was amended in 2022. So if anyone's interested in specifically the evolution of that, that's information I can provide. Some more information for the committee is that there have been bills since that 2022 original language, for example, adding clergy or social workers or those items, but none of those bills have been enacted. And specifically this session, there was no bill enacted that would change the language from this 2022 version in front of you. Other statutes that do relate to mandatory reporting can be found in 382224, 2225, 2226, and these are less about the requirements for mandatory reporting, but they would prohibit termination of employment if someone were to report, and then it allows the Secretary for DCF to adopt rules and regulations for the process and the procedure of reporting in those state institutions that are briefly mentioned in this section. And then the 382226 delves into the procedure of investigating reports. And 382226 may sound familiar because that is the section that requires the visual observation and the CARES exam. So that has been amended in the last few years that quite a few of you know about. With that, I'm available for any questions. The purpose of this memo is that you can kind of lay it side by side with Natalie's and see what is everyone else doing, and then look exactly at what Kansas is doing.
Excellent, thank you, Jesse. Questions, committee? Yes, Senator Falscato.
Thank you, Madam Chair. Thank you, Jesse. So in that reporting process, you've explained, who it goes to and who is mandatory to report. So what is there any process there for the person making the report? So we want to make sure it's just not a neighbor that they're mad at you today, so they're going to report, or it's a sibling you're in an argument with and they're going to report. So how do we determine the legitimacy of that reporter? Thank you.
Yes. Thank you, Madam Chair. Thank you, Senator. So this specific section doesn't go to kind of that standard of proof or that substantiated process that DCF talked about earlier. What the section does require is specific information. So anyone making that report is required, I guess, if known, always that qualifier, if known, the names and addresses of the child's parents or other persons responsible, the location of the child, if the child is not at the child's residence, the child's gender, age, race, reasons why the reporter suspects a child may be a child in need of care, or if that abuse or neglect or sexual abuse is suspected, and then the nature and extent of the harm to the child. And that may include any evidence of previous harm. And then there's the catch-all, any other information the reporter believes might be helpful in establishing the cause of harm and the identity of the persons responsible for that harm. So this section doesn't specifically give any notice on, how far those items are to be determined or investigated by DCF. It just kind of lists them out. And then the section is actually silent as to whether there's a requirement for the person reporting to be stated or whether that person can be anonymous. So that is actually not in the statutory language either way.
Representative Howerton.
Thank you, Madam Chair. So that was kind of where I was going. So we are an anonymous reporting state. We don't have to give any kind of information when the report is made. Is that correct?
So what I will say is in the statutory language on this section, it doesn't speak to whether that's a requirement or not.
Okay.
So it just says what information is to be reported to the secretary.
And as far as like penalties for not reporting when you know something, speaking specifically of teachers, because I know we have some teachers testifying, what are the downfalls of that? Or if they don't report, do they lose their license? Do they get penalized? What exactly is that?
Sure, yes. Representative, you can find the penalties for those violations in subsection E. So first is that willful and knowing failure to make a report required by the section. If that's found to be valid by a court, that would result in a Class B misdemeanor. You can't do any sort of defense stating that, well, I believed this other person made that report, so that's why I didn't do that. And then two, an intentional prevention or interfering with the making of a report, stopping someone else from doing that. If that's valid by a court, that would also be a Class B misdemeanor. And then a person who makes a false report, if that is found to be valid by a court, then they also are a Class B misdemeanor. Class B misdemeanor, I don't have exactly what that would be in statute in front of me, but that would be the penalty, and I can get what are the impacts of a Class B misdemeanor on a person or their record.
Yeah, I would just be curious. I've heard teachers say, I'm going to lose my license if I don't report, so I report everything, which I understand that, but it creates a lot of reports where maybe they could ask a few more questions. Are they allowed by statute to ask questions, or is that rules and regulation, or how do you have to know? What does that mean?
Yeah, so
Or suspect, like how do you define that?
Correct. So KSA 382202 is our common child in need of care definition section, and that doesn't have any definition on has reason to suspect that child has been harmed. So kind of that's the phrasing where those questions may come into play. When it comes to losing a license or the impact of a Class B misdemeanor, there's likely a section in their licensing compact or their licensing regulations that would say, if this person is found guilty of this, then they may lose their license. So that's where you would kind of find that connection.
Okay, thank you. And I'm not picking on teachers. I just know they're going to be testifying, and I thought that would be really good to understand where they're coming from. Because I am curious. They are the #1 group making reports. So we want to try to really understand what their understanding is, what the law actually is. If we can make something clearer, then we want to do that to, give them the ability they need to make good decisions and how to understand suspect, because it's very broad in my mind.
Representative Ruiz.
Thank you, Madam Chair. And along the same lines as Representative Howerton's question, Jesse, is there anything in statute that says what the training requirements are to know how to make a report? For instance, educators, because educators seem to be the highest ones making these reports.
So when it comes to the mandatory reporting statutes in the same code, there's no training requirements for anyone who's a generalized mandatory reporting. It's possible, and I can find this in statute, for each person's licensure or personal or professional development, there may be a requirement. And then I think that would also just be kind of left up to an employer or something that may not be necessarily statutorily required.
The intake questions that KPRC, that we saw in the slides by Tanya Keys, Deputy Secretary Tanya Keys, those are really good, very clear questions. Maybe that might be a recommendation down the road that training requirements, that the training match these questions that are going to be asked. Thank you, Madam Chair.
Additional questions, committee? Yes, Representative Howell.
Thank you, Madam Chair. Just real quickly, I would just like to request, could we research and see if we have any known cases of teachers actually losing their licenses because of failure to report, or anyone for that matter? Or I would also be interested about the false reporting, being actually charged with a Class B misdemeanor also under Section 3. Thank
Additional
you.
questions, committee? Seeing none, thank you so much, Jesse. Committee, next we will move to Marcus Stratton. Welcome to committee.
Thank you, Madam Chair, and I appreciate being able to be here today. I'm a school counselor, and I'm currently employed by USD 437, but what I'm sharing today are my personal opinions or experiences, and not so much I'm not representing the district. One thing I've learned today, I've learned a lot, by the way, and a lot of it's been actually very beneficial to my own education. But probably one point of embarrassment is I need to work on my PowerPoint skills. So I'm pretty wordy, and my wife has told me that many times, but now I know what she's talking about. So real quickly, I just want to tell you that what I'm going to offer today is from the last 9 years I've worked as a counselor, and I've done that in 3 different districts. And so the things that I have learned over that time from mandatory reporting have come from a number of different experiences and several different times where I've made mandatory reports. And when I get to a point to where I have to make a mandatory report for a child, I know that experience, I can no longer meet the needs of the child in the public school setting. And so I'm very grateful that there's a way to be able to make a mandatory report. And for the most part, my experiences have been very positive. As I've gone through this, though, I realize also that the process is only as good as the match clarity between myself and the entity that is investigating what I do. And so as I prepared for this today and as I've talked to other counselors, I've come to realize that there is different levels of experience in both the reporters and I believe in the investigators. But the number one thing that has become clear to me today and throughout the process of getting ready for today is that there's not a whole lot of information that we as mandatory reporters have in terms of what happens once we hand this situation off to DCF. And so once we are continuing to work with the student, once we make the report, we may be meeting our legal obligation to do that, but we still have the relationship with the student that we have to maintain. And if we are going to continue to support that child, then we need to, the more information we have, the better. And so without mentioning specific cases, I will tell you that there are a number of times that we don't know what the outcome of a report is. The only thing that we know is we know that if it's been assigned for investigation or not. So if it's been assigned for investigation, we know that the state sees some merit in it, but we don't know the result. And so I'm kind of rambling here, but I don't know what I don't think I did that. Anyway.
We have it in front of us, by the way. We have it on our computers.
Okay.
But you can fast forward on there until our computer tech person returns.
I'm just, actually,
It's okay.
if you're okay, if I just.
You go right ahead.
So a couple of things that were said this morning, and one thing that I'm always aware of when I am working with kids, but Mr. Church said it when he said ambiguous loss is one of the most complex traumas children can suffer. And so a lot of times when you're making a report, I always err on the side of caution when I make a report. So if I have any doubt in my mind that some kind of abuse or neglect is going on, then I'm going to make that report. But when I'm unsure if it's going to be substantiated or not, I'm thinking, okay, but is this going to further harm me on down the road? Am I going to run the chance of being eliminated from working with that child? So if the report's not substantiated, for example, and then parents say, we don't want you working with our child anymore, then some of the things that maybe I've accumulated over the course of the year, I no longer have that kind of relationship with the child. And so I don't know if a report made out of, I want to make sure that I'm meeting my obligation, but I don't really know if that's a report yet. It kind of gets to the point where, is it doing more harm than good? In school, when we are getting our degrees to become counselors, we're taught that, or at least I was taught, that we're not to investigate. If we have a reason to suspect abuse of any kind or neglect, then we're obligated to make a report. And so that is further substantiated by the DCF's guideline, their published guideline on mandatory reports. There's similar language in there. But when we do that, then I think Mr. Church was also talking this morning about further how there's so many different reports in the system that it's starting to burden the system. And so, you know, it's like if we had more guidelines on what we could do to to be more accurate in our reporting, that would be a very helpful thing. Let's see. Okay. Sorry about the delay. I'm just getting caught up here. Also, sometimes another thing that can be considered is what may be a slam dunk mandatory report for one child. You get another child of different intellectual capabilities or different backgrounds, different home lives. It may not be the same situation for a different child. So there's variables. Everything is in motion all the time. So there's just a number of different situations where you can face gray areas in knowing when and how to report. So for example, if you have student X who is a very kind of a calmer type child, and let's say the parent's working, leaving at maybe 3 in the morning and the child's home alone, they're in 6th grade, for example. Is that abuse or neglect to leave the child at home? But then you have another child who maybe has a greater deal of innate anxiety, but otherwise everything else is the same. Is it neglect for one child but not another? And those are things that, once again, I think more training would help those of us that are making those kind of opinions. So I have different thoughts and suggestions. Not that I am the end all in mandatory reporting, but from my perspective, I think first of all, I would say, is it possible to get further guidelines in the things we need to consider when making a report? I would just say that if we suspect that is not really a very good guideline. I mean, it would be helpful if we are going to help the system to make more targeted reports, to know more about what's going on, or not more about what's going on, but knowing more about what the agency would consider to be, these are what you need to be looking for. Also, like I said, the feedback that we get for a report when it is made, the only thing we know is if it's investigated or not. I think it would be immensely helpful to know if we are going to continue working with the child. It would be helpful to know if anything was substantiated. It would be helpful to know if reports have been made before on this family. It's not that we're out to get families, but I've had experiences, and this is the exception and by no means the rule, but without going into specifics, I've had a reporter, or I've had a person that's taken our report and investigated it who I know from experience that there was dysfunction. I better just not say it, but there's been times where you suspect that maybe there's some shortcomings in the investigator. And like I said, that is by far the exception. In 9 years, I think that's only happened once, but it would be helpful to know, you know, there's no direct communication between me and the investigator, hardly ever. So it would be very helpful to know a little bit more along those lines. And also, just for that matter, what are the qualifications for investigators? Another thing that I would like to know that I'm not privileged or I've never been made aware of as a teacher is when we make a report to DCF, is it just a matter of investigation? Or from what I gathered today, I think there's more of a list of maybe positive outcomes that are possible by reporting to DCF. It would be very helpful for educators to know that as well, I think. Also, there are some kids who I have reported on who I think there is some repercussions that maybe come towards the children after it's all said and done. Not so much in obvious ways, like it's more in the way of the way things are discussed and what children are told, who they should talk to, what they should talk about. And so I've had kids talk to me before and they start to get into something and they say, but I'm not supposed to talk about that. And so those are challenges as well. Okay. And then the other thing I'm wondering is there an advocate that's working with the child throughout the process? And so for those of us that are adults that deal in this all the time, we understand the process, but for a child, a 3rd, 4th, 5th grade child who does not, maybe has not been through this before, is there somebody that is with them and explaining to them throughout the process that is willing to be able to help them understand what's going on and to be there to reassure them as they are trying to understand what this is all about? So, in short, I've learned a lot just by listening today, and I think if there was more training available, that would be a good thing. It would help us as educators to have a better sense of how the process works and how we can best get it to work in our situations. So at this time, if you have questions, I'll do my best to answer them. So thank you very much, though. I really do. 90% of what I've experienced has been very, very good and very appreciated with DCF.
Marcus, thank you so much for your testimony. I can tell you as a former classroom teacher, I'm identifying with everything that you are telling us. Remember a young man coming into my 6th grade classroom with a big belt mark across his face, and it wasn't the first time, but he always had a story. Well, my mom said to tell you, in case you asked, this is what happened to me. And then I felt like the second time, like, okay, I'm going to report this.
Yeah.
I don't think that this is just what, I've been told. And it does put you in an awkward position, like, are they going to keep it anonymous? Is this child going to know my teacher, Mrs. Gossage, turned me in, or my mom got mad at me because, I guess I didn't tell the story right. And it can be very awkward. Before we open up questions to the committee, I would like if you don't mind, for Tanya to come back up to the mic to address some of the things that you just mentioned.
Yeah, and by no means
And then
am I
we'll bring you
taking a
back up
swipe
for
at
questions.
DCF.
Oh, of course. We appreciate it.
Thank you, Madam Chair, for the opportunity to been thinking as I was listening, and thank you so much for all the feedback. The training that Department for Children and Families is supposed to provide or afford, that's required in statute that we provide. We do have a partner, Kansas Children's Service League, who helps with that training and has for a long time. What's interesting is we've really been working in the past 2 or 3 years with guidance from a project we had from the National Governors Association and Casey Family Programs to really think about how to fortify whether or not you call it a presentation or a curriculum or discussion points for the training that KCSL does, especially to help reporters distinguish poverty from neglect when they have a worry, and engage discussion pockets of time within that training. And many of the trainings are virtual and they're interactive. So I appreciate the feedback. We have I think it was probably about 12 months ago, maybe 14 months ago, that we, alongside with Kansas Children's Service League, have really put some effort into revising the training to have it be more interactive and informative and integrate some new learnings and opportunities within state law for mandated reporters to help them begin to think about distinguishing or safe ways to really think about if you're talking with a family and describing the worries. We can always do more, and I appreciate the opportunity. I just corresponded with our regional director, Caroline Hastings, about it. I think she's going to reach out, but and if folks haven't had an opportunity to experience the newer presentation version that's been put together with information from other states and the Thriving Families, Safer Children Initiative nationally, that might be an opportunity to see if that's more helpful than it was a few years ago. But we can always improve in terms of presentation, guidance, and facilitating discussion among mandated reporters with the current statutory framework that we have.
Thank you. Committee questions for either Marcus or Tanya about this subject? Yes, Senator Vasquez.
Thank you, Madam Chair. Sir, when you say that you don't know the outcome, why wouldn't you? Aren't you asked to come and testify?
I have never been asked as a result of any report I've ever made to testify. So,
and then, Madam Chair, sir, so you make the report only after exhausting everything else, like, maybe they come with the same clothes on or whatever the issue is. So you've done everything you can before you report, correct?
I would say that it would depend on whether or not me doing things becomes a form of investigation. So if I suspect abuse or neglect, and I would say that neglect is probably a lot more of a fuzzy area than abuse. As per my training, that's what I tend to err on the side of. So that's the kind of thing I would like more clarification on is what are we allowed to do before we report. So I think that's where a lot of those, when they talk about the number of reports coming into the system, I can at least say in the circles that I've been in, it's because that's essentially what we're told to do.
Yes. Yes, Senator Erickson.
Thank you, Madam Chair, and thank you so much for being here today. As I've listened to this discussion as a former principal of a building, I did not want my teachers making that decision. I didn't want them to try to think, okay, something's off here, I'm not sure. If they felt like they had that doubt, I encouraged my teachers. I didn't want them to try to discern whether they should or should not make a report. Make the report. Let the professionals determine whether there's, something there or not. But I certainly didn't want my staff to be trying to make that decision as to whether they must report if they suspect. And so I just want to be careful about, giving the message that a staff member should hesitate. That's not their job. And so that's
I
what I
hope
want to
that's
say,
not
Madam
the
Chair.
impression I was giving.
No, I'm not saying you did. I just want to make sure, though, that there's, you have to think about the staff member as well and the reason why. And I want them to get it to the hands of the professionals to make that determination. Thank you, Madam Chair.
I agree.
I have in the queue Representative Ruiz and Howerton. Do either of you have questions for Marcus or is for Tanya? For Marcus. Representative Ruiz.
Thank you, Madam Chair. Thank you, Marcus, for coming and talking with us. So in a situation, let's say a child comes in, just goes to school 3-4 days, same clothes, kind of thing. Do you have access to a school social worker?
Yes, we do.
Okay,
And
where a discussion maybe could be made with that social worker before doing any kind of report?
Always I mean, it's common practice to involve several people. And even when I'm in a situation where I think a report needs to be done or not be done, I will still talk it over with like the school social worker, maybe the school psychologist, and just kind of flush it out a little bit. I think you're dealing with these kind of situations, it just is best to get all the thinking out on the table. But if, like I said, if there's ever any doubt, then the report is made. So.
Okay, thank you. Thank you,
bet.
Madam.
Representative Howerton.
I just want to thank you for being here, and I don't know what the right answer is. I'm just trying to figure out what we know, what we understand, what the law says, where we're at. Can we do anything to clarify? It sounds like we can. It sounds like you guys need to know, what the parameters are, and they are broad because every child, every family is different. And so it's
Exactly.
really hard to legislate that. We have to
Yes.
be very careful, but then we want to have the backup with the training and what to look for. And I do think, I agree with Senator Erickson, you should report. You're the one seeing them. But sometimes I think of like my granddaughter the other day, she told her mom I hit her. Well, I did, but she snuck up on me to scare me, and I turned at that time, and so I knocked her in the head with my elbow. It didn't hurt her, but that's what she said, and so I'm like, oh my goodness, if she said that to somebody else, where would I be? And so it's those that's the kind of clarifying questions I'm wondering if you feel like you're allowed to ask, or if you should be asked, or I'm just trying to get it in my mind because, especially the younger kids, they say things, and that's not really the truth of the whole situation. And so,
It's all a matter of their perspective.
right.
And then you also have the parents with their perspective, and it's just very difficult to know. And in the years that I've been making mandated reports, I haven't come up with a magic formula, and it's for exactly what you said, and that is there's so many different types of situations, so many different types of people. There's just no way that I think you can perfectly legislate something like this. So what I'm offering today are suggestions, but I don't know if they're actually possible to be able to do all of those things. And I do want to make it clear again that any time you get hundreds or thousands of people working on a certain concept, a certain idea, you're going to get many different ideas, and you're going to get many different ways of doing things. And so I think at some point, the legislation is probably going to be best if we can get it to a point to where people have a little bit of a parameter to move with their own way of interpreting things, but meeting the qualifications, maybe the minimal qualifications, and making sure that we're doing what we can to keep people safe. And like I've said, I've had a lot of very positive experiences with DCF, but the hardest part for me is just not knowing, both in the theater that I'm in, but then not knowing what happens after we hand it off. And I don't even know if it's possible to do something about that, but I do think it would help us follow up with a child better.
And that's one of the biggest frustrations I've heard with the teachers I've talked to is they make the reports, they're happy to make the reports, but they have no idea if they're ever followed up on, if anybody ever looks at them. If the kid's not there one day, then maybe that's, maybe they're in foster care, but they don't know. And you guys care about these kids. You are investing your lives in them. And so it's something we need to consider and look at because
Tanya?
it's frustrating for teachers.
Yes, Tanya, I see you ready to address that, and I had that in my list as well. Please do.
Thank you, Madam Chair, and I apologize I didn't address it when I was up here previously. So regarding knowing the finding or a conclusion, if the report was assigned to assess or investigate abuse or neglect, our understanding is that that information is confidential DCF would not be able to provide that information. But there are ways, and I hope we're getting better with our tools and with our safety organized framework, that when we're asking the family to bring in their network and their planning, or a young person, that we can include educational supports and staff when we're doing assessments, when we're doing the immediate safety plan or the lasting safety plan. So I think there are opportunities to be engaged or involved, or I would hope there would be opportunities with the tools we have in the approach that school staff could be engaged at any point. But we are not able to share when we get to a conclusion finding within 30 workdays, which, that could be a long time, too. There's a lot of stuff that happens in between. We're not able to share the actual finding, but there sure are opportunities to engage in assessment, service planning, and in fact, schools have a number of relevant, meaningful resources that a family, we might help bridge. So I would hope that we would be including, for school-age children, we would be including the experts at school that could help the family solve their worries.
And just for follow-up with Marcus, something we're looking at in changing the definition of neglect is creating a pattern of behavior. And so when you report on this, it will create that pattern of which we can look back on. So that's important too, even if you don't get the answers.
And I, Tanya, just have a couple questions for you, and then we'll get to our next conferee. There was a question, or there was a mention of long answering wait times instead of 20 minutes or so. When you're a teacher and you just have a few minutes to try to make a phone call, you don't have 20 minutes. And I know that there was a time when those wait times were just really awful. Has that improved? What would you say the wait time is now?
Thank you for the question. I don't have recent data on the queue and the wait times. We could get that.
That would be
for the
helpful.
toll-free. Most of our reports, 60% are received through the web. So web, fax, phone. The 88 staff we have, a report, if it's received on the web, goes through a queue as well. And just sort of falls into queue for us to process.
And you probably heard Marcus say that when he was trying to fill that out, he got kind of stumped because he didn't know previous information that was being asked, and so then you can't move forward in the form. And I can just tell you, as a former classroom teacher, there were times I just wanted to call and say, am I, maybe I'm seeing this wrong. This is kind of what's happening. You tell me. Should this be something that you think I should report? You kind of want to talk to somebody about that, and see what you think. And I agree with Representative Ruiz. Talking to a social worker could be good, but just wanting to know, or we've observed this, do you think this is something you should report? Talk to a human instead of trying to fill out a long
thank you for
formal
that.
line.
I've not heard that as a worry, probably in the past 2 or 3 years, but we can look at the queue.
Do you at least tell the reporter, whether that's the physician, the counselor, the teacher, thank you for your, we have heard your concern. We are investigating this. Anything to let them know that, that something's being done?
When we receive a report from a mandated reporter, if they request to be notified of that initial assessment decision, whether or not the report was assigned or not assigned, we send them an email letter letting them know the decision, was it assigned or not assigned.
Okay.
That's where the formal notice stops. When you make a report on the web, you do instantly get confirmation, like an event number, so you would have something so you made a ticket. You also get that. But with regard to decision points, they receive a notice to the reporter whether it was assigned or not assigned.
And I'm going to request that perhaps you and Marcus could get together and he could show you some of those concerns, because these are as you know, this is the kind of feedback we need to improve.
Yes.
And that we could all work together. So I would like for the two of you to exchange, make an appointment, something that would work. Thank you both so much. And now, committee, we will move to Monique Young, and she's on WebEx.
Hi, good morning. Can I go ahead and start?
Yes, you may. Good morning.
Good morning. My name is Monique Young. I'm a professional school counselor. This is my 9th year in counseling, and actually, I'm a neighbor on the Missouri side, although I've done some internship in long-term subbing positions through counseling on the Kansas side. So I know you guys want to go to lunch, so I'm gonna try to keep it a little short. But as far as what my experience has been with being a mandated reporter inside of a school, I definitely echo a lot of the things that Marcus had said earlier. One of the things I wanted to point out, I guess, with the whole process of mandated reporting is that a lot of times it does feel like gray. And as you all have said earlier, it is hard to be very specific or black and white on situations because every student situation is different. I will say that for myself, being on the Missouri side, every year our staff is mandated to have the training to place hotlines. Not only just our school counselors will do it as a cohort, but then teachers as well as administrators would have that training as well. I believe they use Safe Schools training at the district that I was last at. So it was more of like an electronic, like, here's the information, you click through, answer questions about what you just heard, and then get that information. For some people that works, for other people, they'll just try to click through just so they can get the answers. But what I have found at any school that I've been at is that usually the school counselor or the school social worker are used as like a sounding board from admin or teachers of like what we should hotline or what we should not. And so sometimes that could feel a little bit of pressure because again, as school counselors, even us, we're like, well, I don't know if they're going to take it or if they're not going to take it or if this is a situation to hotline. And so earlier, someone had used the example of what if you have a student who's been wearing the same shirt 3 or 4 times over. That could be really quick to be like a gray situation. And one of the things I think we hadn't really discussed yet, or maybe we kind of just touched on just a little bit, was the relationships with the parents. At the very first school that I worked with, my administrator was very specific about making sure that we treated our parents like family members, like extended family. And so when we had situations where we were unsure of stuff, so like say a kid who's coming in with, clothes over and over, same clothes, he would encourage us to call and to be like, hey, at the school, we do have some extra uniforms. Is your child needing, some additional uniforms? But because we in our school was very particular about, again, this is extended family and it's not me trying to judge you. It was more accepted, not only from the staff to make those calls or conversation with the parents, but also from the parents hearing that from a staff member of like, oh, this person just cares about something. But I will say in other situations or other buildings that I've been at, there is a, I guess, a barrier of being non-confrontational. So if there's anything that maybe a staff member thinks that they could say or do that's going to rock the boat, 9 times out of 10, they're going to try to avoid it. And so even at one school that I worked at, a lot of the staff members, well, the majority of the staff members didn't know that they were supposed to be doing the report. They were trying to put the report on the school counselor to do, and the school counselors were doing it. And I told them, I said, no, that's against the law. What we're supposed to be doing is if you see it, you hear it, you suspect it, you are supposed to be the person who, does the report. Now, as a school counselor, I can support you and, walk you through it. But I think a lot of the staff members would hesitate because for a couple of different reasons. One being like there's some type of mystique around what happens once you place that call, because again, we place that report and then we don't hear back other than maybe you'll hear within 48 hours getting that email, that former letter that she was talking about saying that, oh, we've accepted this initial report, or, this report was not substantiated. We'll get that, but that'll be it. So anytime when we've had a question about a student or about a report or a situation that's happened and we need more information, say a hotline has been placed and now there's a custody battle, right? Which usually happens at the school with parents trying to race to the school and get a kid. Then what we have to do is we have to, sorry, my battery is going low, but we have to basically call the reporter who we reported to get additional information on what happened so that we know what to do as far as like next steps. But yeah, as far as like wait times, I will say once they started creating the online reporting system, so much better and so much faster as far as reports. But like I said, everything else I pretty much agree with Marcus. And I'm just curious to hear your questions. I'm going to put my charger in, but I can hear you.
Thank you so much, Monique. And my apologies to Senator Holscher, who's on WebEx. She had asked to ask a question of Marcus, and I missed it. So, but she is on the call with us now. And Senator Holscher, do you have your questions for Monique?
Yeah, and I think this is a question she might be able to answer. In regard to the issue that's been brought up that there's a notification sent if it's assigned or unassigned, is it possible then that you might have multiple teachers making reports if there's no other information communicated in terms of action taken? I was just kind of curious, like I said, if there might be multiple reports then coming in.
In my experience, I've only seen it like if I'm the person placing the report. Can you hear me?
I think it skipped out for a minute, but we just heard you. Yes.
Oh, okay. If I'm the person who's placed the report, then again, I'm only knowing about the report that I've placed. But if there's multiple staff members that are reporting on the same situation, I'm not aware that that even happened. So in some building cases, we'll have like a school building policy of like, hey, if you place the hotline, if you feel comfortable letting us know, because of course we cannot by law mandate them to tell us, but if you feel comfortable, can you share that with administration or a school counselor so that we are aware that a hotline was placed? Because that was one of the other sticky things too. If somebody else in the building has placed a hotline and then all of a sudden a worker shows up, and typically they'll ask for like a school counselor or something for the kid to come down, them to do the interview, then it kind of throws us off as a school counselor or social worker if we don't have any information about who placed the hotline, what's going on. We just know that we have to be in the room with the child so that they have a safe person or a representative from the school with them while that interview or intake is being done.
Makes sense. I just didn't know if there was a central source like for the building in terms of reports, coming in. Okay, thank you.
No.
Thank you, Senator Holscher. Tanya, if you could come back to the microphone. We realize that we're talking to someone from Missouri. It's still very helpful, but can you tell us what the process is? Does the department ever send anyone to the school to talk to the reporter or to call the child in?
Thank you for the question. Yes, when a report is assigned and we're aware school is in session or we're aware that a child might be located at a school, if their report alleges abuse or neglect, we can go to the school and interview the child or siblings who might be in the same school. There are circumstances of a family in need of assessment where we would provide notice to the parents before we would speak with the child, and we do need to provide notice to the parents. We have a form that's a notice of interview that happened if we interview a child and can't get a hold of a parent. So yes, we do go to schools, we do conduct interviews, and we ask permission, we show ID. There could be times when a parent might object to that occurring. And so if the abuse or neglect is alleged, we can delay that interview or make other arrangements for that interview, like maybe go to the house, or the parent could choose to bring the child to the office instead of that happening at school that day for whatever reason. But yes, if we have knowledge that a child is located at a school, we can go to a school to attempt to interview a child.
Representative Humphreys.
Thank you, Madam Chair. So Tanya, just a couple questions. And I'm not in the education system like some of you all. So, but isn't that normal that when someone makes a report, like if it's a neighbor or whoever it is, they don't know the outcome of their report? I mean, it's not normal that you would, I mean, it seems like kind of what I'm hearing from the counselors is we make the report and then we don't know. But isn't that the way it's supposed to be? I mean, isn't that the way it is with other people that are mandated reporters? I mean, maybe not a neighbor's not a mandated reporter, but whatever, counselor, doctor, whatever. They don't know the outcome. Is that true in all cases?
Madam Chair and Representative, thank you. So any mandated reporter, if they request to be notified of that initial assessment decision, assigned or not assigned, could receive that notice. And any reporter, including mandated reporters, would not know our finding conclusion. For example, if it was substantiated or unsubstantiated, or if we had plans to engage the family in a family meeting, those kinds of things, we wouldn't naturally share those because they're confidential. There are ways in engaging the family or young person in a conversation that we can ask them, hey, who's important to you? Who do you want to include in this meeting or this session where we're going to talk about your parents' worries? So there are ways to engage any mandated reporter, whether it's a healthcare professional or an educator, a coach, those types of things. But just to answer your question, yes, you are correct that no reporter would know the finding conclusion of one of our reports unless the family decided to share that with them, because that information is confidential. Yeah. We're not able to share that. Or we would also not be able to share if a report source was different. For example, the scenario of DCF arrives at a school and we don't know who reported it. That information is also confidential, so we would not tell the school or the facility where we arrived who the reporter was. That is confidential. We would not share that.
And is a non-mandated reporter just a church friend or neighbor? Can they also request that initial finding of if it was assigned or not assigned?
I'll check policy. I believe they can.
Okay, that's kind of a side note. And then my last question was, so there are situations where an investigator would go to a school to interview a child and the parents are not notified?
There might be days when we were able to reach a child and interview a child at school when abuse or neglect is alleged, not a family need assessment, where it's later in the day and we might not be able to also let the parent know. So we want to be able to let the parent know. If we can't get a hold of them on the phone and let them know that day, we do have a way to notify them.
So are you saying you wouldn't meet with a child if you can't notify the parents, or you would?
Depending on the allegation, if the allegation is regarding abuse or neglect, we would interview the child.
Without the parents' permission or knowledge?
Yes, we can do that.
Mm-hmm. Okay. All right. Thank you.
Last question is Representative Howerton.
Thank you, Madam Chair. And so I'm just curious about, now I forgot my question.
Okay.
That one got me, my brain going this way. So I'll come back to you. Okay. I totally forgot. I need to eat.
Tanya, thank you. I'm sure we also have other questions once we start to process this. I can just remember 40 years ago, about that time, I'm thinking how young my children were. I've told this story before when we were outside of a Walmart and I observed a woman screaming at her toddler, and then she was pulling out right in front of me as we were going into Walmart, stopped her car, turned around, and repeatedly slapping the toddler on the face in the little child's seat. And I can't abide that. And I took down her license number and I told her I was going to stand in front of her car with my children until the police arrived because that's unacceptable behavior. And she didn't move. And she apologized to me, but she's like, you didn't see how he was acting in the store. And the police did come. And they took my name and whatever. She didn't know me, I didn't know her. But they did, I did receive a call later saying, thank you. It's like a week later, and we investigated this, and she said nothing else against her, and neighbors said, good things about this mom, but we do have it on record that this occurred, and thank you for caring, for children. But I guess that nothing like that happens anymore. I would have known nothing, right? They would have just said, we investigated, and that's all. Is that correct?
In the scenario provided, DCF would not be able to provide that context.
Okay, thank you. And Representative Howerton, I gave her enough time to remember her question.
Is it normal for an investigator not to talk to the reporter? Because the teachers were saying that they were never talked to, they were never asked questions. So is that normal practice? If they give their name and contact information, why would an investigator not talk to the reporter, I guess is my question.
Yeah, and thank you for the question. I don't know that it's normal. It's possible. We would hope in our framework and some of the tools that I showed you that we would be including anyone who's part of the family's network to be part of the assessment and to get more information. What we wouldn't be doing is sharing with the reporter or the teacher in your scenario what is happening. I mean, it's when we're with the family, it's nothing about me without me. We don't share any information about the family unless the family's present. So I would hope that that reporter could be included as part of the safety network. So I would hope it would not be normal, but it wouldn't be unusual to have adequate information from a reporter to go ahead and proceed to have a conversation with a family, and you might not need to check back with the reporter because they provided a lot of really good information. And information about the reporter is confidential. So engaging that in a way would need to be especially if it's a teacher or the family needs to be engaged in that. We're not able to disclose reporter information. I know some dynamics are the reporter says, I'm going to need to report this. So sometimes there's that, but we also do not disclose reporter information.
Right, no, and I agree with that, like, that should be confidential, but just doing the full investigation would require, even, especially if it's a teacher, I would think you would talk to the teachers and the school counselors as a part of the investigation anyway, and then maybe a follow-up with the reporter, but.
Yeah, and thank you for the question. There could be added value to that. Yes, I agree.
Thank you very much, committee. We are going to take a recess until 12:30. Lunch is being provided by the Children's Advocacy Centers of Kansas. Thank you very much. We'll reconvene at 12:30. May I have your attention? It is 12:30. It's actually 12:34. We are going to reconvene. I know we have some people who have not quite made it back into the chamber. We are going to start with Secretary Howard. It's on.
Good afternoon.
Yep,
Thank
Secretary
you.
Howard, before you begin.
Yes.
I neglected to make sure that we approve the minutes. Do we have a quorum yet? Natalie?
I just wanted to make, before a motion is made, I just wanted to let you know that there is a small technical change that needs to be made. Just needed to add a staff member that was erroneously left off. So I don't know if someone can make a motion to do that. Do we need to just say who it is?
You found the technical change? You found the technical change. Thank you so much, Judy. Okay, committee, do I hear a motion that we approve the minutes as amended by the technical change? Thank you for that motion, Representative Johnson. All in favor say aye. Second. Oh, we need a second. Second by Representative Senator Erickson. And all in favor say aye.
Aye.
Opposed? It's been approved. Thank you for being with us, Secretary.
Thank you, Madam Chair, members of the committee. It's a pleasure to be with you today. I'm going to give just the kind of a regular DCF update in terms of child welfare. So I'll have some slides that are kind of some regular by the number slides that you're used to seeing. And then we have a few new data slides based on some additional data that the committee has requested. I think there's some data you'd like to see quarterly, some of that from the agency. I would say in advance that a few of the new pieces of data, we weren't able to get all of them quarterly this first time, but we certainly will be able to going into the upcoming meetings to make sure you have what you need. I also want to give an update on House Bill 2075 that passed last session, particularly as it relates to the 24/7 operations with DCF as we get ready to kick that off in just a few weeks, and then just some general foster care updates. So, Madam Chair, I'll start with some of the regular by the number slides that you're used to seeing. In terms of on page 4 of the slides, the number of children in foster care. Again, this just goes through, this doesn't have the last quarter of the year. We'll have that and when we meet the next time. We're at about 5,600 as of March 30th, and we'll see where we land in the year. Again, continuing to see kind of a modest decline in the number of youth in care. The next slide on page 5 is where we really try to compare the number of children entering and exiting foster care across the years. And as you can see, starting in 2020, each year we've had more exits than entries. And then also, Deputy Secretary Keyes in her presentation, she showed, the significant reductions in terms of the need for foster care, in terms of the number of youth entering care. You can see that represented on the blue on the chart. And again, for the current fiscal year, we don't have the last quarter of data yet. We'll have that the next time that you meet. And again, I think on in terms of the front end, obviously, much of the work that we've tried to do and that you've supported so well around the opportunities for prevention and diversion from care have had a significant impact. And we're also looking forward to some of the impact, for example, from House Bill 2075 in terms of, timely permanencies and things like that as we think about exit from care. In terms of the primary reason for children entering care, nothing really different from the last time that you met. Again, looking at just the broad categories, really for the last 3 years, we've had about just over 60% of children entering foster care as a result of abuse or neglect, and just under 40% a family in need of assessment, those families that need services, but we don't have issues of abuse or neglect. That's been pretty consistent the last 3 years. In the next section, I have just some additional quarterly data that you requested. The first on page 8, and we've presented this before, but maybe in some different ways, kind of how the case came to DCF. On the first, and we do have quarterly data here, so what we've provided is the last quarter for 2024, the first quarter for 2025. At the top of the page, in terms of requests for removal, you can see that for abuse neglect cases in the last quarter of 2024, and almost the same numbers in the first quarter of 2025, 64% and 63% of the requests for removal for abuse and neglect came from DCF. About 35 or 36% were non-DCF, again, which could be a county or district attorney or through law enforcement. On Finney, you can see that numbers are a little bit different in terms of, for example, in the last quarter of 2024, about 48% of the FINAs were requested from DCF, about 51% were not, and it was about 60-40 in the first quarter of 2025. We also have a new chart at the bottom of the page that talks about removals with and without police protective custody. You talked about this a little bit earlier today as well. And so as you can see that data as well, pretty consistent across the 2 quarters. About 2/3 of the abuse neglect cases, there was some police protective custody before removal. In both of the quarters. In the FINA cases, it was really about around half of the cases where there was some police protective custody. And I think as we look at some of this data, it can seem a little bit confusing in the context of police protective custody versus who made a request for removal. But for example, a child could be in police protective custody, and during that time frame, DCF may go ahead, for example, and be, have a team decision-making meeting, be looking at that situation, and may make a determination from there that they want to make a request for removal. So, I'm just trying to make the point that obviously not every situation where there's police protective custody does that mean that the request wasn't made by DCF for removal. So again, a lot of things can happen during that time period, or a county attorney could look at the details and go ahead and proceed with the request for removal. So again, just maybe a new way to look at data we've talked about quite a bit in the past. You also asked for some additional details around average length of stay. We have a chart on page 9 that talks about the average length of stay by really the case plan, and these are exit cohorts. So for example, if you look at the top half of the page, that's the last quarter of 2024. Out of 698 youth who exited care, we look at the very top line, for example, 199 were adoption. That the average age of that adoption was 7, although the ages range from 1 to 17. The average months in care for youth who exited due to adoption was 43 months in care. And I won't go through each of these lines, but then, for example, if you look down at reunification, the largest reason for permanency and exit from care, in the last quarter of 2024, there were 363 reunifications, average age of 9, and there the average months were 11 months. So again, much longer lengths of stay as it would relate to adoption than, for example, reunification. And you can see, the emancipation numbers for those youth who would age out, again, fairly lengthy number of months in care. A little less for those children who go to a custodianship or guardianship. And then we've just added the sole family numbers on here as well. You can see we had 3 sole family permanencies in the last quarter of 2024. We had 7 sole family permanencies in the first quarter of 2025. The next slide that I have has to do with what preventative services were provided. So we wanted to give you some details on the number of referrals for our 2 primary areas of prevention. for children who are at risk of entry into foster care, which are family preservation and family first services. I know we tend to talk more about the family first services, so we wanted to add some slides as well about family preservation. So in terms of family preservation, providing those services in home, you can see the blue bar is the last quarter of 2024. The yellow bar is the first quarter of 2025. So you can see we had almost 375 referrals the last quarter of 2024, just under 400 in 2025. And then you can see the number of those referrals actually served. That relates to whether the family engaged, those sorts of things. But, it's really important then to look at, what were the outcomes? And so the next slide would show the degree to which children in our family preservation program who did not have a child referred to foster care during the period of those services or 30 days thereafter. And again, you can see those numbers for 2024 and 2025. We're at about 88% in our fiscal year to date. And we'd like to be at about 90%. But again, over the years, and we've had family preservation for a while, we've tended to be in like the 87 to 92% rate in terms of children being maintained safely at home who otherwise were at risk of foster care. The next couple of pages I think you're pretty familiar with. We talk a lot about the family first services, but again, in the context of your question about what preventive services were provided. And this is one where we didn't get this by quarters yet, but we'll start doing that next time. Since Family First started, we've had 7,000 referrals to Family First. On the left side of slide 12, you can see the breakdown by region. About a quarter of those in the Wichita region, 17% in Kansas City, 17% Southwest, and you can see the remainder of the numbers. In terms of the service type, just over a third were a variety of mental health services. Just under a third were parent skill building, like Healthy Families America. Then you can also see other prevention services, substance use, some of the legal services through kinship navigation. And as we've talked many times on the Family First, we feel very good about the outcome in terms of the percentage of the target children and youth who've reached 12 months from the time of service who remain together at home without the need for foster care. Our goal is 90%, and through this entire period of time now, we're at 90%. So, there's some other goals there that we continue to work to improve in terms of engagement in timely services, in terms of successful completion of the service, but in terms of the outcome, in terms of prevention of the need for foster care, we continue to be at 90%. So again, when you think about those numbers of the number of youth entering care, and you think of just with Family First, that we've referred about 1,000 children a year to Family First, and 90% of those have not had the need for foster care, you can really see, since those were youth at risk of, at high risk of going into foster care, what the impact has been of having those front-end services, as was talked about this morning. So critical to see that. Another new item that we were asked to just provide some basic data on had to do with the average cost per child per month in foster care, and that's on page 14. I might first say that foster care is part of the consensus caseload process. So those of you who connect to the budget committees know a lot about that process, but the consensus caseload process is a process whereby representatives from the Division of the Budget, Legislative Research, and the agencies meet twice a year to talk about what the estimated costs will be for certain, entitlement programs. So Medicaid, TANF, foster care is included within that. So those numbers come out. Those are provided to the legislature, and then are typically, adopted in terms of the budget for the year. when we think about the costs in foster care, there's 3 different costs that make up the total. And before I get into the actual numbers, the first are the case management costs to our case management providers. And so that's really about the cost for their staff. It's the monthly payments we make to them for their actual case management work, plus any incentives or penalties that they might earn. The second cost, and the highest cost, are the placement costs, the actual costs for the placements of those children, whether those are, the costs for children in family foster care, so that daily rate for a family foster care home, or if they're in group care, or if they are in, another level of care. So the placement costs, and then there's a small amount of just some other foster care monthly costs that have been included in caseload. Those would be things like home studies for adoption, some of the funding that you added in to help us support the development of therapeutic foster homes, funding to maintain our care match system. So a few miscellaneous things that, tend to be $1 million or less in that category. So what we've provided on this chart then is 3 years of costs. And then we've tried to then attach that to a monthly cost per child. So you can see the monthly cost per child in 2024 was about $4,200, up to just over $5,000 in 2025 and 2026, as we awarded new case management contracts. And a lot of that increase had to do with, as we've talked with this committee about quite a bit, the changes in the staffing requirements in terms of the staffing ratios. In terms of just seeing then the actual total dollars broken into those 3 categories, you can see case management costs ranging from $10.4 million to $13.5 million over the 3 years. And then you can see the placement costs in the realm of around $14 million each year. And then again, as I said, those other foster care costs. So that just gives you a sense of kind of how to parse that together. But if we try to think about it, just the cost per child, as we stand here today, is about $5,000 a month per child. Again, broken into those categories of the case management costs, the actual placement costs, and a few other miscellaneous costs. And again, these are estimated, again, and within the consensus caseload process by folks from the executive branch and legislative branch staff and the agencies to reach a consensus number.
Madam Secretary, as always, you bring us so much information, which we appreciate, but I'd like to give a moment to pause and ask if there are any questions up to this point. Representative Humphreys.
Just about the cost, did you break that down? What is SGF and what is all funds or federal funds?
It's not on this chart, but we can do that easily for you. I mean, it ends up being about 2/3 state costs and about 1/3 federal costs, our budget. So, because the 4E funds that come in for foster care, I mean, not every child qualifies as a 4E child. So, but it tends to be 2/3, 1/3 for the aggregate budget. But we can provide you those details.
And if I may, one more. So the Family First Prevention Services, the number of cases serviced and closed successfully, it was 49%, but the goal's 95. I mean, it's a metric that really was, quite short of the goal. And so do you know why? I mean, can you explain a little bit about why that's 49% so low compared to the goal?
Yeah, thank you for the question, Representative. And I probably need a little bit more detail with me to go into the specifics, which I could provide you, I think, a one-page chart that would do that. Because on Family First, we actually have these detailed outcomes by each service and each provider. And we have a full evaluation that the University of Kansas does for us. So my recollection as I stand here today is that there are some services where the numbers are quite high in meeting the goals, and then there are a few services that they have not. And so we continue to work on that. But let me bring that back, the details in terms of where we've fallen short in terms of that completion of the services, because it's not every service in the program. I mean, some have been more successfully completed than others.
Thank you. Thank you, Madam Chair.
Senator Falscato.
Thank you, Madam Chair. Thank you, Secretary Howard. So the funds that you just shared are explanation of funding for those in foster care. So, so does that same amount of money per child go into, like, for grandparents or kinship or other caregivers that might be that extended family or friend, you know, within like the sole legislation that it passed? So are they getting the same for that child or not? Thank you, Madam Chair.
Yeah, thank you for the question, Senator. I appreciate that question because we've worked really hard over the last 3 or 4 years to improve the payment amounts for relative care. And so we had increased those significantly for relative care, and then more recently with the opportunity to do, federally to do, you know, kind of an alternative licensing path for relatives. For those relatives who choose to be licensed, they would receive the same rates. So again, we're very close on the relatives, whether at this point, whether they're licensed or not licensed. And that's been a real goal, because as you know, we worked very hard to be a state where you know, our goal really has been to get to 50% in kinship care, and we're there in a couple regions, and we're close in some others.
I have a question on the slide that previous to this one. Please tell me what I'm making sure I'm understanding this correctly. So when it says monthly cost per child, so you're taking case management costs per month, placement costs per month, other foster care monthly costs, what would those be?
Yeah, the other foster care monthly costs, Senator, thank you for the question. Those are just an array of costs that are built into the caseload. They include things like we have some maintenance costs, for example, for the care match system that we maintain that is used to do placements for foster care. It includes the costs of doing adoption home studies for youth who are being considered for adoption. It includes the costs of the standby bed network that we initiated a few years ago to reduce our failure to place, and some of the additional funding, for example, that the legislature supported to help us further develop therapeutic foster homes. So it's very specific costs, and then in the caseload process, there's discussion about whether or not those should be included in caseload or treated separately. So again, it's an array of just miscellaneous costs that don't fit neatly into the case management contract or into the monthly placement costs.
So that would be my next question, which with case management, who does these visits that you mentioned that fall under, if not the caseload manager?
Well, some of that would be connected to work that the case management agency is doing that they might have case management costs for. But for example, when I say the standby bed network, you know, where we're providing, you know, payments, for example, to homes to hold beds to support youth. We didn't include those as placement costs per se because there's not necessarily a child in that bed. So it's really more how we've categorized it, wanting to keep things very clean in terms of those categories. And again, those are a small number of just miscellaneous costs that are detailed out in the caseload process, Senator.
And we can see that somewhere in the budget, is that right?
Yes, and you can see that when caseloads are done, those are detailed out for you. Yeah.
So then when we add those costs, the bottom three, then it's divided among the number of youth that are in the foster care program, and that's how we're coming up with the monthly cost per child. Am I right about that?
Yes, that's correct, Senator.
Okay, thank you. Representative Howerton.
Thank you, Madam Chair. So does that include like services that we provide for these children, or is that a different category as well?
No, it would include services, so.
So
yeah.
counseling, therapies,
Well,
different things like
if
that?
things are, let me caveat that, Representative. There are services that would be provided to the youth through the Medicaid program that would not be reflected as part of the foster care budget, so.
Okay, just making sure I was really clear on that. And then if you could look at slide number, page 9, I think your totals may be a little off on that last line. It's not normal for your agency to, but it says like maximum days is 16,912, minimum days 776, and then the average months is 174 for the total on the 2025 quarter one.
We'll take a look at that. We had some issues with this slide, and we actually submitted a new one, but because it had some of the. Yeah, so I think you might be right on those totals might be wrong.
Okay, I just wanted to make
Yep,
sure I was interpreting that
No,
right.
I think you're right. I think you're right.
Okay,
So,
thank you.
yeah, I had some other issues, and I think we didn't catch that one. So we'll provide a revised one for you. Sorry about that.
I saw the same thing, and I attributed it to the fact that it was just totaling the columns. That doesn't really tell us much, but it's just totaling the columns. But I do notice, like, for example, under emancipation, looks like that there was somebody who was in foster care for 17 years. 6,224 days.
Yeah, in terms of the maximum days, yeah, and, and I think one of the goals I certainly hope with the SOUL program is not that every child who ages out of the system would necessarily be a good fit for that, but those are areas where if there's reasons why adoption isn't happening or guardianship or custodianship isn't happening, that we can have a different option. So.
And do we have data on things like that? Do we have data on, this person was in foster care for 17 years, why were they never adopted? Why were they never put into permanency? Do we have that kind of data?
We would have to look at the individual circumstance, individual case to identify that. Yeah.
And then the other question that I had was, back when we were talking about preventative services, and I remember we had quite the discussion about that before, about how much that would save the state and keep children from having to go into foster care, helping families, et cetera. Maybe I'm missing it here, but can you point out the slides that show that that was a good investment, that we do have fewer students or fewer young people that are in foster care based upon the investment into preventive services?
I mean, I think what we can show you, Senator, is I think in the last slide that was in Deputy Secretary Key's testimony, and then say on page 5 of my testimony, when we just show the number of children entering care, where we've gone from about 4,200 youth entering care in 2018 down to 2,500 last year. So you think about that, about 1,700 fewer kids a year entering care. And, talked about, how much, that's not all due to prevention. I mean, but we certainly know then when we look at the prevention data for both Family First and Family Pres, youth have to be at kind of imminent risk or high risk of going into foster care to qualify for those services. 90% of the youth who got both of those services, or close to 90%, didn't come into care. So I put those two numbers together to show that, to say, if we had not had those services, and I'm not saying that 90% would necessarily have come into care, but a significant proportion would have, because these aren't front end prevention services. These are at the cusp of foster care prevention services. So that's how I would answer that, Senator. Looking at the total number of reductions in the number of youth coming into care and coupling that with very good outcomes from Family Pres and Family First in terms of children being maintained at home.
And maybe they have more data on that, but as we all know, scientific method, there are multiple variables.
Yes.
And yes, we have fewer that are coming into care. Could be multiple reasons for that. But then what I would like to see would be a side-by-side comparison to say, we had this many youngsters that were referred to that program. It cost the state X amount of dollars. we have reduced the number of youngsters coming in by this number, or that number reduced, not necessarily we did that, but a number was reduced, that if those young people would have cost the state X, and then at least we would have some notion of a nominal amount
Sure.
as compared to, again, I think we all know that the trauma that's caused from a child being taken from the home. And I'm not referring to that cost, but I am referring to the cost for preventive services compared to having children in services. So some kind of a side-by-side, I think, would be extremely helpful.
Sure, we'll see what we can put together, Senator, because I think in some ways you're talking about what was the cost of the preventive services and what were the costs avoided, for those youth, if they had come into care, what would those financial costs have been? I mean, obviously, we all understand the trauma. I understand what you're asking, Senator. I think we tend to talk about those separately, but we'll see what we can do in terms of putting together something side by side.
Thank you. Committee, other questions up to this point? Yes, Representative Howerton.
Thank you. So I'm looking at the slide that she was looking at on page 5, and this year goes through March 30th, correct?
Yes, this slide does,
And so
yeah.
this is the first quarter of 2025, and we're almost to what we had removals for in 2024. So like projecting it out, am I interpreting this correctly? We have 3 more quarters with these numbers?
No, I'm sorry, Representative, this is through March 30th, so that's 3 quarters of the
Okay,
year.
that's
Yeah,
what
3 quarters
okay,
of the
thank
year,
you.
right.
I'm thinking
right.
January 1st, I'm
Right.
thinking accounting quarters, I apologize.
Right, no, you're
that's why I
you're
asked.
correct. And I think, our projection at this point would be, it will still probably be slightly less than last year. I don't think dramatically less, but I think
Okay.
slightly less, so.
I was just thinking,
yeah.
we're coming on
Yeah.
September, October, where they said the highest removal. I'm like, oh my goodness.
Now, we've already experienced those months, but we haven't experienced an awful lot of permanencies get delayed until the school year ends. And so what we haven't seen is some of the things on the back end in terms of some of the youth leaving care that we'll be experiencing here shortly, so.
Thank you for the clarification.
Additional questions, committee, at this point? Seeing none, please continue. Thank you very much.
Thank you, Senator, I appreciate it. A couple more things, just in terms of specific data that your staff asked us to include at your request. On page 15, you asked how many families or youth received cognitive behavioral intervention, behavioral specialist services. For those of you who've been on the committee, you'll recall that we've talked about these behavior interventionist services for a while. I think you probably first heard about this through some of the work that Foster Adopt Connect had done as really a leader in behavior intervention. And then a year or so ago, maybe a little bit longer now, we actually applied for a Medicaid state plan amendment, and we became the only state to offer these behavior intervention services through our Medicaid program. So the program is slowly growing. You can see we served about 32 youth in the program in the last quarter of 2024, first quarter of 2025. We've included a map for you so you can see the different agencies that are currently providing that. And Foster Adopt Connect, ADECA, and Ember Hope are using the same behavior interventionist model, which is Foster Adopt Connect's model. And then KVC is also providing services, and they're using a slightly different model related to registered behavior technicians and a parent empowerment program. But again, the program is continuing to expand. We continue to expect those numbers to continue to grow. I would like to see a little more expansion to the west in terms of availability. That's often the case when we begin to look at this and begin to see the programs. So you can see the services primarily in the Wichita, KC region, and Southeast region. You also asked for a little bit of information related to foster home makeup and placements in foster care. So on slide 16, just included some information in terms of overall licensed foster homes. It's been around 2,200. We show you that for 3 quarters. You can see that The vast majority of those are family foster homes. A few are what we would call non-related kin. And then the relative numbers listed here are for those relative homes that have chosen to undergo full licensure, so that we have a whole other array of relative homes on top of this. Just under half of our homes serve children of all ages. We have some homes, in addition to that, then, who might only serve, say, teenagers, or might only want to serve younger children, but almost half serve all ages. I would say on page 17, we do go through a process during the licensing process, and then as child placing agencies go through the sponsorship process with families, where there's a lot of information that's gathered about the preference of those foster homes. So you can see that the sorts of things, the preferred capacity, they want to serve one foster child, 2 foster children, are there age preferences or gender preferences? Is this a family that's interested in therapeutic foster care? Maybe experience relating to, human trafficking. And then you can see the same thing as it relates to kind of behavioral concerns in the middle of the page, or foster homes who might feel that they're equipped to serve youth with IDD needs or certain medical needs. So again, there's a lot that goes on through that process that, again, begins to identify what those preferences are to really help with placement. The last thing on the general foster care I just wanted to show was just kind of a basic list of the levels of care within our foster care program. And remember, in our foster care program, in foster care in Kansas, about 92% of kids are in a family-based setting. So this chart on page 18 wouldn't include kids who are in a PRTF or a QRTP, but this would be the kids in a family-based setting. And again, you can see that breakout. There's kind of a whole screening tool to get to what the levels of care are based on the needs of the child. But you can see that the highest numbers of youth are in the basic level 1 care, but it can go higher based on different needs. So again, there's a lot of detail underneath that we could talk about if you wanted to. But we're actually doing some work with our providers right now, just looking at that level of care and how we assess that and assign that. The other thing I wanted to talk about specifically related to foster homes, and I'll have a little bit more in my presentation later, had to do with the therapeutic family foster homes. You very generously provided us. We had actually added this as an option 2 or 3 years ago, and then you very generously, through the appropriations process a couple years ago, gave us $6 million to help to actually develop and grow that. And I'm really pleased to say that as of May 1st, we now have 90 therapeutic foster homes with a capacity for 180 kids. We have those are sponsored, you can see, through 6 different child placing agencies. DECA has 36 of those, TFI 21, and you can see the other numbers there. And you can see the counties where those are. The largest number of therapeutic foster homes is actually in Sedgwick County in Wichita, with just almost half of the homes there. So again, this is continuing to grow. I'll say a little bit more about that on a later slide, but we're very excited to see that growth. The next thing I wanted to talk about, Madam Chair, just has to do with House Bill 2075. And as you recall, that bill started out as kind of a permanency bill in terms of, we introduced it from DCF in terms of increasing the frequency of permanency hearings. And so that bill passed. And in addition to those pieces, which we're very excited about in terms of the reduction of the time period for the first permanency hearing to be within 9 months of removal, and then the hearings thereafter to be 6 months, there was also provisions put in related to issues around police protective custody. I mean, 2 pieces of that. One, a bit more on law enforcement that I think relates to some of the earlier conversation today, really requiring additional steps from law enforcement to explore other options that they might have to separate the child from the source of harm before taking them into custody. But then more relevant for today was the requirements that DCF provide a means of communication for the responding law enforcement agency to refer a child who may be a victim of abuse or neglect. And then when the secretary would receive those referrals, to initiate an investigation within 24 hours and make contact with persons who are the subjects of the investigation. And then with 24 hours of that contact, the secretary would respond to the referring law enforcement agency. What that means practically, because we've not been a 7-day-a-week agency, what that practically means is that starting July 1, DCF will initiate contact with families every day of the week, including Saturdays, Sundays, and holidays, when there's a report from a law enforcement officer about a child in a family who might be a victim of abuse or neglect. So that contact with the family will happen within 24 hours. We'll then make a response to the reporting law enforcement agency within 24 hours of our contact with the family. As in current practice, if law enforcement requests that we hold off on contacting a family, we wouldn't do that until law enforcement gave us further guidance. And if it requires a joint investigation based on the alleged circumstance, we'll coordinate that with law enforcement in terms of the best way. So again, what that practically means is we will begin initiating that contact every day, kind of like the graphic we put on the following page. I mean, in terms of what we think this means. I mean, here for children and families every day of every week. Really opportunities for positive impact on Kansas kids and families. We'd initiate the child and family well-being assessment, initial or immediate safety planning, reinforcing connections with family supports, preventing the need for foster care, and initiating resource or service referrals. And we know some of our partners may not have 7-day-a-week access, but we would do that. It's not really in here, but I have to say, this has been a very, very extensive process since the session ended to get us prepared to begin to do this July 1. There's a lot of policy pieces. Obviously, there's a lot of staffing pieces. It's a real culture change, obviously, within the agency. So we're doing a lot of things on the staffing side. In some regions, we gave opportunities for individuals who might want to have an alternative kind of a work week, like you might see in other realms in law enforcement or healthcare, where maybe they want to work, Tuesday through Saturday, or maybe they want to work, 4 10-hour days and includes a weekend. So we've had volunteers who are very interested in doing that, and that works with their life cycle to work on a weekend perhaps and not do that. In those circumstances where we don't have that, staff will be on various rotations to have those weekend hours on their schedule. So again, we are ready. The first time that this will impact us will be that July 3rd holiday weekend, and we are ready and we'll be staffed and ready to go. So we're excited about that. But it has been a lot of work in the last couple of months. I was kind of glad your session ended early. We had a little bit more lead time. So again, and we have had conversations with law enforcement. We've talked certainly with Mr. Klump and others, and at the local level, our local staff are also having conversations with law enforcement agencies out there as well. So,
Madam Secretary, if I may, I think I could speak for Representative Howerton. We were pleased to carry that bill in both houses, and that our fellow legislators voted for it, and also for the support from law enforcement that this all the way around would be better for kids. Thank you for bringing that to us. Please continue.
Yeah, thank you. Thank you for your support. I just have a few other updates. I know we're getting tight on time. The first, just in terms of some general updates, Executive Order 2501 is an executive order that Governor Kelly signed back in January that required that DCF can discontinue its prior practice of reimbursing the state using benefits that youth in foster care receive from Social Security disability or other benefits that really belong to the youth. This has been a growing trend across the country. The governor did an executive order. So we have, no funds have been reimbursed to DCF from benefit monies since January 1. We have been setting up ABLE accounts for qualifying youth. There's 520 ABLE accounts set up right now, and so far that's conserved about $1.2 million for children and youth in custody that will be available to them when they leave custody. Now, we'll begin to have notices going out about this on July 1. The first notice that will go out will be when DCF becomes the representative payee of a child's benefit. We'll also send out notices when an ABLE account's been established and it needs to be transferred because the child has reached permanency. And then just each year, there'll be an accounting of the benefits received and saved for each child. You know, a really, really important part of this is going to be the educational component of it because, I mean, as youth age out of care and as they have these benefits in these ABLE accounts, they need to understand how these accounts function. The people in their lives need to understand that. And so we've been really, really pleased. We've had great support from the State Treasurer's Office and from Treasurer Johnson, and also from the Kansas Council on Developmental Disabilities, who's actually funding a contract with the Kansas Council for Economic Education to help develop the kind of training and education that was kind of required in the executive order. So we're excited about that because that's just going to be really, really important in terms of, you know, effective management of those resources. So
I think we have a couple of questions up to this point, so I'm going to take a pause. Senator Falscato. Oh, okay. We were discussing, I will ask the question. So on this page that we just talked about, could you give an example of reimbursing the state for the cost of foster care from benefits received by the youth due to their own disability? And then you were saying notifications of the accounts, to whom does that go? Those are the two questions.
Thank you. Thank you for the questions. So the first question, so for many, many years, if a child in foster care qualified for, I'm going to say Social Security disability or survivor benefits, you know, like because their parent died, states used that funding to offset the cost of foster care. So it went in a fee fund, and then, you know, so we would use, you know, state funds for foster care, federal funds for foster care, and we would use those children's benefits. Then a few years ago, you know, what are called ABLE accounts came about, first federally, and then Kansas was one of the first state to adopt those. And those are really funds that are designed to, you know, to preserve benefits. We're not just talking about foster youth, we're talking about any youth, like any youth with a disability, that allows them to have earnings and not lose their federal benefits. So they're allowed to put these funds in ABLE accounts, whereas before, if you had more than $2,000 in earnings, I mean, don't think foster care, right? I just think generally, you would lose your qualification for those federal benefits. So when those rules all changed, you know, states slowly, I mean, it took some time for states to suddenly say, oh, wait a minute, we were kind of doing this in foster care because there really wasn't any way to preserve the money for the kids because it would just have gone away. So we used it to pay off, but now you can preserve the money, so that's better for kids, and let's do that. So that's where the funding comes from. I mean, as I said in the past, we've essentially have just taken that funding, offset the state's cost of foster care. This new policy would preserve those funds so those youth maintain those benefit funds. In terms of who would get the notice, you know, it depends on the circumstance, right? In the sense of, you know, so say a child ages out of care, I mean, the child would receive the notices while they're in care. Whoever the guardian is, the foster parent might receive it, and adoptive placement might receive the notices. Depends on the circumstance of the child who all would receive those notices each year. So
these funds are not intermingled. These funds are specific to the child and put into an ABLE account specific to that child's name, correct?
That's how it is now. That's correct. They are set up in specific accounts. Those belong to the child. And during their time in care, in most cases, DCF would be the representative payee. In some cases, that might not be the case if there's something else that makes sense. Because there are some items that while a youth is in care might qualify as a good expenditure. Maybe the child is trying to pursue some certain, thinking about a certain career path and they need certain equipment or different things like that. I mean, there are reasons why you could spend some of it, but what this would not do anymore is just offsetting the cost of care. So,
Thank you. Additional questions, committee? Thank you very much. Please continue.
thank you. I will try to close up here with just a handful of other ones. I said I would, collaborations with law enforcement. And we were just talking about that in the context of 2075. But, we've continued to try to expand our outreach to law enforcement, and our one of my staff who is kind of our Medicaid and children's mental health specialist in DCF recently attended the Chief of Police Conference in Mulvane and represented DCF at that event. And we're really pleased. We'd put together some informational advisor cards for law enforcement. It has the 4 questions on it. It has information about 988, and it has the phone number for our Family Mobile Crisis Helpline. So we were able to provide those advisor cards to law enforcement. We had heard from law enforcement that was kind of the best thing that they like in terms of having in their vehicles. And so it was a very, very good, very, very well received, and really became kind of an opportunity for our regional leadership to then engage more directly with their local law enforcement. So again, we're excited just about the law enforcement partnerships in general. Therapeutic foster homes, I kind of already mentioned this. We had awarded those capacity building contracts, received an innovative mix of service delivery options, and there's at least 1 home available in each DCF region. KVC will probably talk about their Mockingbird model if they have a chance to today, which they just launched with 2 family constellations. They just had the kickoff for that. And then we even have a prevention part of the therapeutic foster care where Cornerstones has worked with some family preservation families, assisting with issues such as school assistance, bullying concerns, and providing some respite. So again, we're excited. 90 therapeutic foster homes approved, a capacity of 180 right now. The SOUL program update, again, during the first year, 10 young people have achieved permanency with the SOUL Family Legal Permanency Custodian, and we're excited about that. That was in 4 different DCF regions. 4 of those occurred with the family who'd been the young person's only placement. 7 of the young people achieved permanency with the family in their home county or an adjacent county, and 7 of the young people achieved permanency while being placed with a relative. So again, really excited to see how that program grows. Page 29, I think this was talked about this morning from Christopher in terms of the legal representation. You all had recommended to us a couple years ago that we pursue Title IV-E funding for legal representation. We have done that. We've taken advantage of that opportunity, and we've been in conversation with counties. Right now, we have 2 counties have been approved to begin claiming already, Douglas County and Norton County. We have 6 other counties that are in the process to begin claiming the $4E dollars July 1, and another 18 counties are in various stages of inquiry or considering whether they wish to participate. And again, it's not that it gives them a lot of funding. I think I included the same page on page 30 we had before. By the time you do all these calculations with 4E, if there was a service cost of $1,000, I mean, the county's still covering about $885, but that's still, if 10 or 11%, I mean, it grows and augments the budget for legal representation. So we're pleased to do that, and we're pleased that we should have 8 counties on board by July 1, and as I said, a number of others currently looking at it. Let's see, I'm almost finished here. Independent living program, just again, always want to put some focus on the work that we're doing around older youth. we've been doing some additional work with our independent living staff to, just really increase their engagement skills with our staff. And then also, we continue to take advantage of some of the federal housing vouchers for young people who've experienced foster care. And the federal program, FYI, is available in a number of counties you can see on that page. And then there's also housing vouchers for former foster youth available that are not federally funded in Kansas City and Douglas County. So again, continuing to work in that arena. Crossover youth practice model, the work through Georgetown, Shawnee, Montgomery, and Sedgwick County have fully implemented the model and are working towards their sustainability plans. And so, again, glad to see that continuing. A couple of other things, a whole families pilot. Even though I manage both protective services and benefits programs in DCF, one of the things we found, not too different from like folks getting out of prison, that sometimes when families were having their children reintegrated, they were having issues getting timely access back to their to DCF benefits. And so we have a new collaboration around that to make sure there's no lapses in benefits for families who do qualify for EES programs. So we put some processes in place. One more, I wanted to mention that I just feel really proud of the work people are doing. This is a concentrated foster care prevention program that started as a pilot in Kansas City. We began to experience, and I think you might have heard this from us or some of our partners, that we had families who maybe had youth who had gone into an acute psychiatric facility or into a psychiatric residential treatment facility, and when the child's treatment was done, they didn't feel equipped to take that child home. And we had some kids come into custody, for that service need. And I've never felt that, we don't have anything magic when they come into custody, right? So what we've done here is DECA, who provides family preservation services, they're assisting our child protection specialists when they meet with parents or caregivers who might be reluctant to take their child home from an acute inpatient visit or from a PRTF visit. And so DECA can then go in and work with those families and prevent entry into the foster care system for a youth who the family is just worried or scared about bringing that child home or afraid that they may not have the resources or supports they need to support that high needs child. So that's been very successful. KVC had done an earlier pilot related to this as well. So we're now making plans to implement this throughout the state. We certainly don't want youth to have to come into care because their families don't feel equipped to provide for their mental health supports. So last page, again, just references, we continue to work on community collaboration. I was thinking about this morning when we talk about front-end services. We can talk about those prevention services like Family First and Family Pres that are like right at the cusp of foster care. But the more we can move further and further to the front end. So we continue to work hard in all of our regions, whether it's, this page just happens to highlight Wichita, various things going on there, the careforeveryfamily.org, which is kind of a faith-based initiative about how to meet the needs of families. Our family resource centers that we have funded across the state, our school-based partnerships where in Emporia, Hutchinson, and Wichita, we have funded kind of school liaisons where there's not an issue of abuse or neglect, they can help with concrete supports for families or relational supports. So again, we continue to try to think outside of just the structure of foster care, but to say, what does it really mean to support families and to partner with communities, that it doesn't always have to be about the state, right? So that's all I have. Thank you.
Okay, thank you, Madam Secretary. So questions, committee? I have one. On slide 8, if you go back there, can you possibly, with a little ease, break that out into abuse versus neglect? Is that possible?
We'll see what we can do.
That would be amazing.
Okay.
Yeah, just
Okay.
see the,
We'll
just
what
to
we
see
can
the
do.
difference and compare the difference. Okay, Madam Chair.
Thank you.
Additional questions, committee? Representative Humphreys.
Since thank you, since Representative Howerton went back, I also have a go-back question. My question has to do with she did good finding the number, the preventative, the family pres. This is kind of like slides 10 and 11 and 12, that kind of, all of those 13. My question is, one of them, you know, like on 12, you talk about referrals. Family First referrals, 6,969. Who made those referrals?
DCF.
Made them to your Family First providers?
Yes.
Okay, so the question, and we've asked this before, is, I just would love an update. Some of the family preservation services, my question is, why does DCF have to be the one to refer family preservation services when maybe a neighbor who's getting services, you know, is having a great outcome? Do they have to go through DCF when they see that maybe they might be in need too? Or how can we kind of provide more services to more families and not have to go through DCF?
Yeah, thank you. It's a great question and something we really support, right? Family First has been complicated federally for us because we really would like to do community-based referrals. We have more flexibility on the family preservation side. That's our program, right? So we've done some different kinds of innovative things. I mean, for example, in the Kansas City region, I think it was on, Tanya will kick me if I'm wrong, but on family preservation, for example, we allowed our family preservation provider to get referrals directly a couple years ago. So Family First has been more problematic. I mean, just in terms of being able to technically find the pathway to do that. I think we'd still like to keep working on that because I would agree with you. I mean, and I would love to have, you know, those be able to come through a lot of different pathways. So, yeah.
You know, maybe in future meetings, that could be on your list.
Yeah, we can talk to you more about that and some of the ideas there.
Okay, and then just another, just since you mentioned technical, and it made me think of, what about what is going on, like with the, I think you have in the middle of an RFP for the family finding and even just, again, you know, upgrading the whole system, the technology. I didn't hear you mention that, so if we could just get an update on all of those things.
Yeah, thank you for the question, Representative. On the CWIS, the Comprehensive Child Welfare Information System, I really am saying something different than I did the last time, even though it probably doesn't sound like it, because we literally are very close to being able to sign. You know, I mean, there had to be, I think, a last federal review, and then I think that's what we're waiting on, and then we are ready on that. I shouldn't say this because Tanya will kick me on this too, but I would be shocked if we didn't have that by the time we see you all again, and we'll make sure we notify you. On the family finding, we are kind of caught up in sort of some of the new KESA reviews that were that the legislature put in place about a year ago. And I was trying not to have that program have to go through that, but the determination was made at OITS that it did fit the criteria for that. And so we're still trying to work through some of those pieces so that we can get the RFP out. So that's where we're at on that one. That's where that is. But again, we should have the word on CWIS, and I hope to have the word on this one too in terms of getting it on the street as well. So.
Okay, just to make sure I understand, maybe everyone else too. So it has to do more with like some of the security things that we put in place, or is that in?
That's correct, Representative,
okay.
yes. And there was kind of a whole new process that was put in place for IT projects to go through before you could put an RFP out. I don't think it's the only project that's been caught up in that delay. I just had hoped that it would be exempt from it. So, and it ended up not being exempt from it. So that's been the issue there.
Okay, thank you. Thank you, Madam Chair.
Representative Reese.
Thank you, Madam Chair. Thank you, Secretary. And along the veins of what Representative Humphries was talking about being able to have the direct referral, community referrals, and, you know, and just seeing how many of the referrals for abuse and neglect are coming from schools. I just wonder if there could be a project maybe, you know, where there could be a school that could be chosen to be able to work, you know, a school that's got professionals, you know, mental health professionals already working within the school to see if maybe that could be something that could be worked out.
Yeah, we'll look into that, Representative. I think, yeah, certainly a number of schools have the mental health professionals, and as I said, we also have, you know, our own contractual relationships in 3 school districts now related to, you know, special school liaisons connected to supporting families, so.
Thank you, Madam Chair.
Representative Esau.
Thank you, Madam Chair. My first one's sort of a two-part, and I've been trying to figure out how to word it. We changed how quickly the permanency hearings are supposed to happen, and I realize that might take a little bit to get the courts moving faster, et cetera. Do we have any idea if it started to make a difference yet, or how long that might take to get everybody on board with that?
Yeah, I mean, thank you for the question, Representative. It actually doesn't go into effect until July 1. So I think I'll probably have more to report on the next meeting in terms of what our experience ends up being, so.
Okay. Then my follow-up to it's not really a question, it's just something I'll be looking for is if we end up with hiccups, what can we do to fix it? Because I realize it's not just you and, you know, it's all the various parts of how we make that happen. My other one isn't quite related to that, and I've been trying to figure out how to ask it, but you're part of where I need to ask. When we have supervised visits with agencies, supervising visits, et cetera, are those supervised visits ones where there is actually someone in the room supervising? Or is there supervised visits where they simply provide a place and no one's in the room watching the interaction that's going on?
Let me ask my Deputy Secretary, if you don't mind, Representative. I put you on the spot, Tanya. Did you get the question? Or? Yeah.
I think so. Yeah, thank you for the question. As I understand it, there could be both. There could be locations where it's family time, family interaction time. Someone could be just present, but not in the room, but present in the building to assist as needed with that family time. Or it could be a circumstance where a person is present in the room with the family time going on. Did that answer your question? I might not have understood the question well.
You did understand it. I wonder if there's any standards of what would require supervised visit of actually somebody being physically there because of concerns versus ones where we just need to provide a place because otherwise they wouldn't be able to have that supervised visit. And if you don't have that answer on the spot, I understand. I just wonder if there's actually some definition or something concrete so that it doesn't come down to how somebody thinks things are going.
Thank you for the question. Certainly, some colleagues from our partners could help answer. One distinguishing factor might be a court order, that they are supervised in person. So that could be an attribute that contributes to family time, having a person actually with them in the room. That's one factor. Another factor could be wanting to see how family time is going, and if you're coaching or helping out with different times or development or some coaching issues, that person could also be in a role of coaching, modeling, affirming good things going on during family time. So there could be some different factors, but I think one distinguishing factor is if they are if and until they are no longer court ordered.
Seeing no other questions, thank you so much.
Thank you.
Committee, we are going to move to our next conferees, and that would be the Family Preservation and Case Management Provider Updates. We're going to start with Cornerstones of Care.
Good afternoon. Chair Gossage, Vice Chair Howerton, Ranking Minority Member Faust-Godot. My name is Justin Horton. I am the Chief Programs and Innovation Officer for Cornerstones of Care. So just to clarify, that means I oversee all of our programmatic offerings, 28 different programs across Kansas and Missouri. And the innovation part of my job title is I lead our strategic planning processes for the organization. We had a new face in the room today, but I know there's a couple new members on the committee. So just a reminder, we've been providing services in Kansas since 1999. We have 7 physical offices with about 250 team members, and we support citizens in 49 counties. To create a connection for you all, part of my page 1 is always sort of who we are, and I talk about we're certified as a trauma-informed agency. You saw our friend from Casey, Christopher, talk about adverse childhood experiences and ACEs. That study is actually the foundation of our trauma-informed care model through the Sanctuary Institute. So they took that study and continued the research forward and built a whole model around how you support kids and adults who have had adverse childhood experiences. And that's what the additional layer in this work that we take with our team members and work with them on and get certified every 3 years in. And we have our recertification coming up next month, actually, from peers from around the country. Page 2 just gives you a depiction of where we do our services and how busy we are with those services depending on the county. I'll transition to page 3 and talk about family preservation, not to be confused with Families First, but Family Preservation Services. We are the provider in the northeast part of the state in 9 counties, and also the southeast part of the state in 16 counties. Those are 2 distinct separate contracts that we do reporting on for the state. That center visual is a picture of our 3x5 card. I provided Patty, our lobbyist, with additional copies if anybody needs any of those handouts to provide to their constituents. Some data at the bottom of page 3. You see information on number of families served. Now, that's not number of referrals, because typically a case can be open 4, 5, 6 months with the family. So during that first quarter of the calendar year, January through March 2025, we served 113 families in the Northeast and 109 in the Southeast. Some data points about keeping families safely together, because that is the goal, keep them together, but keep them together safely. Successful case closure, the goal is 85% that's established in our contract, and we were able to do that at rates of 90% and 88% in those regions, respectively. And importantly, families served who did not have children placed in foster care, and that is a measure that continues post-case closure to see if those kids remained in the home. That's a goal of 90% that's established by the state, and we were successful at 98% and 95%. Are our clients pleased with the service that we provide them? That's the last 2 data points. We do our own client satisfaction survey results proactively. And get historically responses that are above 85 to 90% satisfaction with the service. And lastly, no service recipient constituent grievances received. So you've heard me say it every time, Kansas has really good family preservation providers across the state, and it's a service that really works well. Page 4, as we adapt our testimony to some of the things that the committee asked for last time. What are our program and our family struggling with today, need help with today? So I just engaged my team members and took their unvarnished thoughts and sort of organized them here. So I don't think anything on this list on page 4 is going to be too surprising or new to committee members, but really it's things that factor into safety and risk contributors or detractors, depending on how you look at it, and then access and capacity to services and treatment. So just highlighting a few. Obviously, affordable housing, whether it's a wait list or maybe shelters are full, that is a stressor for our families. Access to mental health services, which you've heard about a lot, wait lists. Employment, but tying that to childcare. You see childcare on a couple places here. If you don't have childcare or good childcare, that can be a barrier to employment, but also specifically those who want or need to work second and third shift. You can't always find childcare in those non-bankers hours that could support you in your employment endeavors. Transportation, whether that's a lack of public transportation or just a lack of transportation, obviously can impact getting to childcare, getting to employment. Services for children with significant developmental needs. Waivers for children with physical disabilities, developmental disabilities can be years. I give you one case example in there about a 10-year-old boy who had a terminal illness. The family was not able to get funding for a shower lift. The father injured himself while trying to bathe the child. So just some real life circumstances that sometimes when we talk about barriers, that's how they play out. Risk or fear of losing SNAP, Medicaid, WIC. This is not an intentional lightning rod issue on a popular topic, but this was what was provided to me in an unvarnished way. It is a fear factor for our families, and just understanding how they're going to take care of their kids, keep their kids healthy, and be able to feed their children. And lastly, mentoring programs for kids. Sometimes just having a safe, caring adult that's in your life outside of your immediate family. There's not a whole lot of options for mentors as our staff try and find that with the families that they're working with. Transitioning to page 5 with foster care case management. Again, you see a snapshot of our 3x5 card on how to contact us, and we have copies of that. As of the end of Q1 calendar year, we had 449 kids that we were caring for in foster care case management. Some Area 5 data, because that's where we provide our services, is Area 5, Wyandotte, Leavenworth, and Atchison. Page 6, so there was a question as we adapted from the committee meeting last time, number of children initially placed with relatives or kinship of those who entered care. So we had 32 entries, and 76% were placed with someone that they know, right? So if we don't want kids in foster care and we know that's traumatic, then the best we can do from there is place them with someone that they know, and we were able to do that 76% of the time with an established sort of federal goal of 50% on that. Sole permanencies, as the Secretary touched on, we didn't have any, unfortunately, in Q1. We're discussing the topic actively with 30 youth, but when you distill that down to those who might be interested and providers who might be interested in it, we're actively working on 8 as of Q1 for sole. Some interest from this committee about permanency decisions and how those decisions are sort of stratified. I think sometimes there's a perception we're pro-foster parent, we're anti-foster parent, we're pro-relative, anti-kinship. We just outlined that stratification for you that of the permanencies we had, other than reintegration, 7 were adopted by their foster parent, 1 by an out-of-state relative, 4 by an in-state relative, 3 reached custodianship or guardianship with an in-state relative, and then a few emancipations, either independent or with a relative. So a fairly broad stratification, I think. Moving over to page 7, similar line of thought as I wrap up. What's the foster care program our family's struggling with today, need help with today? I could have made a longer list, but it's sort of synthesized into 2 categories. So as Deputy Secretary talked about, FINA, where a youth is entering care, there's a number of outcomes of FINA, but the 2 that we focused on were mental health or juvenile justice support. So children entering custody to access mental health services. The Secretary talked about the PRTF situation. Sometimes, we're not talking about dozens and hundreds of kids in our area, but sometimes kids have come into care who need PRTF because they think maybe if they're in foster care, they can access a PRTF bed quicker than not being in foster care, which would be a bit of a misnomer. We heard testimony earlier today from our friend at Casey that entering foster care itself can be a traumatic experience with potential long-term negative effects on mental health. He called it ambiguous trauma. So, we're just pro community-based services because they can offer a more stable, supportive environment, minimizing the risk of trauma. As someone who's from a small town in Kansas and spent most of their life in Kansas, I think there's a pride and sense of community in taking care of our own, whether you're in Andover or Mulvane or Basel or wherever you're at. We like to take care of our communities. So if you can find community-based approaches, it offers benefits such as reducing stigma, promoting inclusion, strengthening social support, early intervention, fostering a sense of belonging. Entering foster care, you lose that control and where you're going to be and how you're going to be there. So truancy leading to custody entry, we routinely have kids who are 17 and a half entering foster care solely due to truancy. So I will marry that with sort of offender behaviors. Not that those 2 things go hand in hand, but if you're truant, you might have offender behaviors. It's that theme of, as a parent of an 18-year-old and a 22-year-old, I'm not abusing or neglecting my child, but they won't go to school, and they stole a car. Those kids come into care at 16, 17. We had one come into care a month before his 18th birthday. I don't know that foster care has this magic wand that's automatically going to help that youth just before their 18th birthday sort of remedy some of those behaviors. So every state needs a restorative juvenile justice system that will hold youth accountable for their actions, protect the community, and provide opportunities for rehabilitation and reintegration. Second theme is lack of beds for high-need youth. So beds for acute mental health stay. You know, when you think of office sleepers, those kids who are actively needing an acute care bed for treatment, if you don't have that and placements are saying no, what do you do with those kids? And then beds for youth with intellectual and developmental disabilities. I can think of 3 youth today out of our 450-ish that really monopolize and dominate our time because they are lower functioning, they are lower IQ, autistic, they don't really understand and be able to equate their behaviors to the consequences like running away and aggression. So those are the kids that monopolize the caseworker's time. Those are the kids that are physically aggressive and unfortunately tend to languish in the system because the foster care system's not perfectly situated to help serve those kids to swift reintegration or adoption. Lastly, wanted to talk about some things that are going well, and in a strengths-based way, Secretary Howard stole my thunder, but I will reiterate her concentrated foster care prevention slide. We're really excited about that work in partnership with DECA and DCF and KBC, and just helping those kids who were supposed to be discharging out of PRTF, and the parents are just scared about what their next step is. Bringing all of your professional service providers together to brainstorm for those youth has been really powerful. And the Secretary mentioned whole families, which is exciting. And lastly, we are using the Iowa 4 questions in our court reports, and that's been received well from our court partners. I will stop.
Thank you very much. Questions, committee? I have one for you. And by the way, I appreciate that card.
Yeah.
And I have a few of those. I'd like to get more. Where we have, trying to understand, you have number of families served, 113 and then 109, number of children in those families, 236 and 350. And then you go on to state successful case closures, et cetera. So are all of those children then currently placed in foster homes that you're
So
serving?
I believe you're referencing the chart on page 3.
I
Am
am.
accurate? So that is strictly for family preservation.
Family
So they're
preservation
together.
only.
Yeah, so it's a depiction of.
These are families that you're working with?
That's right. Yep.
Okay. Do we have, you heard the question because you were in the room when I asked Secretary earlier, if we could get an estimation on family preservation, how much does that cost per child? I know that vastly varies, but if we could get some kind of an idea, and then how long do you serve these families typically? 3
Yeah.
months, 10 months, 4 years? That would be very helpful to the committee.
Would it be most helpful to you to have it broken down by child or by family unit?
I would say by child, since the information they gave us was by child.
Sure. A typical case sustains 6 months, and if the family needs and it's warranted to go beyond 6 months, there can be a re-referral by DCF so we can keep the case going a little bit longer. We want to intervene in whatever amount of time makes sense for that family. So we are okay with DCF's approval at closing a case at 2 or 3 months or 4 months, but typically it's going to be in that 4 to 6 month range. But yes, I will come back in a future meeting with hard data.
Additional questions, committee? Yes. Representative Howell.
Thank you, Madam Chair. Justin, I just want to tell you thank you so much for this report, and I really like the format and the information you provided, and both the assessment of the needs and things that are going well, and just the layout in general. I know at the last meeting that we had, we talked about some of the things we were interested in.
Give yourself a kudos.
This
Yeah,
is a
that's right.
great start. This is a great start. I'm very excited to hear from the rest of you. So, even though, we all know in this room that there's a lot of challenges. We all know this, but having it laid out like this is really helpful. And this is just, I'm impressed. And this is really helpful. And having it laid out like this, especially by region and like this rural area, more rural area and everything, is just also I think this is just help us assess things in a simpler, more efficient manner. So this is wonderful. Thank you.
First time for all of us, right? So I think certainly I can do a better job next time of, there's quick wins and then there's long-term systemic changes. And I think we can start to hone in on where we have quick wins and then where it's going to take a lot of investment and you won't see the payoff for a little bit. But thank you.
Thank you very much. And next we'll go to DCCCA. No pressure.
I was thinking that exactly. Thanks a lot. Good afternoon, Chair Gossage and members of the committee. My name is Jeanette Owens, and I'm the Chief Child Welfare Officer at DECA, and I appreciate getting the time to speak with you today about our services. I will just share up front, it does not mimic his report, but we will work on it. So I really wanted today to just spend a little bit of time giving you updates on numbers since when we met in March, and then really focus on some family preservation updates and that concentrated family preservation pilot that has been spoken about earlier today. For our child placement agency, since March, we've gone down just about 4 homes and increased 11 children in those homes, though. And for the state of Kansas, I think it's important to note we've increased 21 homes since when we met in March. And so that's a trend we hope will continue because it had been going the other way for quite a while. One of our large increases in therapeutic foster care has been talked about a couple of times today, but I want to really share the excitement of where Kansas is at with this program and having that many homes available for some of the highest need kids that are in foster care. Since we met in March, DECA's increased 10 more therapeutic foster homes, so today we're at 38 homes. And we've been able to then, since March, place 10 more long-term children in those homes and then 9 short-term respites in those homes. Next, I'll cover our We Can Drive updates since March, and we've been able to have 77 more youth drivers be enrolled in driver's education since then, and we've purchased 19 auto insurances for kids, and then we've had 25 more youth actually obtain some sort of driver's license since March. So we're really excited about this program. We just completed an RFP response to continue the program. Overall, years ago, I was sitting in this committee or behind talking about what this could bring, and to watch the number of youth it has impacted has been fantastic. Now I'm going to skip down to our family preservation services. We currently today have 248 active cases, and so average for us is about 115 per region. And so we're a little higher right now than our average per region, and we're not surprised by that because in May, oftentimes there's additional referrals, and we often have a higher amount of active cases, and then it reduces back over the summer. As we're nearing the end of our first year of this current grant for family preservation, we really reflected back over the year. And one of the things we consistently heard from our staff was the gratefulness of the adjusting system. We see Kansas moving, and we see those adjustments in family preservation. So one change that we've really seen is it's becoming more regular for us to get a family preservation referral when we're working with a family whose children have been safety planned out of the home, and we're working with that family to help get that child reintegrated back or moved back into that family in a quicker response. And sometimes that's a day, sometimes that's a week, and sometimes it's a couple of months. But that is not something that we used to see regularly in family preservation. Another change that we're seeing more often is working with families that have at least one child that's in out-of-home placement and one child still remaining in the home. And so this has brought a lot of collaboration between providers and partners and visitations to make sure that we're serving the kids in the home, the kids out of the home, and the family without overwhelming with all of the interactions. We really welcome these new opportunities and the expanded services that are happening for families. Another opportunity for expanded services that I really would like to finish today talking about is the new pilot that Secretary Howard mentioned, and then also was just mentioned again of this collaboration within family preservation. And so in January, Deputy Secretary Keyes reached out to a group of leaders across Kansas and said, what could this look like? And so as that group of partners came together and really went through, how do we support parents who have children that have either been in a PRTF for a short period of time, for months, or acute residential or acute hospital, that are saying, that kid can't return here. How do we support them? How do we do things differently where that child doesn't have to experience foster care? And so as a group, one of the things that we first looked at is, what are those parents' concerns? And often it was safety. And so they were potentially scared for other children in the home. They were potentially scared for that child and what they may do. And they were scared oftentimes for their own safety. One mom particularly had shared with me at the beginning of this pilot that she locks her bedroom every night. And she truly believes that if she didn't, that she wouldn't be safe. Another area that we knew that parents had shared with us was that they thought that their child might receive better services in foster care. And so I'm really grateful for Cornerstones of Care and KBC, who spent a lot of time writing up myths about foster care and ways for us to be able to explain to families and to providers outside of that direct interaction of what foster care may do to children that don't need to necessarily be in that, and how then we can provide those services without them entering foster care. So we were able to develop that pilot, and it included system navigation so we could help those parents receive services quicker. It involves behavioral interventionists where we can assign them same day as referral. Those behavioral interventionists can come alongside those parents for 15 hours a week and give them a minute to either decompress or to feel like the child's covered and they can work with other children. It also allowed us to provide in-home therapy, again, immediately. We worked with our providers and said, we may get a referral this morning, the child may be discharged today, we need to be in the home tonight. We also have provided parent peer support in those homes where we can just come alongside the parents and help them realize they can do this too, and here's some tools to help them through that. And then as a part of our therapeutic foster grant that was mentioned, we now have the ability to do prevention stability placements. So if what we've had happen in this pilot is we've had some families that say we need to see a step down before a step into our home. And so we're able to safely take that child from discharge, and actually truly DECA comes and picks them up from discharge at the PRTF or the acute and can drive them to a stability placement and have that foster family work with them over a couple of days. We've had one that was 2 days and we've had one that's been going on for a couple of weeks, and hopefully then working to successfully transition them back into their home. So this is a small number of kids. We expected 1 to 3 referrals a week. As this has grown, last week we received 4 referrals. So it has gone faster than we've expected. Our 4 referrals last week ranged from the age of 14 to 17 and a half, and behaviors ranged from self-harm, daily drug use, running away behavior, threatening and attempting harm on others, and inappropriate sexualized behaviors. So to date, each of these have been successful in us being able to continue to work with this child not having to go into foster care, except for our very first referral that happened before we had the referral form complete. So we're going to continue to have that one there, but that child did come into foster care, and we're continuing to monitor that process as well. So we look forward to the statewide implementation of this. We believe that it will continue to impact kids and families. And with that, I will share my appreciation for all that you guys are doing with the committee and stand for questions.
Any questions, committee? Seeing none, we will move on to Ember Hope Connections. Oh, we have one. Representative Howell.
Just really quickly, I'll say I really like your report too. And
Thank you.
So I just wanted to state that very clearly. And I just want to say I have I have some lived experience with this need in my past. And I I am very excited about this. This would have meant the world to my family. And so I am very excited to see this. And I think that this is probably the tip of the iceberg. And we're going to find a lot more need for this probably moving forward. So I hope our capacity for workers is great out there and we will find them quickly. But I am very grateful to all of you for doing this work, and I am excited for this moving forward.
I appreciate that. Thank you. And we do have a flyer for that program, so I'll leave that up here if anybody's interested in giving us feedback on that. Thank you.
Thank you. Next, we'll have Brenda with Ember Hope Connections.
Good afternoon, everybody. Chair Gossage, Vice Chair Howerton, members of the Joint Committee of Child Welfare System Oversight, thanks for the opportunity to speak with you today. I feel intimidated that the first two reports have gone 2 for 2, so hopefully this will be 3 for 3. But we did take your notes and we did combine those and agreed upon exactly how we would present testimony today, or attempt to present testimony the way you want it today. We did choose to focus on a period, a time frame of January, February, and March of 2025. So for us, that would be the most recent quarter that we've completed, that we've got data from. So the numbers that I'm giving will reflect those dates of January, February, and March. From January 1, 25 through March 31, 25, we served 942 unique families in Sedgwick County. We served 1,770 children during this same time frame. That does include the period of aftercare, which is 6 months after a child goes home. We have experienced, since the contract started in fiscal year 25, July the 1st, so quarter 1 of the fiscal year through quarter 3 of the current fiscal year, a 3.5% increase. So we are not a county that is seeing a decrease overall in terms of child welfare need and in terms of children coming into custody. In terms of the number of youth initially placed with kinship and relatives for the time frame I mentioned, we received 153 new referrals. 58 of those youth were placed in relative or kinship homes as their initial placement. While that only represents 38% for that time frame, for the fiscal year, we are running at 49.33% as of March 31st. So we're right at that 50% mark and are continuing to increase numbers. The number of missing children that we were asked to report on for the entire quarter, we had 5 youth that were missing from care in all 3 months. 2 males, 3 females, and they were all ages 16 or 17. We continue to diligently search for those youth. The number of youth reintegrated during the time frame was 47, and of those 47, 78.7% were reintegrated with the custodial parent, so that would have been the parent that the child was initially removed from, and 21.3% were reintegrated with the non-custodial parent, so that was the parent that the child did not reside with. For the period under review, the number of children adopted was 23, and it's almost a 50-50 split for us between adoption by foster parents at 47.8% and children adopted by a relative at 47.8%. 9 of the relative adoptions were by grandparents. We only had 1 child that was adopted by an adopt-only family, and that represented 4%. Placement stability, since starting the contract on July the 1st, we've definitely made progress toward outcomes, but we still experience the highest numbers for failure to place in the state. What we have seen, we started high, we kind of leveled off, and now we're starting to peak again. And I'll be talking about that a little bit later on in my testimony. As far as moves per 1,000 days, with the goal being, or the benchmark being 4.44, we're at 6.8, so we are running higher than the goal required in the Children's Rights Settlement Agreement. For children that are experiencing 4.44 moves or less, it is 55.8% of children, so a little bit higher than half. Sole permanency, we're pleased to announce we just had our first sole permanency that we completed. We've got 4 with a dual case plan goal with sole right now, and we've got all of the procedures in place. We've got the process figured out, and we're rocking and rolling with this now, so we're real proud of that. As far as how many youth spend the night in the office, and, it's just such a tough topic to talk about. For us, from January 1 through March 31, we had 15 unique youth spend at least one night in the office, and the total number of instances during that time frame was 43. The children who have experienced one or more nights in the office range in age from 6 to 18 years old. And one trend that we're seeing that we don't like anyone staying the night in the office, but 53% are 12 or younger. And so we're starting to see a decrease in the age of children that we're not able to place. Through May 28, we had experienced 312 total nights instances of failure to place, which represents 97% for the state. I brought up our 6-year-old at the last hearing, and just to provide an update, in regard to his placement, when we talk about whether or not we do have a placement crisis and whether or not we do have enough capacity, that individual youth, again, is 6 years old, has spent 112 days in care. Of those 112 days in care, 48 nights overnight in my office and 40 nights acute in the hospital. And most likely will be in my office again tonight. And we have elevated this issue with KDADS, with KDHE, as well as with DCF to get assistance with this young man. As far as referrals go, we received 45 new referrals in January, 41 in February, and 72 in March. So our numbers just can continue to trend upward. Certainly, we are very worried at this point about some of the trending that we are seeing. And the trend that we're seeing in the last few weeks, we've seen a steep increase in bouncing youth. And bouncing youth is what we refer to as those night-to-night youth. We typically range from 30 to 40 youth in unstable placement daily, but the last couple of weeks, there have been nearly 60 youth bouncing in Sedgwick County. This is the highest it's been for us since the contract started. We have seen a decline in both foster homes and facility options for children. Several facilities have been put on admission holds or have had to decrease their service level. In the summer, we tend to see a decline in foster homes taking youth due to not having schools' additional support or just wanting to take a break, which has been more significant this year. We also see a trend of higher acuity youth in a younger age range, which can be challenging to locate placement for, as they tend not to be candidates for congregate care or need to be placed in a home with no younger children due to sexualized behaviors or aggression. New referrals and emergency referrals have also increased in the last few weeks, which does not leave us much time to locate a long-term placement. We are concerned that the placement crisis is worsening across the state, most significantly in Sedgwick County. I will echo our other CMPs, some of the things that they're worried about, reading their testimony. I would echo staffing overall, the lack, again, of social work professionals in the field. I would echo an extreme concern about staff and child safety. This continues to be an issue. I echo the rise in the cost of liability insurance as something that will have to be taken into consideration in the current contracts, and also to the mental health wait list and just being able to access mental health services effectively for children who need those services, as well as the continued wait list for the PRTFs throughout the state. And one solution that we made for ourselves was to open our own youth residential center in Goddard. It's an 18-bed facility. Due to staffing issues, our current census is 5. And we are doing 6 to 8 respites there per night. Otherwise, our failure to place numbers would be an additional 6 to 8 on top of the numbers that I just gave you. We're excited about a potential partnership with TFI and working collaboratively with our other CMP partners. How do we build capacity? How do we help one another? We're excited to meet with DECA and see how we can start piloting the pilot in Sedgwick County to really be able to implement that family pres model coming out of a PRTF. I think that will be wildly effective. And to end on a positive note, I want to do that as well. We are seeing a lot of early success with our Hope Unified for Belonging team. This is our team that's working with high acuity youth and helping them to get to long-term placement. We also have achieved a lot of early efficacy with our crossover team, and we have seen several of those youth come off of probation. That's our team that works with duly adjudicated youth. And we celebrate 57 youth who have graduated from high school this month. I'm happy to stand for questions.
Questions committee. Yes. Senator Falscato.
Yeah.
The last part. Oh, that's much better, Madam Chair. Well, thank you for ending on a positive note, and I commend you for that. So, 2 quick questions, Madam Chair. Are you working with a foster adopt connection there in Wichita? Are you collaborating with them? That's one question. I know they've got a ribbon cutting coming up. I'm going to go to, anyway, there. But so when you talk about the need for social workers, could you please elaborate on that again? You said the lack of, or could you elaborate? Thank you.
Sure. I'll answer your first question first. And yes, we have fully implemented Foster Adopt Connect's behavioral interventionist model. And Ember Hope Youthville, who's my sister agency, they are a recipient of the Therapeutic Family Foster Home Grant. We have several homes as well. Our homes have the benefit of having the behavior interventionist model in the home, working with the children up to 15 hours a week in order to support the placement. And so that's going well for us. We continue to try to increase capacity for TFFH homes as well. As far as your second question, I know Crystal Hedrick with Children's Alliance will be providing the testimony. But overall for us, we had, I think, 83 eligible direct care positions And of those 83 positions, I think we had 6 that are actually licensed workers. So I think our percentage came out to 6% overall. And just looking at it for the other CMPs, it's pretty comparable. So I think overall, we're probably looking at as, you know, a child welfare workforce 10% or less.
Representative Humphreys.
Thank you, Madam Chair. One super quick question. You use the term in here, an adopt-only family. There was one of them that represented 4%. What's an adopt-only family? I'm not familiar with that term.
So that is for a child without an identified resource or resources. And so the Kansas Adoption Exchange, children who are looking for a resource for a permanent family, then those children are available for adoption. And so it may be a family unknown to the child at the time that we start working towards adoption with that family if it's a good fit.
Okay, so sort of like Susan's kids, or like someone that is adoptable but doesn't have an adoption resource? Okay, got it. Okay, thank you. And then I'm curious about your statistic about your new referrals. 38% of them went to relative or kinship home. And then, you know, later, of all of your out-of-home children that are placed out of home, a little over 49% are placed with relatives or kinship. So I'm just curious, how did that come about from 38 to 49, or that 49, did they start out with kinship, or did you find kinship later? You know, because as you know, sort of I have a definite preference of kinship at the beginning, and then once they're attached, you know, kind of let them stay where they're attached. But so just any extra information. I mean, of course, I love kinship at the beginning. So, yeah.
Yeah, I would say for us, a struggle that we've noticed is that we don't always get the information needed when we get the referral. We don't always get the names of the relatives. We don't always get the completed genograms. And so in some instances, we may be starting from ground zero. I believe that that impacts the percentage. Now, what we're doing as an agency, we're contracted with the National Institute for Permanent Family Connectedness, and we have a 4-year contract with them, and they have provided training, ongoing training, consultation. If we've got a case we can't find a relative for, we consult with them, and they help us to think way outside the box. We're also using LexisNexis as a search engine to search really far and wide for any potential relative or kin for a family. We have 4 family finders on our staff, and I think that's why we see that the number eventually does go up, and will continue to go up, but I think we still need to do some work in that initial handoff.
Okay, and do you have any statistics or data on like when they get switched of that 49% that are with relatives? Can we find out when they were placed with relatives, maybe something like that? That would be great.
Yeah.
And then that family finding RFP that we're not getting, would that be helpful to you, or is that not something that would?
I think we're already doing it.
Okay.
But it could be something additional to what we're doing currently. But we knew bidding on this contract, I mean, Kansas is a kin first state, and we wanted to be a kin first, you know, case management provider. So we really invested on the front end with our proposal.
Okay. My last question, Madam Chair. So when you're talking about the problem of the kids who bounce from place to place, and so Representative Howerton and I had a great time with Pyxis, that they really are trying to deal with those kids that bounce. And have you found them to be a good resource? I mean, what if, and we haven't had them present, well, not in a long time. They have before, but not in a while to this committee. So just thoughts on that, because we both were quite positive about their program. So any thoughts on that?
Yeah, we love them, and they're great partners. Their struggle right now, they have the facilities, they don't have the staff. It's back to this staffing problem that it is very difficult to find high-quality staff who have the knowledge, skills, and tools to be successful with these youth and to want to endure what a typical day may look like, working with some of these kids. And so really for them, they've never done residential work. And so we are willing and able to provide some technical assistance to them to get them through the front door for some kind of residential model, because what they do right now is unlicensed day services. We would love to see them become a licensed something. And we are working with DCF and talking about pilots and where are the opportunities and what might we be able to do. So we're kind of in design phase, I guess is what I would say.
Thank you. All right, thanks for being here.
Yep,
Madam
thank
Chair.
you.
Additional questions, committee. Representative Howerton.
Thank you. Just to follow up, I was going to mention that, and anything we can do to assist in moving that process along with Pyxis, I think that is a real need, especially in Sedgwick County. Yep. And for those of you, the committee, they work one-on-one with kids or two-on-one or maybe four-on-one, depending on the kids, but it is very intensive work. And their goal, what they explained to us, is it's not going to be long term, but it's stabilization and maybe medication or whatever is needed for those children to get them into a normal foster care. So it's that in-between work that we don't really have a plan for. It's a gap, right, that we have that needs to be addressed. And my question to you is on the moves, on the numbers that you presented, how did you count those? Is that the moves since they've come into your care? Does it count? Because Sedgwick County is very siloed in the fact that we have the Wichita Children's Home, and there can be several moves in that transition before they even get to the 72-hour court hearing, correct?
Right.
And so I'm just trying to figure, do the numbers you gave me count Wichita Children's Home, and then if they're referred from there to another foster home, or if they're referred to JIAC before they even get, I mean, you don't even know about this, right? You don't even know about them yet. So I'm just trying to figure out, where does your counting start?
Yeah, I know I will need to get you an answer and follow up with you about that. But what I do know is I know that's one of the problems when we don't have a placement identified early and we have to send them to an emergency foster home. That's already going to count as one. When we find that relative, we find that kinship, we find a long-term placement, a family foster home that's going to be able to serve those kids. So that initial placement is so critical because it's already going to count one. And when you've got 4.44 in 1,000 days, if you're losing, and I can't tell you exactly how high the percentage is, but I'm going to say it's pretty high, and you're losing one right out the gate, that means you're playing with 3.44 more to go for 1,000 days, which is really hard to do.
And just to clarify, I mean, in 2024, the numbers that were given to the DA, or from the DA to me, was that 1,057 cases, not children, were placed in police protective custody, which went straight to the children's home, and then DCF was notified. And of that, 299 were, became SYNC cases. And so there's that large number that DCF doesn't know about right off the bat, and you don't know about until DCF refers.
Correct.
So I'm just trying to figure out what those numbers actually mean with the removal, or with the moves.
Well, for us, it would be when the sync petition is filed, the child in need of care petition is filed, then that's when we're notified at the temporary custody hearing. We pick the children up initially. We hold them until such time we find a place for them to go, and that starts our clock with 1. Yep. Uh-huh.
Quick question from Senator Fausto.
Thank you, Madam Chair. So, Brenda, you mentioned that you're at an all-time high. I know that since July 1, your Amber Hope, so I believe you had the transfer of the children that were over at St. Francis come over, but you said you're at an all-time high of children in your space. What do you accredit that to? That school's out, parents are doing drugs more, neglect and abuse. What do you credit that to? Or do you also feel it's part of what we heard this morning from Christopher Church, the definition of a reason to remove children, and we're just removing them and putting them, and then you said that you don't know where family members are. Is that because the mother who gave birth to that child just won't tell you where her other family members are? So why is that increase there? Thank you, Madam Chair.
Yeah, I would say all those things are factors. I think especially when we transferred the contract originally, there were a high number of youth that were already experiencing failure to place and night to night. And if we look at the data historically and we look at it over the last 3 to 4 years, this problem has always been concentrated in Sedgwick County. And yet we have not yet addressed the why. Why is it more in Sedgwick County? And I've attempted to suggest that we have the most licensed capacity in Sedgwick County. We have the most providers. We have the most congregate care, the most foster families. But our percentage of our kids actually placed in Sedgwick County is less than 50%. And so, it becomes very difficult when the capacity that's right there is not available to us. And so I think it's put us in a position to go and find our own capacity, build our own capacity, create something that doesn't exist yet with our friend Pixis, or maybe partner with TFI on their space down in Wellington. And I do think summer, that spike, we'll see that a bit. And like I read in testimony, certainly foster families in the summer, they just want a break. The kids aren't going to school, so there's just a lot of things that probably are impacting that spike of what we're seeing right now. But that spike is like double.
Thank you so much.
You're welcome.
Committee, next we'll go to Linda Boss from KVC Kansas.
Good afternoon, Chair Gossage, Vice Chair Howerton, and members of the committee. My name is Linda Boss. I am president with KBC Kansas. As I've shared before, we've been in services for over 50 years. We have about 450 staff working on our case management, prevention, child placing agency, and outpatient services. Like the other CMPs who've testified, we're debuting our new format, so welcome feedback if there's something that you'd like to see differently. So the first data snapshot I will share, again, this is covering January through March of 2025, is the number of families served. We had 922 families served in out-of-home care, 367 in aftercare. So taking out the families who received both out-of-home and aftercare services during that same time period, just a little over 1,100 unique families served during that time period. Breaking that down by children, 1,493 children in out-of-home, 545 children in aftercare, 1,900 total children served between January and March of this year. We have not had any youth in the office during this quarter, and we haven't had any youth in the office since September of 2024. We had, of the number of children who were referred during this time period, which was 114, we had 59 youth placed initially with relatives. That comes out to be 52%, which is pretty consistent with our ongoing number of children placed with relatives or someone that they know is about 51% for us. And looking at the number of children who are missing from foster care, on average, we had 25 children missing from foster care during the months of January till March. On any given day, we have about 10 to 12 youth missing, which is about 1% of the children who were in foster care. And the number of unique youth who were missing for even one day during January through March was 44 unique youth. Looking at the number of children reintegrated during the first quarter of 2025, we had 106 youth reintegrated with their caregivers of removal. We had 18 youth who were adopted. And then looking at who, if they were not reintegrated and they were not adopted, how did they reach permanency from foster care? The next largest category was aging out of foster care, that we had 30 youth who aged out of foster care. We had 2 youth who reached permanency through SOL, 2 through custodianship, and 3 who left our care because of a change of venue. So they might still be in foster care, but their foster care case was moved to another venue outside of our area of coverage. Looking at placement stability, our Area 3, which covers Northeast Kansas, had 6.9 moves per 1,000 days. And our Area 6, which is Johnson County, Douglas County, had 7.2 moves per 1,000 days of care. One of the items that the committee asked for was if children achieved permanency in Kansas or in another state. So during this time period, 136 youth achieved permanency in the state of Kansas, and 25 youth achieved permanency outside of the state of Kansas. It was also asked how families can contact KBC if they have a concern or something positive to share. We try to start this right from their first contact and helping families understand how to navigate what can seem like a very complex system, getting in touch with anyone beyond their assigned worker. So when families start services and they meet with our assessment worker to gather information about their family, they give them a welcome packet. In that welcome packet has a letter from myself orienting them to the agency, who I am, that our goal is to reintegrate their child with them. It's our top priority. It has my contact information, and then attached that is a org chart for that office that they're being served by with a phone list, because we know it can be, we've all had this experience in life trying to get to the right person at the right time, and it can be very frustrating to navigate someone's website. So we try to make it clear on the website, but also give them a hard copy of who's in their office so they can see, oh, this is my case manager. That person is on this team, that's the supervisor, and that supervisor reports to this director. And so they know email, cell phone number, not just a general office line, but the direct cell phone number for the person that they can reach out to if needed. Also on our website, you'll see that in the hyperlink there, is a link to be able to look at that same staff directory through our website in case they don't have access to the handout that was given to them initially. And there's also a customer service phone number on there. And I know the Children's Alliance will be presenting testimony on the number of complaints during this time period. And those typically do come in through our customer service line, but they can also leave an inquiry through our website. To shift gears a little bit and talk about some positives, you heard Secretary Howard mention our Mockingbird project. We had our kickoff launch of that about 2 weeks ago. We do have both of our therapeutic foster home constellations up and going now. And so if you remember from previous testimony, there is a experienced foster family who we call the Hub Home, who's been fostering for some time, who has specialized training, and they support a network of foster homes in their area. They have 2 beds available for respite, and they also get the group together for naturally occurring social activities, building really a support system around foster families so that no one feels like they're doing that important service alone. So we launched that kickoff, and each of our hub homes is currently supporting 6 satellite foster homes, and they are supported by 2 behavioral interventionists that work directly with their satellite homes. And then in addition to that, looking at specialized populations of youth with significant behavioral health problems, we do have both of our teams now of intensive intervention teams up and going. We still have some open positions, but they're currently serving 4 youth. And if you remember, those teams work intensively with caregivers and youth to provide in-home behavioral intervention and case management services to help keep youth with significant needs in the home and stable in their placement. So I hope in future committee hearings to be able to provide you some data on how those 4 youth and additional youth who are being enrolled are doing. Another area to celebrate is our workforce. I know that's something that we come up frequently as CMPs and say we need help with workforce. Is an area of challenge. It is continues to be an area of challenge, but it is an area where we are excited about our current staff retention. We have had high retention for several fiscal years now. We are at 85% staff retention through March of this year, which is still well above the national average of 50 to 60%. And we are continue to be rated as high on Indeed's work well-being, which puts us in the top 1% of all employers. And I mentioned previously that we use Gallup to assess our staff engagement. And our next survey is going to launch on June 16th, which will give us very valuable information about how engaged our workforce is and the pieces that they might need of support that we can continue to adjust to make sure that our staff who we do hire not only are well-trained, but are also supported by the agency and in the work that they're doing, and that they will stay. I won't go through these specifically, but I did include a highlight of a foster family, Jennifer and Brad, and I also included a highlight of one of our kinship support staff. I always think it's nice to be able to put a family's picture and name, but Jennifer and Brad are doing really amazing work with biological families, making sure that kids don't lose their connection, even if they can't be placed with a relative, and making sure that when children do go home through reintegration or adoption, that they have their foster parents still in their life after that permanency happens, so that adults who love and care about them don't disappear. And then I also highlighted one of our staff members who just does a really great job with customer service. Where does KBC need support? I think probably a lot of the pieces that KBC highlighted in our testimony do mimic and represent what other CMPs have shared and will continue to share as well today. Staff safety concerns come up for us as well as the other CMPs. Some of that is around training and ongoing support, but some of it, despite having all of the training in the world, the incidents that come up with youth exceed the capacity of what our facility can possibly provide. A lot of the behaviors that we're seeing in the most critical youth are ones that would be served in an inpatient setting, and none of us as CMPs are operating inpatient settings as part of foster care. And so it does create safety concerns that we do our best to mitigate, but is an area that we want to have continued focus on, because everyone deserves to receive treatment and be safe, and everyone deserves to come to work and be safe. Also, just ongoing support for those youth who have those significant behaviors, because it's what their behaviors are telling us is that their treatment perhaps does not match the intensity of what they're needing, and they need it in a higher dosage or in a different location. They're communicating with us through their behaviors that some of their needs are not getting met in the way that they need to. So ways that this committee and the legislature in general can help, I listed on my last page of testimony some bullets that I know I've shared before, but wanted to take this opportunity to highlight them again. Prevention, prevention, prevention. Foster care doesn't usually make things better, even when it's done really, really well. It typically exacerbates a lot of the family's problems, and if we can do it through prevention and not have to separate children from their parents, it's always going to be best. Increased community-based mental health support. I've heard this from my colleagues. I know you've heard it from me before, but we have children on the PRTF wait list for months, sometimes on end. They're getting passed by because their needs are so complex. They require one-on-one from PRTF staff, two-on-one, sometimes three-on-one. And so those youth are being cared for in a residential facility or in a foster home, but those youth meet the criteria for a much higher level of care, and they deserve that higher level of care. And if it's not available, they deserve to have the closest thing to that provided to them in their placement location. And we shouldn't ask placement providers to care for the most critical youth with not having those resources in place. Also continuing to focus on barriers to education, especially enrollment of youth who are moving frequently. They oftentimes miss out on education and get further and further behind when they don't have stable placement. Encouraging utilization of relative and kinship placements for youth by narrowing the scope of disqualifying offenses to those that directly impact safety. We still have this come up as a barrier where potential caregivers are not able to provide care, and that can be because they have an offense from 20 or 30 years ago that didn't involve a safety-related issue, or they have a youth in their home who has a felony charge, who becomes an adult, and they continue to want them to live there, which is the right thing to do, but then they cannot take placement of foster youth. And so that is an area that legislation has been introduced previously that did not make it through, but we would like to see that come back in a future legislative hearing and be addressed again, and that would make it increase capacity for youth in care, especially those with significant behavioral health issues who have somebody who does want to care for them, and there isn't a safety concern related to that. And again, just continued focus on treatment at all levels, from outpatient to inpatient, for youth with very specific needs, whether that's IDD, co-occurring, substance use, mental health. We definitely know who are the children who are falling through the gaps of the system and where do we need more treatment capacity. And it's definitely youth with complex needs and making sure that the right services are available to them at the right time. And I will stand for questions.
Thank you, Linda. Very thorough. Committee questions for Linda today. Yep, Representative Humphrey.
Super quick. Your number on the number of kiddos that were placed with kinship first, you said 59, but I didn't know what percentage that was.
That's 52%.
52% of those that came in right then, 52. Okay.
Yes, 114 youth were referred, and so 52% were with kin.
Thank you.
Additional questions? Yes, Representative Johnson.
Thank you, Chair. I just want to thank KVC. Just after our last meeting, I referred something to them. Was amazed how quickly they were able to help us. And I feel good that they're responding so quickly, and we need to understand our people are listening. So thank you very much.
And thank you, Representative, for bringing that to my attention.
Yeah, you did excellent.
Thank you. Okay. Committee, next we're ready for St. Francis Ministries with Matt Stevens. Matt, welcome to committee.
Chair Gossage, Vice Chair Howerton, Ranking Member Falscado, thank you so much for the opportunity to be here. My name is Matt Stevens. I'm Vice President of Advocacy for St. Francis Ministries. Like my colleagues, we're taking a stab at a different approach as we move forward. So again, welcome the feedback if you have it, and we'll definitely be ready and able to stand for your questions. St. Francis provides the Family First Prevention Services, and through that work, we've served 90 families through FCT, with a 99.3% of those children being maintained at the home during that service. We also provide Seeking Safety, and we served 22 families with 37 children, and we have a maintained at-home success rate of 90%. And so we're keeping a lot of kids at home utilizing those two services. We also are the case management contractor for Area 1 and 2, and so on the first page, you'll see kind of the same map that you've been seeing now for years at this point of where we're providing services. Through that work, and on March 31st, 2025, we were serving 1,624 youth from 1,078 families. During the first quarter of this calendar year, we received 146 new referrals, of which 76 were initially placed at home, resulting in a 52.1% of those children initially placed with kinship. Permanency outcomes are broken down in this pie chart here, we continue to be very proud, and everybody in the state of Kansas should be proud. We have a very high reintegration rate from a permanency perspective, especially as it applies as we look across other states. So again, I think that's something that we're doing incredibly well. Through SOL, which again, we continue to utilize and appreciate that it was passed through the legislature. We finalized 3 such permanencies during the quarter or period under review. One of the questions really is around once permanency or adoption happens and it can't be reunification, how do we end up there? And so one of the things that I looked at was best interest staffings. And so this particular quarter, we had 10 best interest staffings, and I don't know exactly where they went. All I know for sure is they didn't move. So 10 of the 10 that we looked at remained in the placement to be adopted where they were. So we were not at the end of termination of parental rights moving those children. I think that really is, when I think about Representative Humphreys and some of the things that we've talked about throughout the years, I think that's a good indicator of where things are at. Missing and runaway youth, we had 8 youth that were missing or runaway on March 31st. Again, that's less than 1%. We continue to work diligently to find and return those children. How families can reach us, and so much like a lot of our colleagues, some version of an orientation packet that would have contact information for their team. In addition, our email signatures typically have their supervisor's contact information as well, as does voicemail. So if you call your worker, they're unavailable, they'll also tell you who their supervisor is so they can work through that. Our placement stability numbers are not where we want them to be. And so in Area 1, we're at 6.55 moves for 1,000 days of care, and in Area 2, it's 8.54. The challenges that I've identified, again, it's going to be similar to what you've heard from my colleagues, but really, I think the main challenges that we're experiencing here is going to be our workforce recruitment and retention, liability insurance issues, and then I'd say access to appropriate services for both prevention and reintegration. And so, again, I go a little bit more detail as I move down on here, but the workforce recruitment and retention, child welfare national turnover rates are very high. We also, I think the helping profession in general continues to struggle with hiring and maintaining the right level of employee. And it's not, one of the things that we'll talk about is licensed social workers. I think that's important, but also you've heard that we've got residential facilities that are operating way below capacity, and it's because of staffing issues. And generally, those folks are not licensed and maybe not even degreed. So I think it's the whole gamut of the workforce. I don't think it's necessarily just our licensed workers. We continue to struggle as a sector over the last several years with the rising liability insurance costs. And so that's, again, a nationwide issue that some of our kind of nationwide associations are taking a look at. We're looking at a little bit kind of internally, and I know all of us are continuing to be cognizant of the fact that while we are nonprofits and while we are here to serve families, ultimately we're also a business. And so how do we make sure that we can continue to operate by controlling costs? I'm more concerned, or very concerned, about kind of the smaller providers. Several states have seen lots of their capacity from a CPA perspective. CPAs will just close because they can't afford it, and that just leaves a lot of families in a bad situation. And really, it impacts the vulnerable families that we're trying to serve. And then last but not least, really the access to appropriate services. And so one of the things that we've talked about, and I think we've got to continue to acknowledge it, we've done a really good job of decreasing the number of kids in care. However, we continue to bring children in at a rate higher than in the national average. And so for me, what that tells me and what the barometer is that our prevention services and services available to families are not available. So eventually they end up being referred to foster care. One of the things I said in here is that the foster care system could be viewed as a barometer for how other systems like mental health, substance use treatment, and economic supports are functioning. And access to services, not foster care, should be the primary response for families in crisis. Foster care must be reserved for situations of immediate danger and not used as an alternative to juvenile justice, behavioral health, or substance use interventions. And so, again, we've talked about trauma, we've talked about all of the things, all the negative reasons, a little bit about the cost, all of the things that come with foster care, but ultimately, we're not a solution to these problems. We can help support when children are really in imminent danger, but that's when it should be utilized, not for access to other services. In addition to, it's been pointed out that we have kids who remain in care longer than other states too. And for us, what that tells me is when children get into care, they don't have access to the services they need. And so, again, the testimony you just heard from Linda Boss at KVC was there are kids on the PRTF wait list that have been on the PRTF wait list for far too long who continue to not have access to that level of service because all the PRTFs in Kansas are saying no. And so that means they are in offices or they are in foster homes that are ill-equipped and unable to manage those. Those kids end up bouncing, impacting our placement stability. So all of these things are definitely tied together. And so for me, it's going back to what capacity do we have inside of our system to ensure that our children can move to permanency as quick as possible. Some of our successes, we are working with KDADs to turn and convert some beds into a specialty PRTF, and I think that will be beneficial as we move forward. And we are later this year celebrating our 80th year as an organization providing hope and healing to children and families. So with that, I will stand for questions.
And you don't look a day over 70, Matt. That's incredible.
Thank you for that.
Questions, committee? Yes, Representative Howell.
Thank you, Madam Chair. And maybe this isn't, maybe you're not the appropriate person to ask. You can just tell me that. So, you know, I think that we may have a two-pronged problem. I know that without question, as you referenced, we definitely have families that are waiting to receive care, and you know, they're not being able to get care in a timely fashion for all kinds of care, including the PRTF. But sometimes we are giving them referral to care, and they're not necessarily willing to go get that care. That's another problem. I'm not sure that we're tracking that accurately or collecting that as a data point, like a refusal, for example, and that might be a question that's perhaps better asked of DCF, or I don't know if that's something that we try to track as a state. For parents to be refusing to do that, but.
So I don't know if this gets your answer, Chair, and thank you so much for the question, Representative, but at the individual and micro level, you know, that really is what our case managers are doing, is making sure that families are following through with what's listed on the case plan based on assessments that we do. And then our work is, you know, coordinating with service providers. And so if families are flat refusing to do those things, then, you know, we clarify that in court reports so that the courts are understanding that that has been the response. Now, usually a response of I'm not going to do it, you know, it's our responsibility, I think, an obligation to dig into that. You know, is it a timing issue? What is it about the service that you're not interested in? And so I think that really is the relational piece of our case managers to really, remove barriers and to build positive relationships so that we can get and not convince, I don't think that's the right term, but really support our families in the services that they need so that they can provide a safe, stable living environment for their kids. As it applies to kind of previous to that from a prevention standpoint, that might be a little bit more tricky to ascertain, but I think within the system, if children are actually placed in foster care, then it would be kind of documented in their, not only in their files, but also kind of reported through their court report.
Yes, thank you for expanding on that a little bit, because I do think there are a lot of, I definitely agree. I think there are a lot of barriers and challenges for communication, especially because I know the caseworkers and other staff are very overwhelmed and trying, between parents working and everything else, trying to communicate back and forth between schedules and availability for them to go take classes or whatever else that they're trying to do. It is quite the mess, actually, for both on the parent side and on the the provider side. But so there's a lot of challenges going on there.
Additional questions, committee? Seeing none, thank you, Matt.
Thank you.
Next, we have TFI Family Services and Tabitha Gibson. Welcome to committee, Tabitha.
Good afternoon. Matt's taller than I am, apparently. My name's Tabitha Gibson with TFI Family Services. Excuse me. Sorry, I've been clearing my throat back there all afternoon, and you've probably been hearing me. Chair Gossage, Vice Chair Howerton, and members of the committee, thank you for having us today. As I said, I'm Tabitha Gibson. I'm with TFI Family Services. TFI Family Services is a statewide nonprofit child welfare organization that provides a wide variety of services within the state of Kansas, including case management, family preservation, residential services, and foster home sponsorship and licensing. We are celebrating our 60th anniversary this month, and so we're very excited to have been providing services in the state of Kansas for that number of years, and obviously look forward to continuing to do that. Some updates are our prevention services, Family First services. The data that I'm going to share with you is from January to March of 2025. Our Family First prevention services, we provide parent-child interactive therapy in our Area 4 and Area 8 counties, so southeast and south central Kansas. So far, in the first quarter of the calendar year, we served 30 families in that service. In family preservation services, we are the family preservation contractor in the northwest and the southwest parts of the state. And in the northwest region, in January to March, we served 99 families. In the southwest region, we served 123. As I mentioned, we serve as the case management provider in Area 4, which is southeast Kansas, and Area 8, which is south central Kansas. As of the time this testimony was submitted, we were serving 1,008 children in out-of-home care and 213 children in aftercare. Some data highlights from our case management program. In the first quarter of the calendar year, we had 118 new referrals. Of those new referrals, 54 or 45, almost 46%, were placed with relative or kinship the day that they were referred to care. That's actually a little bit low for our average. Our average for the fiscal year is 56, almost 57% of new referrals go to relatives or a kinship placement. Our overall relative placement rate is about 48%. So 477 of the 980 children that were in our program January to March were placed with relatives or in our kin. We had an average of about 3 youth absent from care in the first quarter of the calendar year, and as of the date this was submitted, we had 4 absent youth. 78 children were reunified between January to March. 37 children were adopted. Of those, 25 were adopted by a relative or their in our kin placement. 10 were adopted by their foster family. And 2 were adopted by some other adoptive family, so a family unknown to the child. Other exits from foster care included 7 permanent custodianships, 3 youth exiting care due to what we call APLA, or aging out of the system, and 4 achieved permanency through SOL. which is also very exciting. And we have a couple more who have SOL as a case plan goal that we are looking forward to seeing achieve permanency that way too. Placement stability continues to be a strength for TFI. We actually have ticked up just a tiny little bit on our placement instability, but as of the end of March, we are at 4.84 moves per 1,000 days in care, when the previous quarter, both of our contract areas have actually been meeting that outcome, so we're just slightly above it now. But still doing really well in placement stability for our youth. January to March, we had 0 youth spend the night in an agency office. We have had 1 since then, so the things that you've been hearing from all of my colleagues today, the youth that spent the night in the office was an older youth with significant mental health issues who we were unable to find an acute bed for when they screened in. So those are not uncommon challenges. They're not unique to my colleagues. We are, even though our placement stability and our youth sleeping in offices, statistically it looks good, we are challenged every day to find long-term placements for kids that we're serving. So we do have youth that are in overnight placements that we are still struggling to find long-term placements for. We've implemented some creative solutions to that. We have professional foster homes that have been very helpful in helping provide some placement stability to youth and help stabilize them so we can find either while they're waiting on treatment or find a longer-term foster home that's better able to meet their needs. We also experience youth who screen for a PRTF and are declined by all the PRTFs in the state, sometimes resulting in those kids receiving that treatment in another state. We've actually had 3 instances of that occur. I actually skipped just a little bit. Some of our other areas of focus include improving the rates of siblings placed together. We try very hard to keep our siblings together. We're not currently meeting that outcome, so that's another area we want to continue to improve, and improving our family-like setting. I think maybe it was Matt who mentioned these are all connected. TFI is seeing older youth start to enter care at higher rates than what we had previously seen. And those youth that are entering care are coming into care sometimes with pretty significant mental health issues. And one example, which isn't in my testimony because it just happened this weekend, is a youth who entered care for trying to stab her mom. And so not an abuse neglect reason. She entered care for trying to stab her mom, and our staff were with her taking her to placement, and she grabbed the steering wheel of the car. That was this weekend, and she attempted to wreck the car. Thankfully, our staff member was able to regain control of the car. They did not wreck. But that's the second time with 2 different youth that we've had an instance where youth have either grabbed a hold of the steering wheel or grabbed hold of the driver of the car who was taking them to placement. And in both instances, they are youth who are in care due to their needs as opposed to being in care for abuse or neglect. So these are pretty significant challenges that affect not only placement stability and family-like setting, but also affect workforce retention, which is another thing that you have been hearing all of us speak to today. And while I'm very pleased that our turnover rate has declined by over 20% this fiscal year from last, we are still struggling to fill vacancies with qualified staff. There is now a statewide workforce development team that is looking at some of the reasons for that and how we can maybe tackle recruiting social workers into child welfare so that we can have a qualified workforce to serve these families. And I'm happy that TFI is a part of that. Our average caseload right now is still 23 per case manager, so you can see that we do still have quite a few vacancies that we're continuing to address. I think that's it for now. I do want to say that much like my colleagues, I didn't include all of that in here. I did put our contact information in here for how you can get a hold of the agency or if there are concerns, if you wanted to share that. But similar to our other CMPs, we provide all of that information to families the day of referral. And I'd be glad to stand for questions.
Thank you, Tabitha. Additional questions, committee? All right, Senator Falscato.
Thank you, Madam Chair. So the youth in that situation of grabbing the steering wheel, et cetera, so who handles that? Your employee, or do they call the police?
Depending on the outcome, they may call the police. In one instance, law enforcement was called, and the youth was arrested. In this instance, the worker was able to get the youth calmed down, and she went ahead and went on to placement.
Seeing no other questions, thank you.
Thank you.
Committee, we're going to move on to our Office of the Child Advocate update with Carrie Lohnert. Carrie, welcome to committee.
Good afternoon, Madam Chair, Vice Chair Howerton, and Ranking Minority Member Falscato. Thank you. My name is Carrie Lohnert with the Office of Child Advocate, and I appreciate the opportunity to share with you this afternoon just an update on our office and what our last year has looked like, as well as the first quarter in 2025. And I've shared a lot of the information that is in the PowerPoint presentation. I'm going to actually skip this afternoon. I included it for informational purposes so that you can reference back to it, and also particularly for any new members of this committee who may not have heard about our office on a regular basis, whether it's through this committee or in other committees. So the Office of the Child Advocate, our mission is to act as a neutral, independent agency to ensure Kansas children and families receive adequate coordination of services for child safety and well-being. And we do that by receiving concerns or complaints from our citizens here in Kansas and from others who have concerns about our children and families that are receiving services. And so that process takes on a number of different avenues when we receive those concerns, but really the goal is to provide advocacy to help those complainants receive some type of resolution. It may not look like what they are hoping that resolution may be, but then it also informs our office in making recommendations, whether it's case-specific recommendations, it may be policy and practice recommendations, and then there may be legislative recommendations that we make. So I'm really going to just jump to slide 11. So a lot of information in there that I'm going to skip for you this afternoon. Let's see, there we go. So slide 11 really takes you to our 2024 top complaint categories, and this information was provided in our annual report. And I want to take just a moment to talk with you about these categories and what we were hearing in 2024, so that when we talk about what we're hearing now into 2025, there's some context there. So the first thing and some of this, as you were listening today, from our national providers, from DCF, from our case management providers, you're going to hear some common themes throughout what you heard from them, as well as what our office is hearing from those who are bringing concerns to us. So you'll see that our agency, some of the big concerns are around agency conduct. And that area is something that has been consistent throughout the years that we're hearing. Communication failures, challenges in worker turnover, concerns around actions that workers are making or not making. And so when we're talking about workforce, we're talking about those challenges. We know that that's going to impact then the complaints that are coming to our office. Another concern that you've heard today is that unreasonable delay in achieving permanency. So that's an area that we are continuing to hear concerns around. Issues around reunification, that it could be happening sooner. And then if we're not reunifying, our children are remaining in care for long periods of time. And so we're receiving a lot of concerns around that, and we've continued to hear that over time. I want to take a moment to reference our annual report. It is available on our website. And if you look at beginning on page 28 of the annual report, there's a number of things that we've taken some time to share, really just some research, some information in that annual report that I want to just highlight and take the time to go back and take a look at. So one of those is family time and the intensive work that we believe should be happening early on in cases. And so you heard earlier today from Chris Church around that ambiguous loss and the trauma and the impact of that. So one of the concerns that we're often receiving and hearing from folks is that there is a delay between when children are removed and then their opportunity to actually spend time with their parents or other family members and other connections that they have. And that there's not only a delay in it starting, but then there's a delay in that continuing throughout the case as they're working their goal, particularly if it's reunification. And so we think it's really important that there's some really intense work. If that decision, that difficult decision to remove a child from the home happens, that there's very intentional, intense work at the beginning to ensure that those family connections are maintained and they're having family time immediately. And that those can be, that family time can, look like a lot of different things. So I think it was Representative Esau who had asked around what does supervised family time look like. So there are some states who have taken the additional step to provide some very intentional guidelines around what family time should look like, when we actually should institute supervision, when we should institute more of a monitored approach versus when we should institute an opportunity for there not to be any type of supervision. Another one is around placement stability and wind-chill time. So we've heard a lot around the challenges of finding regular placement and placement stability, particularly for our high acuity youth. Some of the creative solutions that our CMPs have had to take include placements that are quite a distance away. They may be night to nights in the amount of wind-chill time that our children are spending, and really taking a deeper dive into what's going on. So I appreciate that it sounds like a couple of you folks had visited with Pyxis or some other opportunity, like day programs and things like that. One of the things that our office has received around those day programs are concerns, though, that those are unlicensed programs. And so I do think that as we're exploring creative solutions and thinking outside the box, which I think we need to be doing, we do, though, also need to make sure that we're thinking about that in a safe way for our children. So what is it that these day programs are providing? What type of oversight and licensure regulations need to be enacted to ensure that if we're providing these services for our children and our youth and our families, that we're doing so in a safe way? Another concern that we highlighted in our annual report and we're continuing to hear is, and we've heard it, if you look back at our history, we did the former foster parent survey, and this was a theme that we heard then, and we're continuing to hear it today, which is our children, when they're entering care, this is part of our settlement, they're required to have that assessment done. What are their mental health needs? And what we're hearing, though, is that the assessment might be happening, but after that, they're not getting the services. The referrals aren't being made timely, or they're not being able to access what they're needing within their community or near their placement, and that they're showing up to placements without that information. So we're hearing from placements that they're not getting the full information about what these needs are. They may be showing up to placement without medication, which we know that depending on what the medication is prescribed for, if they're not receiving the medication, we're going to potentially be exasperating particular behaviors or placing a child in crisis, or really placing their life in danger if they're not receiving a medication that they need. We're also hearing that they may not be receiving the education information. So placements children are arriving and they don't know what their education history is. They're struggling getting information from school districts back and forth, which is exasperating the concerns as well. Something else I want to just note in our annual report on page 50, and I think it's somewhat related to what, when we were talking about the day programs, congregate care settings, is we believe that it's really important that there's just some additional oversight in these settings. We would strongly advocate that that there be a statutory change potentially around increasing the number of annual inspections for congregate care settings, and that those should also include a requirement that there be at minimum at least an additional unannounced annual inspection that happens. We would also encourage some change around some language that really looks at risk precaution, that's really focusing on sight and sound supervision. And so really exploring some of those regulations around those safety concerns. Those are things that our office is hearing from providers, from the individuals that are in those settings, as well as law enforcement. And just to, as a reminder, in the annual report, in the appendix, we have listed all of our 2024 recommendations that we made throughout the entire year. And what we tried to do is break those down based on legislative recommendations, policy and practice recommendations or system recommendations, as well as case-specific recommendations. And then just a quick snapshot look into 2025. You'll see a lot of those same categories that I mentioned in 2024 continue to be the theme for 2025 as far as our top concerns. You will notice that on the concerns reported, we have actually tried to pull out a judicial process. So historically, we have reported that under the other category, but because we are continuing to hear concerns around representation, whether it be by guardian ad litems, whether it be by parents' attorneys, practices by maybe our prosecutors, as well as some of the judicial practices within the courtroom, we're starting to track that individually. You'll see in 2025 so far, I think it's important to note when we talk about our office and our scope. So under our statute, our scope is set out pretty specifically that it really involves any child who either is alleged to be a child in need of care, could be alleged to be a child in need of care, or adjudicated to be a child in need of care, and any child who is in the custody of the Department of Corrections and has received services within the last 5 years. And I share that because you'll see that we have a large number of cases that have come in, and it's increased even in this last quarter of those cases that really don't fall within that scope. And our office is spending time. We're still trying to hear from those individuals, trying to find resources for them. A lot of those around domestic custody cases. Those are continuing to come to our office, and well-meaning. It makes sense that they're coming to the Child Advocate Office because there's concerns around child safety when it's a custody issue. And so if we can provide information and resources, we do so, but it may not necessarily fall within our scope depending on what's going on. Another interesting increase that I shared just because it's really been an odd influx is around child support issues. So we're trying to provide a lot of information to folks as far as resources where they can go elsewhere for those supports, but we've had a really large number of folks who are coming to our office with some child support concerns. So that just gives you an idea of some of those when we talk about out of scope, what that may look like. And that's just a quick map. Just a map to show you in 2025 the breakdown of the number of concerns that have come to our office from January until I think May 28th breakdown based on the area and service provider. So at this point, I really want to talk about in our annual report, we broke down a number of recommendations in thinking about what are priorities for 2025 and beyond. And so a couple of things to highlight. So the first one we had recommended was support initiatives to build 24/7 access, communication pathways, and collaboration between DCF and law enforcement. And so I want to thank the committee and the legislature for moving forward with House Bill 2075. One, it addresses that recommendation, and I'm looking forward to seeing the implementation of House Bill 2075. And we heard from the Secretary the work and the focus that's been happening since session ended to make sure that they're ready to go on July 1 if there's a law enforcement referral in response to DCF. But also, if you jump down to the other green highlight, which is consider proposed revision around the frequency of permanency hearings. So also HB 2075 addressed that. And so I'm looking forward again to seeing the implementation of that and hopefully improving the frequency of hearings or increasing the frequency of hearings, the quality of those hearings, and seeing then the impact towards timely permanency for our children and families. Also wanted to take a moment when we talk about when we talked about intentional and thoughtful deliberation around the statutory definition of neglect. So a lot of time and energy went in last session addressing that, and I know that that's come up today. And I look forward to, I think, those continued conversations as our state really looks at that and tries to make sure that we're moving forward in a way that's going to work best for our children and families. There was, I think, taking the time to step back and hear the concerns that were voiced. So that we really can make sure that it's going to have the impact, that the intended impact versus the unintended impact. The other two, the gray ones, consideration of a statewide centralized multidisciplinary law office. So our office, I think, first annual report under our executive order, and every year we have continued to receive concerns around representation, quality representation by guardian ad litems and by parents' attorneys. And part of that, that we've encouraged our state to access Title IV dollars to help reimburse for those legal services. Very encouraged to hear the report from the Secretary as far as the number of now counties that are either starting to receive that or in the process of moving forward with that. The other piece is, Representative Humphreys is on in this group as the JO Sync Advisory. There's a lot of work that's happening in really evaluating how services are being delivered in our state and really exploring other service delivery models. What are the training that our attorneys and our courts are receiving? What are the standards that they're being held accountable to? And so I'm excited about the work and the different subcommittees that are really focused on that area to see what will come then out of that advisory council and what those recommendations are and what the next steps will be. And then we heard today, and we've continued to hear around the workforce. And when I talked about the agency conduct, that was one of our highest concerns that we hear, and the impact that it has on each of the different decision-making points within cases, engaging parents, working with the courts, communication families. So our workforce, it's so key, and we have turnover, but we've also heard concerns around the level of education that our workforce is bringing to the table, that we don't have licensed social workers who are applying for these positions. I'm hearing from a lot of individuals that not only do they may not have a social work license, but they may not have the education or degree in any type of related service or area of education area. And so in thinking about if that's our landscape, if that's what our world looks like today, it sounds like there's some really great workforce development happening. I know that Representative Johnson's talked about working with colleges in his area to try to build those programs out. And so I think there's a lot of work that are happening in different areas. But until those take time. So what do we do today? So one of the things that our office has recommended, and we would continue to encourage our state to explore then, is some sort of certification program. How can we build then, if this is our workforce and this is the education and the training and the expertise or lack of experience that they're bringing to the table, then how can we build that within? And so if there are certain things that we expect them to show the capacity to do, how do we train them internally? How do we provide the support that they need? And how do they then show that they have, that display those skills? And then how do we hold them accountable to that? And so there are some states that have implemented a certification program. And so I would encourage our state to explore that further. And then if the chair would give me, I go off script for a moment, you know, the privilege, I think, of maybe going towards the end of the day. And there's just a couple of things that I wanted to take a moment to address. And one of those was the conversation around mandated reporting. And I'm very encouraged to know that and hear that we're talking about that issue and we're thinking about the impact that it has on our systems, but also the tension that is around the issue of mandated reporting. And I think about that as when Senator Erickson was saying that as a principal, you didn't want your staff to be doing that investigation piece. And I think about, you know, as school districts, we're risk adverse, right? So right now, under the current statutory scheme and the requirements, you know, there's a risk if staff are not reporting when they should be. Do they have the expertise to decide whether they should or should not? And so I think that's an important piece that we need to continue to explore here in our state. And what I will say is with the shift of the language around mandatory supporting, and there has been a change in the training curriculum. So if you go to the Kansas Children's Service League, who has partnered with DCF, and look at their training that's now available, it's very different than maybe those of you who may have received training 10, 15 years ago. Or when I was a school social worker, I was the one who was supposed to be doing the training for my school district. I will tell you that it's extremely different than how I would train staff back then. But what hasn't changed, so the training's changed, some of the language that we're talking about, but what hasn't changed is some of those pieces around what the statute actually says, what our mandatory reporters are required to do, and the potential risk. And so I do think it's important for us, as we're exploring this topic, that we take a moment to think about those things. We heard about the potential Class B misdemeanors if you don't report. So that's something that if we're training, or if the training is talking to our mandated reporters around asking certain questions, what are services that may be available to the family? What are some other, you know, is this a neglect issue where maybe they don't have access to laundry services, so they are wearing the same clothes every day? What is it? But there's a tension between that piece and then our current statutory requirements. So I think it's important for us to be thinking about that. The other, well, actually, I addressed Representative Esau, so I made a little note around the family time. So what I will say is, you'll see, and I don't know if you can see it in here. I didn't bring my toy today, but if you've heard me talk, our office is often asked, what's the answer to foster care? How do we fix the system? And so there's a in the background you'll see there's a picture of the expandable. It's a sphere, it's the toy that expands and it, you know, gets smaller, right? And it's made of all different colors and there's all these different touch points. And so I always use that as my, you know, when I think about visually how we can, when we're thinking about changing the system, every single one of those pieces in different colors is a different system, whether it's our education system, whether it's our community health providers, whether it's law enforcement, whether it's foster care, whatever it is, our different systems, our MCOs, our medical providers, we're all working with our families at different touch points. And so every decision that we make, whether it's as policymakers, community providers, working with families, those are going to impact the system. And so I want to bring that to our attention because we often talk about child welfare in such a siloed discussion, and it's not. So every time we think about all these other systems, at some point it's going to impact our child and families within the child welfare system because they're so interconnected. And finally, just to share a little bit about some things that are happening with our office. So I brought some handouts that I'll maybe beg Natalie to pass out, or I can do that afterwards. But we've taken some time this year to really think about how we can get information out to the community, out to providers. And so you'll see just a number of things. And so I have one for each one of you just to share. And we've tried to be present at some outreach events that DCF has had, at other community events. We had the opportunity to present at a foster parent retreat that was held by Ember Hope and TFI together. I'm looking forward to sharing this in just a couple weeks to our Kansas Youth Advisory Council conference to youth. And share some of these materials. So we have posters now available, an updated brochure, and then we also have cards for youth. One of the things that we hear so often is that our youth don't know what their own rights are. And so, our legislature took the time to pass a Youth Bill of Rights. And so we want to make sure that youth that are in care and receiving services understand and have information about their own rights and how to exercise those. And then we also have a youth coloring book for them to, and not only will it have access to their Bill of Rights, but it also has a place for them to write down who their guardian ad litem is and what their guardian ad litem's name and number are, and some other important contexts that we're often hearing from youth. We get calls weekly that says, I don't know who my guardian ad litem is, or I don't know what their name is, or I don't know how to contact them. So we're hoping to, by providing additional resources to our youth and to our placement providers, that will improve that information, those experiences, and our youth being able to exercise their own rights. And so with that, Madam Chair, I'd be happy to stand for questions.
Well, thank you so much. Committee questions. I think we have one from Senator Erickson.
Thank you, Madam Chair, and thank you for your report. Going back to mandatory reporting, I know you said that it can be a Class B misdemeanor for not reporting. Are there any instances you're aware of where school personnel have actually been charged for not reporting?
Thank you, Madam Chair and Senator, for the question. That's not something that our office has researched or been aware of here in Kansas. I was just talking to one of my colleagues, and we were thinking about there was probably about a year ago, maybe now, there was a big a lot of articles out of Colorado where there was a school employee that was charged. Now here in Kansas, I don't know, and I don't know if that's tracked by any entity out there.
Mm-hmm. Go ahead.
Thank you, Madam Chair. Just anecdotally, in my experience, decades in public education as well as my husband, I'm not aware of any, so it would be interesting to know, because I suspect more often than not, we have school personnel that are hesitant to report. They don't want to be wrong. They don't want to rock the boat. And they should be reporting, and there's no consequence for that. Therefore, they don't when they should. So just an observation I'd be curious to know. Thank you, Madam Chair.
Senator Faustigoto.
Thank you, Madam Chair. Thank you, Carrie. So also along with that, regarding the reporting, I know that you have a background in law somewhat, and I think we need clarification, because if we're requiring teachers or the healthcare industry, daycare providers, foster parents, if we're calling them mandated reporters, and so who does what and when, I just think we need that clarification. And so I don't know if you know that answer now, or if you can provide it for later. And then my second question, Madam Chair, would be for those who are listening in right now who don't know exactly what the Child Advocate Center does. What are 3 things of reasons they would contact you, as opposed to calling DCF or a contractor?
Thank you, Madam Chair and Senator, for the question. So let me try to tackle the first one. And I want to tackle that one first because I'm not sure if I quite understand the question, because you had mentioned clarification for those individuals that are mandated to report. And are you saying clarification as to?
Madam Chair, if I may clarify. So, we all kind of know what a mandated reporter is and who those entities are. And then Senator Erickson said she just wanted, educators to report and not have to make the decision. So is it an option that they report, or by law are they required to? And if, just to the senator's point, when we do or don't, isn't it the same requirement across the board for teachers, child care providers, and the medical industry? Isn't it the same?
Okay. Madam Chair,
Thank you.
and thank you, Senator, for clarifying that. That helps me better understand. So I think number one, yes, educators are mandated reporters, just like a number of those other individuals that you mentioned. They're all required to, as a mandated reporter, under the same statute that we heard, essentially from Jessie when she spoke about, what the provisions set out. Whether there's particular policies where they work or other practices that, may impact how they institute that, or what their training that they receive, that looks different. So different school districts or departments may have different training, or in a medical profession or provider, the training that they receive may look different. But as far as the statutory requirements, those are the same. And then to get to, thank you. Okay, so the second question was, why would someone maybe reach out to the Office of Child Advocate versus DCF or one of our case management providers? So I think one of the first ones would be that maybe they've already exhausted those other avenues. So if you are a parent who your child's been removed, who's in the custody of the state, and you've been working with your case team, and there's been a number of frustrations that you're experiencing, whatever those may be, and so you've contacted that case management provider's grievance procedure. All of our providers have their own internal procedures, and you didn't get a response that helped you find a resolution. So then you may contact GCF customer service, and that also didn't get you where you needed to go. Then we would absolutely encourage you to contact our office. With that said, you're not required to exhaust those things. So that is a question that we ask folks when they contact our office. What have you done to try to help find a resolution to address your concern? And if they haven't, we'll encourage them to exercise that. But sometimes they don't feel comfortable doing so for whatever reason. And so, we still may move forward with the process internally. So really, it's really anything that they're frustrated with about the system, and they're not getting a resolution that they're hoping for. And so with that said, sometimes we're not able to help them find the resolution that they're hoping for. But what we can try to do is help them navigate the process better, help them make those connections, help improve communications, help them better understand what's going on. And depending on the situation, we may still try to advocate for a particular pathway. But those are the times that, we're working with them to figure out what's going on. And sure.
Representative Ruiz.
Thank you, Madam Chair. First of all, this is awesome. Thank you.
Sure.
Giving us a copy of all this. You were talking a little bit, when you started talking about the mandated reporting, Carrie, it also got me to thinking about the statute, and it covers licensed psychologists, school counselors, social workers. But we have unlicensed workers working directly with children. And so agencies are going to say that they are mandated reporters, but they're not really under statute. However, if you're a supervisor with a license and you have caseworkers working under you, it's always been my understanding is that it's that person's license, that they're working under their license in one sense. Am I correct in that thinking, you think?
Madam Chair, Representative, somewhat. I think I don't have the statute in front of me. I do believe that there is a provision, I'm looking at Jesse, if whether or not it covers if they're working in a particular setting, even if they're not licensed. I do think there's some language in that. As far as the licensure, I do think that there are some things around whether you're supervising someone and you're the licensed worker. I think that there is some liability there.
There's something about the nonprofit.
Yes.
Right. I'm not sure it covers it, but.
Yeah, I can go over that. So the medical care and treatment and the mental health services are licensed only, and that doesn't refer to any other employees or any one part of that organization. But then it further goes and applies to persons licensed by the Secretary of Health and Environment to provide child care services or the employees of such persons, so licensed at the place where the child care services are being provided. And then the nonprofit organization is going to be paragraph F, where it's any person employed by or who works as a volunteer for any organization, whether for profit or not for profit, that provides social services to pregnant teenagers, including but not limited counseling, adoption services, and pregnancy education and maintenance. So that is the specific language when it relates to an employee or a volunteer of an organization, very narrowly tailored in that instance.
Carrie, I was just doing some quick math here. When people contact all of us all the time, Senator Falscato and I often will share stories without names of, I had this situation, have you heard this? And the biggest problem that I'm hearing is that, this situation or that, parents are very concerned, or foster parents are very concerned. My children were taken away wrongfully, or I can't believe this kid wasn't removed from that horrible home. You hear all kinds of things. But I always ask, have you contacted the child advocate? And I hear, yes, that was no help at all. So I know you have to be helping. You and I have had some discussions about that. But when I look at the resolution here, and so, I've talked to people and I will ask, what would resolution look like to you? And sometimes I don't know. I'm just mad. They didn't do this. But is that done now? Yes, but they should have done that earlier. Well, we can't go backwards. But I'm seeing out of 69 complaints, there were 20 that says resolution reached with assistance. Then I see 61 complaints and 10 resolution reached with assistance. Can you explain that to me?
I want to make sure I'm looking at the right
I'm
part
on
of
the
the
slide.
chart.
I'm sorry, our slides are not numbered.
No,
so I'm
that's
afraid I
okay.
can't help.
So I think you're probably looking at slide 12, which is our OCA 2025 snapshot?
Yes.
Okay. And the resolution reached with assistance, is that where it says 20
Yes.
and then 10?
So that would be, in the first quarter, that would be 28% of the complaints. And in the first quarter of this year, or in the second quarter, I guess, 2025 so far, that would be 16% of complaints.
So I think our report, I think the numbers don't make sense because of how it's broken down. So you'll see that resolution reached with assistance is actually those cases that we have not done a formal report or investigation, but we've been able to provide some assistance and help them reach a resolution. The other ones, when you look at investigation with findings, then those are formal investigations where we've made some formal findings and most often than some type of recommendation. And Chair, I think if I might be able to work with my team to maybe better clarify and break down and provide some definitions of those, if that would be helpful for the
That would be
committee.
helpful, and again, partially because we want to be able to show value from the office, and to be able to say to someone, I called the child and it didn't help. Well, what was the resolution? What happened? Oftentimes that's very confidential, and they're like, well, I've been told I can't, share that. But if I have data that I could say, well, we know that in this office, this many complaints came in, these were found to be outside the scope I see that you have here, but resources were recommended, or you did some research and found it was not substantiated, the complaints were not substantiated. So what you have here, if you could have a better breakdown, I think, of just like, so this actually was resolved, or that actually was resolved, that would be very helpful. This is definitely a start. Thank you. Committee, other questions for Carrie? Seeing none, thank you so much for being here. Finally, today, committee, we have the Child Welfare Reimagined report, and I know I'm going to say it wrong. Is it Crystal? Yay! Okay, Crystal Hedrick. Welcome to committee.
Thank you, Madam Chair, Vice Chair, members of the committee for having me here today. My name is Crystal Hedrick. I serve as the CEO with the Children's Alliance of Kansas. Let's see if I can. Right. The Children's Alliance of Kansas is an association of 17 private, nonprofit child welfare agencies that collectively provide a full array of services for children and families in terms of child abuse and neglect prevention, family preservation, foster care, adoption, independent living, parent, youth, and child skill building, mental health, and substance abuse treatment. Let's see, trying to think of the best transition. I can assure you, and Natalie can vouch for me, that I did not sit in the back of the room and develop this testimony today, but it is very much in line with the testimony that you've heard today. So there'll be some slides that I'll maybe work through faster than others. But for those of you who might be new to this committee or into this space, just a little brief history of reimagining child welfare in Kansas. Former Representative Susan Kincannon and Representative Owsley really championed this, and you can see who our core team participants were in really bringing this process to life in the fall of 2024. Casey Family Programs had representation and helped guide us through this process as well. And there were several stakeholders from the legislature, governor's office, judiciary, prosecutors, law enforcement, education, Department for Children and Families, the Children's Alliance, Carrie Leonard, Office of Child Advocate, mental health service providers, and also individuals with lived experience. So a big comprehensive groups of people came into this work. Jeanette Owens is actually here today, but she's already been up here on the hot seat, so I told her I would take one for the team here. But I'm sure she'd be happy to answer any questions that you have. But she and I sort of split this work in two, and she took the prevention and removal piece, and I took the foster care through permanency piece. And there was some overlap there that we found, but we really kind of did that work separately and then brought it together to make recommendations towards the end. We began this group with these goals and vision, which I think is eerily similar to the conversation we've had today. So kudos to the leadership of this committee today in putting together our agenda and having some synergy in our priorities. So the very first thing I think that we can all agree on is that foster care really should be used to address imminent and clear child safety concerns. And when foster care is needed, it's a temporary, short-term, and targeted intervention. So you heard a lot of that this morning from our friends with Casey Family Programs. The second is that families and children can access a robust array of services resources and support needed to be safe, healthy, and thrive without CPS intervention, so Child Protective Services. The third would be to identify strategies that could enable Kansas to become a national leader in ensuring safety for children and supporting families. I would say this one, a couple weeks ago, I traveled to a NOSAC meeting, which is essentially the national level where all of the associations, like similar to the Children's Alliance of Kansas, come together and talk. And I will tell you that amongst that group of 25-ish states, Kansas is still very much a leader in child welfare, and specifically because of our community-based setup that we have in our public-private partnerships. Folks really are interested in the work that we're doing, and we are still very much seen as a leader. So I appreciate our state and you all's commitment to continuing to press ourselves to be better. But in terms of other work across the country, we are still kind of paving the way in terms of child welfare. And I think that you'll see that as I walk through some of the data that the Secretary has already introduced today around prevention services. The final piece here is that foster care, one of the goals would be that foster care is appropriately resourced and honors children's family and community connections by prioritizing reunification, family time, and placement with kin whenever safe and possible. So I want to dive into each of these with a little more intention. And this is kind of a busy slide, but I was really looking for a way, very nicely recaps the testimony that we heard from Casey Family Programs this morning. And our community-based care process has really got us here in this left space, in that left diagram, where foster care is the center of this space that we're in, where we're here to address immediate safety, right? That's a temporary solution until some of these other services and supports can kick in. And then as quickly as possible, we're getting that kid back home and into their home, comfortable environment in a safe space. What's happened through our community-based care model over the years is that our foster care has gotten really independent, so to speak. And I, over the years, throughout my career, have worked for many of our providers and have had the privilege of working for providers where the answer was not something that we were looking for down the street, but if we needed a solution, we would come up with a solution. And so we did that, and we did it really, really well. And I think that you see within all of our providers, you'll see our providers have mental health services integrated into them. They have supports for caregivers, for kinship caregivers into them. They have, I remember when I was in that space, we would bring in physical health providers and dental health providers to do clinics specifically for the families that we were serving. So we brought the services to our kids in foster care so that they could access it timely and with intention and with a trauma-informed perspective. That was really great until a lot of things have happened over the past 10 years, and other parts of our system have shifted and changed, and the needs of our kids have changed, and our families have changed, and that's become much more intensive. And so that's when you started to see us struggle a little bit, and I think we lost track of how foster care fits into the bigger picture here. And so we have a child and family well-being where foster care is one tiny piece of the puzzle. And I'm grateful to the leaders of this committee today that we've really heard from some of these other spaces in a way that is different than maybe we have in the past. And I think that this committee in the past has focused a lot on foster care. So I can feel that shift and that synergy. So it's a great space to be in. But this right side is really a depiction of a system that's designed to meet a family where they're at, based on the circumstances of their family and the risk and the needs that their family has at that time. I last week spent some time on the beach, and I was hoping that my testimony when I got home was still going to make sense. So I'm coming back, and I'm grateful that it is. But nonetheless, when you travel, something wonky at home always happens, right? So what it was for me was that we were having our driveway redone, and thankfully my father-in-law was kind of managing that for me. The problem is that my car wouldn't start to get out of the space needed so that our driveway could be worked on. And so I drive a Toyota Camry, so he called the Toyota dealership and they were like, well, let us think about it. We'll come up with some options. He called a few other random places who maybe didn't necessarily specialize in Toyota. And they said, well, tow it in, bring it to us, and we'll figure it out. And he was like, wow, that seems like a lot of work. So eventually the Toyota guy calls back and says, let's troubleshoot this together. It's your car. You're the expert in your car. Tell me about it. What noises was it making? What's happening here? And they walked through all these different things. And eventually they troubleshooted. And without that car leaving its home, based on the expert of the person that owned the car, they fixed the car, right? So you get the analogy here where I'm talking about, we don't take our Toyotas to the Honda dealership if we want them, right? And so this is part of it too, is that the way that we're going to help our families is by serving them at home with people that they know and love. And foster care may be a part of that solution, but that is not going to be the whole solution for us. So appreciate the opportunity to dig into that a little bit more today. I'm going to skip a couple of slides here that were perfect slides from Secretary's testimony previously that she also covered again today. And this is also a repeat, but I want to focus on this a little bit. Since 2019, we were one of the very first states, thanks to our Secretary and Deputy Secretary, to implement Family First. Even when I was at NOSAC a couple of weeks ago, they were asking, how is Kansas doing it? How's it going? And there have been parts of it that have been excellent, right? And we've seen the number of kids coming into care decrease. We've seen the kids staying in care decrease. All of that's really great. Despite that, we're still almost double. And I think the question we should be asking ourselves is, do we really believe that Kansas parents are abusing and neglecting their children at almost double the rate of other parents across the country? And that just, you all sit with families in your communities, and I believe we have well-intentioned caregivers and well-intentioned parents. I don't believe that, I have a really hard time digesting that and believing in that. And so if we take a look at the primary reason for removal, we talked about this, that 39% of our kids are entering care through a family in need of assessment path. 61% through reasons directly related to abuse and neglect. So that FINA, 995 kids. So if we break that down, these are the family in need of assessment, more specific situations. So some of this sort of makes sense, right? Like you can conceptualize how domestic violence, parent drug or alcohol use might lead to imminent danger for a child. But some of it's a little bit harder to wrap our head around, right? Like truancy, not going to school, a child's behavior problem, a caretaker's inability to cope with their child's behavior problem. These behaviors and circumstances don't necessarily change when we remove a child from their home and place them in another home or another setting. In fact, what we see is that it gets worse, right? These are our kids that are struggling in foster care because the same problems exist, because now our foster parents are overwhelmed, because our system is overwhelmed trying to meet their mental and behavioral health needs. And then we have placement instability, which then impacts our ability for their access to timely mental health services or timely drug and alcohol treatment. Foster care does not fix these things. So we'll drill down. This is one of the first recommendations. Foster care is used only to address imminent and clear child safety and concerns. And when foster care is needed, it's temporary, short-term, targeted intervention. So with the leadership of DCF and Representative Howerton, we did a lot of work around that this last session, and really taking a look at the definition of neglect and ensuring that poverty is not a reason for a child to come into foster care, but there's still some pieces around that we could shift. One of those would be truancy, and one is access to mental and behavioral health services. The second piece to that would be that we explore some assessment tools. How do we, in getting upstream, Representative Humphreys lifted that up this morning and how she liked that term. We've been talking about getting upstream, part of that is here, right? When a family's in crisis, we have really great tools available for them. How do we access them that early on? And so one of the recommendations that the prevention side of things recommended was exploring some standardized assessment tools where we could incorporate family finding, concrete service coordination, and really intersecting the prevention services that we have and lifting those up. The next recommendation, the next bullet, was a robust array of resources, services, and support without CPS intervention. And this is the part I assure you, I did not just make this up this afternoon. But one of those is exploring opportunities for mandated reporters' responsibilities to be connected to access to services, as well as eliminating and reducing anonymous reporting. This morning, we talked a lot about concerns because the kid is wearing the same clothes over and over again. I was raised by my grandma, and I'm pretty sure she had 3 outfits. She had a school outfit, she had a play farm outfit, and she had a Sunday best outfit. No one was hotlining that family, right? Her clothes were clean. These really are some of the reports that are coming in to the KPRC. And while we do want to make sure that our experts in child abuse and neglect are having an opportunity to visit that, these are our community's kids, and we do all have a responsibility for them. And so if we need to ask a curious question and do some additional critical thinking in those other spaces in our community, there are opportunities for us to do that. I'm a licensed social worker. We also have an ethical obligation to do no further harm. And when we are pulling away resources because of outfits, because of misunderstandings, because we're not asking the follow-up questions of families, we're taking resources away from that 18% that you were concerned about, Representative Humphreys. And that 18% could possibly be more, but we might perhaps be missing those other kids because we're focusing on things like that. There's a differential response piece here, and we have done that in Kansas in different, in bits and pieces, but there are some other states that have fully differential response. And one of the things that led us to that was a conversation. There's actually an author and researcher from the Northeast states. She spent months embedded with CPS programs just to understand and kind of live that life for a bit. And what she basically published was that while our mandated reporters are well-intentioned, our police and teachers and doctors essentially are struggling to address housing, domestic violence, mental health, substance abuse, and shifting that responsibility somewhere else because they don't have the answers. And I think that is what we see in some spaces. And actually a month or so ago, I had a couple of KU students, one of which was in CPS work and working to get her master's degree, that offered some data about the concerns with anonymous reporting. And their data was that 95.5% of all reports assigned to the KPRC in this fiscal year so far have been unsubstantiated. And lifted up that there's many, many other states, Arkansas, California, Colorado, Montana, New Hampshire, that have implemented policy to prevent anonymous reporting. Some going as far as to require specifically what information reporters are providing about themselves so that they can adequately participate in that process and offer information to be helpful. So that was one of the recommendations of the prevention group. Increasing funding to prevention services at a community-based level without the requirement of DCF involvement. We talked about that a bit today, and the secretary had some pilots and things going on in that way. But I did just want to lift up that Kelly Fong that also did this research. This felt a little harsh to me at first because I also have worked on the DCF side of things, but she said, CPS is fundamentally oriented around parental wrongdoing. And no matter how well they do their jobs, it is a threat of removal and family separation. And they hold an ultimate power. And so it really made me think about the way in which we implement our prevention programming and who's best suited to deliver that in a way that meets families where they're at. Right now, Kansas has, I think, 10 family resource centers, which Deputy Secretary Keyes was a champion for many years ago. And it's a fantastic solution. If we take a look at, there are providers here in Kansas that are doing this work, and our investment in them will speak volumes if we allow it to happen. Radical Life is someone that joined and offered some testimony a few months ago. I took a visit to her space and was blown away. There were over 75 to 80 people at her weekly gathering in the community. And she does that every single week, every month, year-round, no matter what, to prevent kids from coming into foster care. And when they are in foster care, she's helping them go back in a timely manner and helping that be sustainable. She is a family resource center. And for those of you who didn't get an opportunity to listen to her speak, I would recommend going back and checking it out. But when I talked to her about what her budget was, and then I listened to testimony today about the cost of kids in foster care, she's serving 80 people on a minimum weekly for what it would cost to have 2 kids in foster care for a year. So as we think about how we're investing ourselves and our strategies, that is one of the recommendations, is we continue to encourage other providers to be a part of that and be here in this space with us. And we need to hear from them what they need to be more formal and be able to expand those programs effectively. Identifying strategies that could enable Kansas to become a national leader. This is when I told you I had some heartburn around because I feel like we still are leaders in that space. You can see here, I agreed to report out about licensed child welfare practitioners and caseload carrying positions on behalf of the providers. And you can see those percentages here. And it's interesting that Carrie Leonard brought this up, but there are other states that are successfully implementing child welfare certification programs to really professionalize that workforce. And I was a part of some of the decision-making here in Kansas when we moved away from licensed practitioners. And the reason is someone has to do the work. And we understood that there was risk in that, and we found ourselves here. But now we're also in a space where you can get a master's degree in social work 100% online, which makes me be in my feelings a little bit, but as I often support practicum students, and I think we see that. They're less prepared for what the challenges that our families have, and it's difficult. And to ask our providers to also bring them up in that training and education is a challenge. So also this group was also supportive of some sort of a certification program that would also be professionalized through the BSRB, the Behavioral Science Regulation Board. And that the legislator approves that board as well and actually is behind the statute around that. So that would be a way for us to hold practitioners accountable to a high level of service and support in our residential programs for our providers. And we would know exactly what was being offered to them. So being supportive of that. I also would just lift up that our residential providers, you heard providers in Wichita that are willing and interested in doing this work, but finding folks to come into the workforce is a challenge. I spent some time at Kids TLC, which is one of our members, a couple of months ago, and they are going to their donors, specifically asking for money to support training for their staff for kids that are in care. And it is difficult, and I think we do a lot, the state expends a lot of time and energy into assessing rates and are they appropriate? But that is also, always looks back, right? And so now we're measuring what was happening 18 months ago. And so we're always playing catch up a bit. And so we'll just encourage that we do have community members who are willing to support this, but it is difficult for providers in the state to seek out additional support for things like that. That's not always where donors are wanting to spend their time and energy. But also, some folks have lifted up liability insurance. It is going to be a problem for community-based care states to continue offering. And if you haven't read about what's happening on our coasts and moving in, I would encourage you to do that, or I would be happy to provide some information around that, because our liability insurance costs are going to be a growing concern. Okay, let's see. Last piece. Appropriately resourcing foster care. Family resource centered, I chatted about that. When we looked at this as a group, we really prioritized areas in which there were a high number of kids entering care, so Sedgwick County. And just put together some general numbers about what it would look like to implement a family resource center, or 3 of them, because of the number of kids coming into care. And that would be $2 million, ballpark, $2 million to have 3 family resource centers in Sedgwick County. And the idea would be that if we built those could be prevention, but they could also house peer parent models that would support parents whose kids are currently in foster care, which is some of the Radical Life approach. And right now, some of our foster care providers do have funding for that, but it is much smaller scale than, essentially, we're not able to have a peer partner for every parent whose kid is experiencing foster care. So an investment that we could consider making in the future. Improve quality of legal representation for parents and their children is also something that has already come up today. One of the things that I wanted to lift up about that, New York did a study. They served, I think it was 18,000 children that had experienced abuse and neglect. And they were at a space where they had a system like ours, where there was a panel of attorneys that would be assigned to a case. And they took some of those and created a comprehensive team that was made up of lawyers, social workers, and peer partners or parent advocates. And what they found was, in the first year, 67% more often, birth families were reintegrated in a timely manner. And it was 50% in the first year, 67% in the second year. And then of the kids who couldn't be returned to their families, 40% more children ended up with permanency when they were represented by the panel, the multidisciplinary panel, as opposed to just the single attorneys. So those are some of the highlights. They also, kids spent 118 fewer days on average in foster care. So this is something that could potentially pay for itself if it's an investment that we chose to move forward with. And then the last one, I don't want to minimize this, but reducing barriers to licensing for relative and kinship families. At a federal level, there was a shift that would require us to create a pathway for relative and kinship families to become licensed. And essentially what we did is offered an exception process for them. And so if there is an issue with a background check, something that was multiple years ago and the family is working to get it expunged, or there's issues with their home and the family still wants to be licensed and it's not going to be a direct safety issue, there can be an exception process for relatives. Other states are sort of doing the opposite of this, where they're saying you have to have an exception to place with someone that the child doesn't already have a relationship with. And they call that a kinship firewall. So there's plenty of work to be done around that. And we have, the Children's Alliance has a partnership with KU where we're working on some of that, and all the other providers in the room as well, that would be more suited to offer specific information about that, but would highly recommend that they could go into more specific detail about how we can continue to be a kin first state and support those families. I agreed to offer this information on behalf of members of the Alliance to highlight and overview grievance policies and complaints among the case management foster care providers. So you can see a total of 143 complaints from January to March of 2025, 120 resolved, 24 unresolved. 23 of those the agencies were unable to reach the person who filed the complaint, and then there's one ongoing that this committee is familiar with. So I also wanted to add that all of our members, in order to be a grantee through the state, have to have some sort of accreditation. So whether that be Joint Commission, Council on Accreditation, or CARF, they also require really stringent policies around consumer complaints and access to that. In addition, Carrie Leonard, who's here today, and shared with you her platform and processes as well. And then on each of the providers' websites, there's opportunities there to reach out to them online and through many fillable forms, direct toll-free numbers, email addresses, and such. So I wanted to make sure that everyone has that information available to them. And then I'm happy to answer any questions that you all might have.
Thank you so much. I'd also like to give a shout out to Foster Village, if people are not aware of them, Foster Village of Northeast Kansas. Been there, wonderful organization, and how they help foster parents, and just all, if you haven't visited their website, and I encourage you to do that. Questions, committee? Yes. Senator
Madam Chair, not so much a question, but I just want to say, Madam Chair, this has been a great informative meeting. Thank you. And to all of the speakers, I really heard something different, different information this time than before of working towards a solution. So I appreciate, and Madam Chair, I'm actually going to leave the Capitol, Topeka, once and for all. I'm encouraged, totally. Seriously, I'm not even mad at anybody today.
That's a win.
No, I'm serious because of your presentation. It's the best I've ever heard. Wow, thank you. Because I too agree that children are not being neglected and abused that much. I still look at a lot of it, especially in my inner city district, part of the district. People are poor. People are struggling still. And the cultures are different, and they just need a little help. And so I'm, Madam Chair, and I don't know when we'll get to recommendations, but I'm just the reporting process, that anonymous piece. Can you elaborate on that just a little bit? Because I know if we think something, say something, and we want you to report, but all the manpower and time investigating those reports on where just the neighbor's mad at you, and I just am always concerned, how do we know that's a legitimate report? And so can you just say what you mentioned on that piece again?
Yeah, the data that was provided to me was that 95.5% of all reports assigned to the KPRC so far this fiscal year had been unsubstantiated. So that, I mean, that's a tricky number, I think, and it's probably a little bit high, but it is, the KPRC's hands are tied if the information being provided by an anonymous reporter fits the definition and the criteria in statute. And it has to be passed through and it has to be investigated. And so if there's a way to, other states, there have been other states who have had the same concern and eliminated that anonymous reporting.
Senator Erickson.
Thank you, Madam Chair, and thank you, Crystal, for your report. It was really good. I have a question about your slide on foster care, the bar chart that showed the biggest portion was parents' inability to cope, and one was child behavior. Do you remember that bar chart?
Yep.
Are there duplicates in there? For example, parents unable to cope. Was that because of a drug or alcohol problem? Are there duplicates in there, or are there those all?
This is a DCF report that I pulled from their website, so Deputy Secretary Keyes would probably be able to speak to that better. It is strictly FINA cases. It's just the 39% of FINA cases.
Okay. I don't know the source data. What we have on our web is it reports the primary reason for removal. So it is not a duplicate. If this is from our website, it's primary removal reason.
But there could be other contributing factors. I mean, I'm assuming that, like, what would be the primary reason that parents are unable to cope?
Yes, and thank you, Madam Chair and Senator, for the question. Yes, a child can be removed into care for more than one reason. We are required to identify a primary reason. Many times with the caregiver's inability to cope, it might be related to challenges or pieces around the child's behavior that they're struggling to think that they can keep their son or daughter well. It also could be related to a substance use disorder, but yes, there could be contributing factors and more than one reason that a child can enter care. We are required to designate a primary reason that is the overarching.
Okay, thank you. And just a quick comment on the whole child wearing the same thing over and over again. Let me just testify that I have two granddaughters who are 3. They have a closet full of clothes, but they throw down to wear the same thing every day. Just let me tell you, and they look like little orphans sometimes, but it's not from neglect. So thank you, Madam Chair.
Representative Howerton.
Just to follow up off of Senator Erickson, and Tanya, I'm sorry if I make you come up there. The crossover youth that we're talking about that are entering into care because there's no place for them, where they should be probably in a juvenile detention facility or juvenile care or something like that. What is the primary reason for them entering into care? How do you classify that?
It could probably jump into a number of these categories. I mean,
Okay.
If they're using substances, if they're running away, if they're truant, again, child's behavior problem, caregivers.
Okay, so that's where those would fall in.
Mental health. It could be a
Would
variety
it be
of
the
cases.
parents' ability to cope? Would that possibly
Could be.
be some of those as well?
It could be.
I was just curious. Okay, thanks.
Committee, we are, as you know, I like to begin and end on time, but I do want to just state, as a child growing up in Wichita with a dad who worked 3 jobs and 5 kids in 1 bedroom, we had a little tiny 2-bedroom house. I often would wear the same clothes during the week, but they were clean. And if not, I would say to my sister, who's about the same size, she was 2 years older, but I would say, can I wear that on Thursday? So she wore it on Tuesday, but I wore it on Thursday because we just had a few clothes, but they were always clean. And my mother always made sure that when there was no girls left in the family to wear those clothes, she ironed, we had to iron everything back then, washed and ironed, and we would carry those clothes across the street to a neighbor who had children younger than we are. My mother made sure it was still dark because people had a lot of pride back then. nobody wanted to feel like you couldn't take care of the kids. So my mom would make sure that all these clothes were taken. And she said, if you see anybody wearing that, don't say that used to be my dress or that was my shirt, because now it's theirs. And they take a lot of pride. Committee, we are adjourned. We will be meeting Monday, August